Good morning, good morning, good morning. It's Tuesday. No, just kidding. It's Wednesday. It's January 29th. It's January day 797. And today we are zooming to Utah for court for Utah versus Kouri Richins. If you do not remember this case, do not worry. I will be giving you a breakdown and replay crew. Do not worry, I've got you. Everything will be timestamped down below if you want to get to the parts of today's hearing that interest you the most. But for those of you that need a brief refresher on this case, no worries, I've got you. Utah versus Kouri Richins. She is accused of killing her husband with a laced Moscow mule. You might remember this case because she was out on a small local book tour regarding a children's book about grief that she wrote after losing her husband. There have been numerous hearings on this case with Judge M. Love Judge M, do not love the media rules in this court, not gonna lie, because Judge M has allowed no streaming, which means we have got to wait until the hearings are released. Someone from Team Baker or myself has been present at these hearings via media access, which is audio only, cannot be streamed, cannot be recorded, cannot be shared. All of the everything is locked down. So I know that there are parts of this hearing that were not televised. We'll catch you up on that at the end. There's a lot going on procedurally in this case, and I feel like we are just trying to catch up because so much has not been streamed or televised. I'm hoping the judge might change his mind before trial. If he does not, we're probably going to be a day behind at trial by the time it gets uploaded, and we will work on figuring out how to do that on our own. It is just not super easy to do, but we're our own media network and we will do what we have to do to bring you this trial when it starts in May, because I am deeply invested. Here's the challenge. If we have to do this trial on day delay, we're going to potentially bump into the Karen Reed trial. So we're going to be navigating these trials coming up simultaneously, perhaps. Where we are procedurally, before we get into the intro, before we go to court, before we
bring the jury.
Just kidding, we're in pretrial motions. There's no jury just yet. This case is also up on appeal. So the attorneys had been in court and we watched that. They made motions about in-person voir dire, which means the jurors come in IRL and sit there and get asked questions. It's strange to me to hear that there are courts in 2025 doing Zoom voir dire. I can't wrap my head around it because I don't know how that works, not in person. Like, a lot of jury selection, not to oversimplify it, but a lot of jury selection is legit vibes. You have to see, every attorney has their own way of picking a jury. It was something that I very much like doing, but you have to talk to people. That's harder over Zoom. So in this jurisdiction, Zoom voir dire is part of what they do. The judge granted the request from the defense and the prosecution. Everyone was like, can we just have these jurors come in person? And the court was like, yeah, we'll make it work. And then the presiding judge in charge of Summit County was like, yeah, y'all are adorable. No, my ruling, not me, site judge. My ruling is that it is Zoom voir dire. So that is going up on appeal to the Supreme Court. The Supreme Court has agreed to take that up in an expedited interlocutory, while the case is ongoing fashion, versus your typical appeal, which is after the case is done. They also argued to expand the number of jurors that sit on this case. That is not happening. The judge denied that because in Utah, if it's not a capital case, you do not get 12 jurors. This is not a capital case. It is a murder in the second degree. This is not a case where the death penalty is on the table. That's not what's happening here. You do not get 12 jurors. That's the way that it is. Oh. All of that, the appeal is up determining what is going to happen with in-person voir dire, which again, I cannot wrap my head around voir dire via Zoom. Like, I just can't picture it. Somebody might have it pictured better. I'm not the one, especially in a murder case. Like, the attorneys, prosecution and defense made great arguments, not only about this case being a media case, but there are things you can't know until you know. And there are things we can all wrap our minds around with. You don't know until you know. And there are experiences you can't explain to someone until like they feel it. Oh, you know what? No, I was wrong. I was looking at the wrong notes. Sorry. It is a first degree. I was looking at my wrong notes on a different case. Apologies, chat. Chat's like, wait, what? No, I had the wrong docket item up when I was talking about that. No. We'll get to the charges in just a minute. All of my notes crashed, and when I went to pull them back up, I pulled up the wrong one. Apologies, chat. Sorry to terrify you. Don't worry, it's a live stream. We'll fix it in post. Quick bits will get you the smoother experience. I'm going to tell you what the charges are in just a second. But it's not a death penalty case, so there are 8 jurors, not 12. So thank you. Chat was like, wait, what? And I'm like, wait, what? No, that's not right. This is what I get when I have the wrong thing pulled up. But some of the charges have changed, which is why I want to pull this up, because not everybody might have watched that in the last hearing that we covered. If you have not watched this case with me yet, then let me know with a 1 in the chat so I can bring you up to speed a bit more fulsomely, as they say. So Kouri Richins, in count 1, it is the aggravated murder. Count 2 is the attempted murder. Count 3 and 4 were dismissed by the prosecution, as they should have been, because they were dumb charges. Let's just call it what it is. They were dumb charges. Count 5, 6, 9, and 10 have been severed, which means they will be tried later. So counts 5, 6, 9, and 10 are mortgage fraud, and then the forgery that goes with the mortgage fraud. This happened well in advance of the murder, or the alleged murder. However, the prosecution was arguing that the mortgage fraud ties in to a financial motive here. If it's giving Murdaugh to you, hang tight. So the financial motive here is that the house was in her husband's name. This is going to be relevant in this hearing. The house is in her husband's name. It is not in her name. It was purchased prior to the marriage. So it is the husband's, who is the victim in this case, Eric Richins. It is the husband's property solely. So the mortgage fraud and the forgery with regard to the mortgage fraud has to do with her taking out loans against the house that he did not approve. It seems that he did not know of till down the line. When we watched the initial bail hearing and then the subsequent bail hearing, we heard a lot more about these financial crimes and the mounting stress and debt that was befalling Kouri as she girl bossed so close to the sun that she was trying to service millions in loans that she was not able to service well. And the payments on those were like 10,000 plus a week. Like, the financial boulder was rolling down the hill. We also heard that Eric Richins met with a divorce attorney. We saw testimony and documents regarding that. That seems to be when he discovered the financial fraud with regard to the mortgage and started to discover some other financial things as well. Then we see that the prenuptial agreement very clearly states, and I've gone through all of this in prior content, the prenuptial agreement clearly states that if Eric Richins passes while they are married, then Kouri takes whatever is part of his estate, his half of his very successful business in Utah, the home, and the rest of it. But if they are divorced, everybody takes what they came in with, which generally I don't have an issue with. You get what you come in with and you take it and go, depending on the relationship. And there were some provisions for what's built during the marriage, but his business stays his home stays his, etc. if there is a divorce. We also learned that Kouri's got a side piece. Kouri's got herself a little side piece while this is all going down. And we hear about the side piece in a few of the hearings. In the filings, the side piece is referred to as the paramour, but Kouri's got herself some OPP going on the side. And then on Valentine's Day, her husband eats a sandwich that makes him incredibly ill. The prosecution has said the way that he describes this in his present sense impression to his friends is consistent with a reaction to a dose of fentanyl. We have heard that Kouri reaches out to the person she got fentanyl from and said, I'm going to need something stronger. We have heard in court that there is a journal that we're going to hear about more today, I believe, where Kouri literally was journaling, and I am summarizing what we have heard in court. It seems that we're going to need a little bit more fentanyl. Like, we didn't use enough, and it takes more to kill someone, so I'm going to need some stronger stuff. So reaches back out to the person providing her with narcotics and says, I'm going to need something stronger. After February 14th, that's where the attempted murder comes from, is that February 14th sandwich that she brings him for Valentine's Day before going to her boyfriend's house. And then he gets incredibly sick, and she's texting him like, maybe you should just lay down. If you hear me start quoting the lyrics to Goodbye Earl, it's just, it's just. So she's like, maybe you should just rest. And he's like, I think I might need to go to the hospital. She's like, no, you should just try to sleep it off. And then he doesn't die, and she tries again. And that time, according to the prosecution's theory, it is successful. So right after this happens, it becomes clear, and I don't think Kouri knew, based on everything we've seen, I don't think Kouri was aware that Eric had moved everything into a trust and put his sisters in charge. It seems that Eric was concerned about what was going on, concerned about whether or not their marriage was going to survive, and concerned about what was going to happen next. Put everything in a trust. His sister was in charge. The kids were in the trust. The house belonged to the sister. All of his property then belonged to the trust, his sister being in charge of the trust. What we heard at the bail bond hearing, is that when the sister came to stop her from getting into one of the safes, it seemed that there was maybe weapons in the safe, perhaps cash and things like that, that Kouri and the sister got into it. And Kouri literally, this was the testimony. This is not me being hyperbolic. Sometimes I am. Lawyers can tend towards the dramatic, as we've all learned in the last few weeks. But Kouri literally like throat punched her sister-in-law over getting into Eric's safe. So Kouri, it seems, knows that she, as we're leading up to this, and it took a year after the death for Kouri to be arrested. So it seems Kouri knows that the sister-in-laws are in charge of the property and in charge of everything else. If Eric Richins did not die of natural causes, then Kouri Richins does not get his half of the business, the house, or anything else. If Eric Richins did not die of natural causes, if this was a homicide, then Kouri gets prison. The kids are with the husband's family, and we are now here in court. The sister-in-law came in and testified during that bond hearing about how disorienting it was to not only lose her brother, but also then for Kouri to be like wilding out. But there is a journal that was taken. There is a cell phone that was taken. And today's hearing, we're going to hear the defense motions to suppress. So the defense has a motion to suppress the electronic data, all of it, like statements subsequent to arrest and taking the cell phone and the rest of it, and the walk the dog letter. For those of you that did not see me cover the walk the dog letter, y'all can make up your own minds. The prosecution has alleged that the walk the dog letter was Kouri trying to tell her family what they needed to say when this all comes to trial. In that walk the dog letter, she talks about what Skye needs. Skye was her previous attorney, and talks about what the family needs to say to help her defense. And she wrote this letter, and when she was on jail calls, which are video as well as audio and are recorded, it seemed that law enforcement thought she was holding a letter up to the screen for people to read, because then law enforcement can't hear what you're saying on the calls. And I have done dramatic readings of her jail calls with her brother before, because the prosecution, in all of their snark, threw in quite a lot of what Kouri had to say about things when the defense would make certain arguments and open the door. The prosecution is like, let me tell you what. Kouri's side of the story is that letter is A, work product, and B, a novel. If it's a novel, it's not work product, or it's not attorney-client privilege, but made the Diddy argument before Diddy did it, saying, no, what was taken out of my jail cell was attorney-client work, and or it's a novel, because she's a writer. She's a writer. She's just writing stories. This is part of a novel. This is not a confession. This is not a plot with her witnesses. This is just a story. It's not real. And if you still have not remembered who Kouri Richins is, she's also the one that was Googling things like luxury prisons for rich people and can police recover deleted messages off your phone and how to pass a polygraph. Kouri. This is Kouri Richins. She also has had lots of thoughts about how she looks in the media, how the media portrays her. She gave an interview via jail calls and said that she was being persecuted and that this is all tremendously unfair, and that her husband overdosed on fentanyl 5 times the lethal dose of fentanyl. Though in the walk the dog letter, she's trying to remind her family, remember how he gets those gummies from Mexico? Remember? So Kouri's an interesting one. I very much like this judge. I hate this media order because it makes everything difficult. But I like this judge. The attorneys are interesting. Mr. Bloodworth, the prosecutor, is just dry snarky, which is interesting. So we've got a couple hours of court for us today, and we're going to hear about those 3 motions to suppress. If you're like, Emily, it feels like we've done a lot of motions to suppress lately. Yes, a lot of the cases that we've been covering for the past couple of years are all getting ready to go to trial. And because they're all getting ready to go to trial, like back to back to back to back, starting in April, then we see all these motions happening at the same time because we're just in the normal process of what happens before you go to trial. And it just so happens that a lot of the cases that we've been covering are all going to trial. March, April, May, August. For those of you asking about the Crest white strips, yes, she was the one trying to sneak in the Crest white strips. So we've got much court to do today, and we will take a poll later on whether or not Bloodworth is a secret law nerd, because I strongly think the prosecutor is a secret law nerd, which, you know, we're here for it. And when they're in the middle of prosecuting cases, you know, they've got to keep an eye on what people are saying. This is the case where the judge at one point called out that there were YouTube channels with like 803,000 subscribers covering this case. At the time, I had exactly 803,000 subscribers, and we were all like, is it us? It feels like it's us. It feels like it's us. And I have to wonder, Judge M, the law nerds love and respect you and your entire family. I know that Judge Daddy is a good thing. And we adore you. Let us stream. Let us stream. The law nerds are a very responsible community. We really are. We just want to see what happens in court. And we want to hear more about Kouri Richins journaling about how to better kill her husband. I mean, it's just the definition of self-snitching. So we need to know more. But if we have to do it on a day delay, we have to do it on a day delay, and we'll figure it out. We'll figure it out. It's clearly it's going to hurt my heart. It literally takes my breath away. We'll figure it out. So with all of that, law nerds, we need to get rolling. Thank you for being here. Let me know where you're coming in from, what you're drinking. I have coffee. I have water. I have more water. I have snackies. We're just ready to rock. Law nerds, you're the best. Let's roll the intro. And, I'm ready to get to court. How about you?
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not Let's get into it.
All right, I was trying to pull up my share screen while the intro was rolling. Did I get that all the way done? No, I didn't. No, I sure didn't. But we're getting ready to go to court, and we're gonna have to. Well, hopefully the sound is good, but we'll mess with it if it isn't. I was hoping we would have the whole hearing except for the parts that were sealed. Alas, we only have what we have, and there's only so much we can do. So you see Kouri Richins there at defense table with her counsel and people pulling into court. So that's, I think if I stay down here, I'm not going to block anything. So we'll just put EDB in a box in the corner. Bloodworth is the prosecutor in the blue suit, tie, sitting at the table. His co-counsel's next to him with the pearls, and then the defense counsels are at the table with Kouri in the black jacket and the blue. All right, y'all. Are we ready for court? We're ready for court. All right, let's turn this up. Let me know how volume sounds. If we need to boost it a little bit, we will. And let's go. Oh, that sounds like it's going to the wrong place as people are shuffling in. Emily, that would be helpful. I was watching YouTube yesterday and had it sent to my main speaker, not the speaker that y'all can hear. So,
all right,
that's Judge M.
on the record in 231-500-139,
Good morning, Judge M.
State of Utah versus Kouri Richins. Can I have counsel for the state make their appearances?
Good morning, Your Honor. Brad Bloodworth, Lindsay Shervanack, Margaret Olson.
You're listing an entire sports roster at this point, Mr. Bloodworth. Does the judge sound good to y'all? Is Judge Emming? We're all hearing it. There's resonance. I know. So, court.
Joseph Hill and Fred Burmester for the state.
Welcome to all of you. For the defense, please.
Wendy Lewis, Catherine Nestor, and Alexander Ramos, and Ms. Richins is present.
Good morning, Ms. Richins. All right,
He
we're
is
here for an
always
evidentiary hearing on
infallibly
3
polite.
motions to suppress. We previously had a discussion on the record regarding initial burdens. I've made notes on the motions that match that discussion. Which motion do you all want to handle first, or is there an agreed order of events?
Your Honor, there's an agreed order that roughly follows chronology. The first is the motion to suppress statements and evidence. The state, for 3 of the 4 issues raised in that motion, bears the burden, so we've agreed that the state will just go first
Okay.
on that. The second motion is the motion to suppress electronic data. The defense bears the burden on that motion. The defense will go first on that.
Multiple
The
motions
third
today.
in order is the motion to suppress the letter. Again, the defense bears the burden. They will go first.
Who is the state's first witness?
Your Honor, the state's first witness is Detective Eric Maynard. But before we get there, the state would like to move into evidence.
And the court's like, no.
What we have previously marked
And for those of you asking questions,
as
I'm going to hold
exhibits
those and get to them when we
1
take
through
a break.
149. Move into evidence for the purpose of this
The judge is
hearing
like, nah.
Is there a stipulation to that effect?
Your Honor, we got these exhibits at like 10:30 last night. I was already asleep.
Good for
So,
you, girl. Get
Can we just do that at
needed.
the end? I mean, whatever he ends up using. I don't expect we're going to object to any of these, but just because I haven't gone through them all, can we just, they come?
It would be helpful to me to have a record of what's being offered through which witness so I can
Yes.
understand and have some notes. Any objection?
Your Honor, in a sense, the state is offering them into evidence.
Oh, Bloodworth is much
now, kind of
sassier in
considering
writing.
Both the evidentiary standard for a hearing like this.
Right.
Under 1101 referring back to 104. The state does not intend to address most of these exhibits today. Rather than the state is moving them into evidence to use them to reference in our follow-on papers.
I appreciate
Well,
that.
then they get-
Are you going to be laying any foundation for the ones you don't
Then they get admitted
expressly
later.
reference today?
Yeah, no.
For
later.
example, there are, it appears, numerous either transcripts or notes from telephone calls. Is somebody going to talk about where those came from or when they were secured?
The judge, are we going to have like
Your Honor, we can.
foundation?
All the phone calls referenced.
Where are we going to
are,
like deal with that?
Jail phone calls using HomeWave, the jail phone call system, which
Someone
I don't know,
will
we have-
lay the foundation for.
laid foundation for several times throughout the course
Sure.
of the proceedings.
Right.
I think kind of the only, to my mind, audio and video recordings.
I know.
That we haven't discussed in other proceedings in some fashion are a video recording by Detective Maynard, an audio recording by Detective Woody.
Thought my closed
and a video
captionings were on and then they weren't.
recording by Detective O'Driscoll. I will address
I
each
can't
of those
move these.
recordings in my examination of those witnesses.
I don't know why they're fixed. Oftentimes I can move those better,
I
but
appreciate all of that.
there we go.
Guess it's up to the state to proceed how you want, but I'd hate to see you miss a short
Just like when your parent says, yeah, I mean, I guess you can do what you want, but I don't know about that. Yeah. Yep.
opportunity to lay some basic foundation for some things that you want to refer to in the briefing rather than just call a witness who can say this is how this stuff was gathered.
And for those of you asking,
need
this
to
hearing was
provide
late last
some
week,
foundation for
It took it a few
reliability.
days to
It doesn't
get
need to meet
online.
the formal
and we were in other hearings.
admissibility threshold that would be required under a formal application of the rules of evidence. But there has to be some foundation for reliability.
This hearing was on the
Yeah,
23rd. I should have said
I
that.
appreciate that, and
I should have said that at the top. This was on the 23rd. We were in Idaho, not Utah that day, and then it takes a few days for these to get up online. They are not streamed. Court TV is pool. Court TV does not put the entirety of these hearings, or has not yet put the entirety of these hearings up on the internet. So it's whoever is there locally to plug in and then chooses to put them up. So sometimes it takes a little bit of time to get them unless someone is there IRL to plug into the truck. So
I guess to some edge we can do that. I think mostly we're talking about warrants, self-authenticating documents.
Sure.
I'll bear that in mind.
Okay.
I appreciate that the defense didn't get notice of these exhibits until after I was in bed last night.
Sure.
I love the blood where it's
Also,
like, I was
please-
also sleeping.
Bear in mind that the defense's moving papers are somewhat vague and uncertain. And rather than litigate their sufficiency under Rule 12, the state has decided, perhaps at some risk, but the state has decided to just roll with
Y'all
this.
caused this yourself.
And in
is
doing
what he's
that,
saying. We're not
It
sure
is
what we're going to
unclear
need.
precisely what evidence we will need
Then admit
to
it at the
respond
end.
to the defense's
Yeah, just
motions,
do it at the
because
end.
At this point, I don't think we're really on proper notice. So we have taken an expansive view with the hope that we have swept up all the evidence we may need. That, of course, will be ultimately determined once we receive more substantive papers from the defense.
We'll see where this goes. The defense certainly is reserving its objections based on or regarding the reliability of the state's evidence, and we'll see how it shakes out. Okay. With that, go ahead.
One more, Your Honor.
Yep.
Not only is there 1 through 149, as we have done in the litigation so far, there are certain documents on the court's docket that we will be referring to throughout today. For example, 214 is the walk the dog letter,
Understood.
and we will refer to in our opposition papers.
Okay. Understood.
Your Honor, subject to the off-the-record discussion this morning, the state calls Detective Eric Maynard.
Okay. I'm going to adjust that a little bit. On the record, but sealed discussion we had this morning. Sam, I need you to stop video recording for a moment. Thank you.
So we should
there
have
will still
audio.
be an audio record of Detective Maynard's testimony.
But we will not
Ms.
see
Nestor, you're looking
Detective
at me. You ready to
Maynard.
go? Okay, let's call Detective Maynard. Zach, will you let Detective Maynard know we can have him in now? Thank you.
The reason, did they skip Maynard entirely? They didn't give us the audio portion? There was a sealed proceeding before Maynard testified. There are a lot of reasons why they might not put law enforcement on camera that can involve the types of work that they do, whether or not they are working with task force, etc. So CW said Court TV put up the full hearing today. We'll go look for it. But there should be an audio portion of Maynard. So let me zoom and see if they're going to skip it. Because if it was skipped,
Mr. Bloodworth, are we ready to go?
if it was skipped, I'll go see if the
Yes, Your
audio
Honor, we're
only.
ready to call Detective Maynard.
Okay.
Okay. If it was skipped, I listened to the entirety of Maynard's testimony, and I will, let me go check and see real quick. But I listened to the entirety of Maynard's testimony, and I will cover that afterwards. So I had looked for this late and did not see it. So give me 1 second to take a look. Chat is always bae. But I was also in bed. After I finished Onyx Storm, but that's a conversation for another day. Let's see. But if the entire hearing is up and we have Maynard, then it would be nice to see, or at least have the audio, because it was my understanding when I was listening in that that they had cameras down. Oh, there it is. So that they had cameras down, and then even though they had cameras down, they allowed for the audio to be recorded. So let's switch videos real quick on that and see if we can catch up in time to the other recording. And if the sound is not better, chat, we will switch back. So live streaming is dynamic. So I knew they were going to put it up at some point because they had mentioned when they were in chat, we had asked them, will you put the hearing up? And they were like, yeah. I don't think this is still the whole hearing, though, because it's not long enough to be the entire hearing. but there were other sealed portions of the hearing. So let's see if we can get to Maynard's testimony. And let's all cross our fingers for closed captioning and Maynard's testimony. Okay, now let's cross our fingers for sound.
Solemnly swear the testimony you're about to give in the matter before the court to be the truth, the whole truth, and nothing but the truth, subject to the pains and
Right
penalties
now,
of perjury.
that sound is yummy. Oh. Huzzah. I mean, there's a bit of background, but I think we can survive. I feel like
proceed.
we can
Thank you,
survive.
Your Honor. Detective Maynard, are you currently a detective with the Summit County Sheriff's Office?
Yes, I am.
Were you a detective with the Summit County Sheriff's Office on April the 13th, 2022?
Thanks, Court TV, for putting up the audio, even the part where Maynard couldn't be on video. Look, there are reasons why that may be the case. They had a sealed hearing about it. As I said, that can have to do with the assignments and the rest of it. So I'm glad we get to hear it because Maynard is covering what happened when Kouri Richins was stopped and her cell phone was taken. And we hear some audio from that. So I'm interested to see how that audio comes across. And then there's some things we need to discuss with regard to, because we're in criminal procedure well and truly with regard to the Fourth Amendment. We can talk about the issues of when you can use somebody's cell phone passcode, when you can't, if somebody is required to give you their passcode, if they're not, when you have access to a phone, when you don't, search warrants for the person versus search warrants for a vehicle, et cetera, et cetera, et cetera. So there are some interesting conversations to be had. So let's go ahead and listen in. And we've got closed captioning. We've got the only fan. We've got the carpet. But at least when the carpet is what's being filmed, there's no risk of somebody walking in front of the camera and you seeing it other than shoes. So yay. Yay.
Yeah. Yes, I was.
I want to turn your attention to that day
So
at
this is
approximately
Bloodworth?
10 o'clock in the morning. Do you recall that day?
I do.
Let me back up so we all are oriented as to date. This is Bloodworth doing the direct examination of the detective. This is audio only, not video of the detective.
Maynard, are you currently a detective with the Summit County Sheriff's Office?
Yes, I am.
Were you a detective with the Summit County Sheriff's Office on April the 13th, 2022?
Yes, I was.
So we're on April 13th.
I want to turn your attention to that day at approximately 10 o'clock in the
2022.
morning. Do you recall that day
I do.
at that time?
Yes.
What were you doing?
I was assisting in a warrant service in Francis.
And was that warrant to be served on a Willow Court address where the defendant in this case resided?
And again, this is April 13th, 2022. The date of the crime as alleged is March 3rd, 2022. Richins was not subsequently arrested until May of 2023.
Yes.
Was that warrant
I forgot
also
my
to
notebook.
be served on the defendant's person?
Yes, it was.
And while you were at that address, in conjunction with serving a warrant, what were you doing?
My assignment on that particular day was to be a kind of an advanced observer. And so I was in the area before the rest of the team of detectives was.
Your Honor, I'm having trouble hearing him. Can he speak up to the
You
mic?
can sit wherever you're comfortable. It's
I mean,
easier
I can
to
hear him
move
just
the mic.
fine.
There you go.
Yay for us. Finally, we can
My
hear.
assignment that day was to be on site at the location prior to the other detectives to watch for people leaving or coming to the home.
Yeah, you don't want to be surprised.
While
on
watching
warrants.
for people leaving or coming to the
Things go
home,
badly.
did you observe anybody leave the home?
Yes, I did.
What did you observe?
I observed Kouri Richins, who was.
Every time I bitch about a prosecutor's questioning, Bloodworth's questioning is what I expect. Bloodworth's questioning is direct, it is concise, it is single issue, he lays foundation where needed. What were you doing? You were at the home. Okay, you were at the home. What were you doing there? I was advanced for serving a search warrant. And then what happened? It is incredibly precise, direct, and simple. There is no need to make questioning a word salad of whatever. Bloodworth's questioning style is very much the style I prefer because I think, this is just my opinion, that it is much easier for the jury to understand what's happening when the questions are clear because you can just follow along. And then what happened? And then what were you doing? And then what was your assignment? The questions are meant to guide the witness so that you are oriented as to what's being asked. So every time I sit here and go, this prosecutor wants, or attorney, makes me want to rip my ears off of my face, it is because this is the questioning style I very much prefer.
A part of that warrant, leave the home in her Infiniti SUV.
And was the defendant, Kouri Richins, the subject of the search of the person portion of that warrant?
Yes, for her cellular phone.
So they had a warrant. They had a warrant to search Kouri Richins' person for her cell phone and a warrant to search the home.
Observed her leave the home where she was then residing in the Infiniti SUV. What did you do?
I followed her a short distance just around the corner from her home and initiated a traffic stop.
And when you initiated that traffic stop, were you behind her?
I was.
Did you then initiate the stop by turning on your emergency lights?
Yes, I did.
And did she stop?
She did.
What did you do next?
At that point, I made contact at the driver's side window. I asked her to step out of the vehicle, informed her that she was being detained, and had her come back and sit in the passenger seat of my vehicle.
Why did you detain her outside of her vehicle?
So she wouldn't go anywhere?
My job was to preserve evidence. Her cell phone was left in the vehicle, and I wanted to get her out of the vehicle so she wouldn't be able to access her cell phone.
Okay. When she left her vehicle, where did she go?
I took her to my vehicle and sat her down in the passenger's front seat.
Ma'am, step
At
out of
this
the car.
point, was she in handcuffs?
No, she was not.
Was she ever in handcuffs?
No, sir.
Was she under arrest?
No, sir.
Was she ever under arrest?
No,
Did you take her car keys at all?
I did not.
The sound going in and out is frustrating.
Did there come a time when you recorded any of your interaction with the defendant?
Yes, when I got back to my vehicle, I realized that I didn't have a body camera, and so I turned on
He was probably just in a
the video
jacket
of my
and plain clothes
department issued
would be my
cell
guess.
phone.
that he was plain clothes.
And where did you kind of set that video as it was recording?
I placed it down by my right leg, kind of
Did you notice he said my work cell phone? Mm-hmm. Important distinctions.
between the seats near where the cup holder would be.
And you're at this point in time sitting in the front driver's seat of your car?
I am, yes, sir.
And she's to your right in the front passenger seat?
Correct.
Okay. Have you seen that video?
I have.
And that video, Your Honor, is marked as Exhibit 3. Is that video a true and authentic depiction of the video, meaning it's not altered or changed
Jennifer, I
at
didn't
all?
mean it as shade. I
Yes,
was
sir.
just pointing out proper work procedures.
In the video, you see
more direct than
a piece
shade.
of kind of police equipment you often see in police cars, captures much of the video screen. Is that right?
Yes.
What is that piece of equipment?
It's a mount for a laptop computer.
And do you know the time that you started that video recording?
It was right around 10 a.m.
Whatever time it says on the recording.
Does 9:58 sound
Yes.
about right?
Yep.
From the time how much time elapsed from the time you approached the defendant at the driver's side door of her car to the time you started your video?
Less than 60 seconds.
I'm guessing
in
he's
the-
in an. This is me speculating.
In
I'm
your
guessing
car-
he's in an undercover vehicle, and that's why the vehicle did not have recording inside the vehicle, and he did not have a body cam on him. He said he was probably in plain clothes and a jacket, and so when you're in plain clothes, it depends on the department if you have body cam on or not. So work recording still records.
With the defendant, did you call that stop to dispatch?
Yes, I did.
And
I don't know why the audio cut out, but
there's a binder of
Called it
exhibits
into
in front of
dispatch.
you. Can you please turn to Exhibit 2 in that binder?
there's a binder and all the exhibits are in the same order.
Okay.
It's so
Is
refreshing.
Exhibit 2 a screenshot of what they call a CAD?
This trial's just going to be like,
It is.
And is a CAD
Linear.
simply a log of your calls between dispatch at this, for Exhibit 2 at this time?
CAD, not
Correct.
cat.
And does the
CAD.
bottom line of that CAD, does that show that you called the stop at 10:02?
Yes.
Okay, thank you.
I wonder if the microphone is audio activated.
You mentioned that you've recently reviewed that video. There's points in the video where you can hear the defendant something like cry. Do you know those points I'm asking about?
Yes.
At any point during the video, including those particular points, did you observe any tears coming from the defendant's eyes?
I did not.
Okay. This detective was assisting. I don't remember what department he was assisting. So they said it right
There
at the
comes a
beginning.
time about 21 and a half
asking.
minutes into the video, Detective Woody arrives at the side of the passenger side of your car. Do you recall that point?
Yes.
Who is Detective Woody at this point in time in relation to this investigation and the search warrant which you're executing?
So Detective Woody at that point in time was the case agent for this case, and she would be, in other words, the lead investigator.
So we're talking April 2022.
Did there come a time after the defendant and Detective Woody spoke for a while, and I'm not going to ask you about words that are captured on the recording. That'll speak for itself, right? But is there a
Yes, it
time
will.
when Detective Woody and the defendant walked from your car to her car?
Yes, there was.
And does the video capture the defendant leaving your car before she and Woody walk over to
Yes.
to the defendant's car? Did you observe the defendant and Detective Woody walk to the defendant's car?
I did.
Did you observe either of them reach into the defendant's car and extract a cell phone?
I observed the defendant walk up to her driver's side door, and I saw that Detective Woody was behind her, but I didn't see anyone physically reach
This will
into
come
the
up a bit
vehicle
more
from
later.
my point of view.
Does there come... Let me back up. Have you reviewed a audio recording or transcript of an audio recording where Detective Woody also records her interaction that we're talking about with the defendant?
Yes, I have.
And does there come a time on that recording where it's apparent that Detective Woody hands you a cell phone?
Yes, Detective Woody did hand me a cell phone.
Okay.
Remember, there's a motion to suppress all digital evidence, so
Once
that's part of
Detective
why
Woody
we're talking about
handed
how the cell
you
phone
that
was
cell phone.
obtained.
What did you do?
At that point, I was kind of just hanging there at that stop until it was finished. And then I went back to the Richins home on Willow Circle.
And how far is the stop to the home on Willow Court?
As the crow flies, maybe 50 yards.
As the crow flies.
Literally just around
Just
the
over
corner
there.
from the home.
When you moved from the stop location to the home, did you have
So she was literally just around the corner from her house.
the defendant's cell phone with you?
Yes, I did.
What happened in connection with the cell phone when you returned to the defendant's home?
At a brief time later, Kouri came back to the home and needed some contact numbers out of her cell phone and asked if she could get those.
Okay. Where during this interaction with the defendant are you and the defendant kind of in relation to each other and to the home?
So when Kouri came back, she pulled her vehicle kind of partially into the garage, and we were standing on what would have been the driver's side of the vehicle in the garage wall.
Declan's like, look, chain of custody.
And by
I
this
know.
point in time, had other detectives secured the home to execute the
And we're going in
search
order.
warrant on the home?
Just
Yes, sir.
right in order of what happened.
Okay, you mentioned
It's just so refreshing.
the defendant the defendant providing you with the passcode to her phone. How did that happen?
I asked the defendant, I said, "What's your password?" And she had been cooperative throughout, and she voluntarily gave me her password.
Okay.
This will matter.
And so at this point in time, is the defendant even detained any longer?
Oh, no. No, she wasn't detained after we left the traffic stop.
How did she get from the traffic stop back to her home?
She drove her vehicle.
At the time she left the traffic stop and drove her vehicle to their home, could she have then driven anywhere else?
Yes. And I heard Detective Woody tell her several times she's free to do it. Just can't go back in her house.
Okay.
Woody's like, go where you want, but you can't go home because we're serving warrants there. Can you imagine? You can't go to your house. We're serving warrants there. I think most people would want to go watch what they're doing.
Did the defendant provide you with the passcode to her telephone?
She did.
Do you recall a discussion that's captured on the audio about the defendant asking for various phone numbers out of her phone?
I don't.
Okay. Did you provide the defendant with any phone numbers out of her phone?
I did. Yes.
And they're not going to let her have
After
her phone.
you provided the defendant with phone numbers out of her phone, did you have any further interaction with her on April the 13th, 2022?
I did not.
Thank you. No further questions.
So when the passcode was obtained, how the passcode is obtained is going to matter for whether or not they had permission to use the passcode, not use the passcode. We're going to hear more about that in these motions to suppress. But it's interesting to see the detective being like, look, she asked for contacts out of her phone. I said, okay, I can give you contacts out of your phone if you give me your passcode. I think a lot of people would be disinclined to acquiesce to that request and be like, I'll get those contacts from someone else. But law enforcement, once they've taken your phone into custody, is not going to hand it physically back to you to look for those contacts yourself, because you could delete something, manipulate the phone, wipe the phone. Once they have it in their custody, you're not getting it back. So you are not obligated to give over your passcode. But she was like, no, we want your passcode. But at this point, again, we are, the date of the crime was March 2nd. We are now at April 13th, and they're coming to take her phone and search her house. Let us continue.
Ms. Nestor, one moment.
So we are going to get to the defense.
Mr. Bloodworth may, in fact, have another question.
Apparently, Mr. Bloodworth has another question.
Your Honor, I'm not sure actually where we are with the admission subject to the reservations.
I think, why don't we admit that, why don't we agree that 1 through 149 are being offered? What the court is going to rely on in making findings related to the legal issues raised in the 3 motions is yet to be determined. Fair enough?
That works, Your Honor.
Does that
Allison,
work for
this,
defense, Ms. Nestor?
Yes, sir.
Okay.
this witness not being shown is subject to a sealed proceeding that we did not hear, but
Court's indulgence for just a minute,
shouldn't
Your
apply
Honor.
to the rest of, should not apply to the rest of the hearing. It applies to this specific witness.
And while you're doing that, will you note that for the minutes? Exhibits 1 through 149 offered by the state, which exhibits the court will rely on in making findings is yet to be determined.
Yeah, it's my assumption that he's either on a task force or working undercover in some capacity, that they're not going to show him streamed.
Video on this.
I mean, I guess there's not a
You don't
fan.
need to keep a formal
to show
offered
us?
admitted kind of chart
So.
for this hearing. The rules of evidence don't apply.
Since there's not a fan, carpet is what we're getting.
No, I got to maintain them for a couple of reasons.
There's only 2 videos on there. And
Well, then you just have it all offered.
Tracy, I appreciate that. Tracy in the chat said I would give my passcode because I didn't do anything wrong. Tracy, I appreciate that. However,
Or maybe wait till I make
try
the
to take
findings,
some
and then
things
you'll
you've
know.
said in an email out of context. People you've called out of
1 through
context. Texts you've sent out of
149.
context.
Yeah.
Even if you don't think you did anything
which
wrong,
exhibits the
you'd be
court
surprised
relies on in
at what,
making its findings
at what
is
can
yet to
be
be determined.
ascertained from your phone.
Ms. Nestor, my apologies.
Even if it's
Please
just
proceed.
wrong place, wrong
problem.
time.
May it please the court. Good morning.
This is the defense
Detective
attorney.
Maynard.
We
How
are now
you?
on cross.
My
of
name's
Detective
Kathy
Maynard.
Nestor. I'm one of the attorneys representing Ms. Richins this morning. I would like to start by your assignment that day.
This audio.
You mentioned you were there to assist in
It's nice and crisp.
monitoring anyone coming or going during the execution of a warrant, right?
Prior to the execution.
And just to be very clear for the record, the warrant was a search warrant, not an arrest warrant. Is that correct?
That is correct.
You did not have an arrest warrant for Kouri Richins, did you?
No, ma'am.
Did you look at the search warrant before you did your assignment that day? Did you read it?
Yes.
Okay, let me show that really quickly. May I approach, Your Honor?
Of course.
Angela, she's not. I don't think she's yelling. The audio is gained up in court, which is appreciated. I think she's just talking directly into the mic, and we have better audio than we've had. But the microphones, you've got to remember, don't project in court. The microphones are for the viewing audience here on YouTube. So in court, she just might be speaking loudly enough for the witness to hear her. And when you're projecting to a large room with a microphone in front of you that's not projecting back, she has no sense of how loud she is in the mic. So I think
Just a moment.
she's just nearer the mic or farther away from the mic. At
Mr.
least we
Bloodworth,
have a
forgive
mic.
me. I'm going to ask this from time to time. Does this one have a number?
It's not, Your Honor. This
Okay.
is the warrant for the house.
So I don't.
The,
May we mark it as 150 just for the purposes of having
Fern's
a
mom,
record
I've been having this problem too.
Sure.
It's
objection?
it's.
no, sir.
I'll summarize it,
Exhibit 150, Your Honor?
but
Please.
the audio is
I'll
extremely
put a
challenging
sticker
for
on it
me.
before we finish the day out.
Okay, we're going to call this the warrant for the house for the time being.
Is that the
Do
house
you
warrant?
recognize that warrant?
This is an affidavit.
Okay,
No.
I think the warrant's on the back of it, but had you reviewed the affidavit or
Ma'am,
not?
this is an
Just the
affidavit,
warrant?
not a warrant.
Okay, if you flip a couple pages, I think the warrant's next.
Okay.
see if you recognize
Do you
it.
recognize that warrant? I recognize
Just
that this is
just
not a
to
warrant.
Clarify, there were 2 warrants that day. I'm going to show you the second one, so I'm not sure if you reviewed both. So if
There
you
were
don't
2
recognize
warrants.
it, that's fine. Had you reviewed that warrant?
Shereen, no, it generally
It's hard
means
to
you're
say. It
over
was almost 3 years
characters.
ago.
Okay.
The
fair.
chats are limited in
All right,
how
let me
long
show
you can
another
write,
one.
so it's generally characters.
And just for the record, that we're going to mark that exhibit 150.
May I borrow that?
You want this all back?
I'll take it if you don't mind.
The judge is like, no, just give it to me.
Thank you,
All right. The warrant we just looked at was a warrant to search the house for fentanyl. Is that right, when you just
Yes.
looked at it? Okay, so now I'm showing you another warrant.
We've already established this. They had a warrant for the house. They had a warrant for Kouri. I will say, when
Okay,
you
thank
see
you.
ODs, it's rare that there's nothing on scene,
Okay.
and there was nothing on scene when
You
EMS
take a look at
arrived.
that one and tell me if you recognize that one.
Nothing near where he was. Nothing they could find in the house. Nothing. So they had a warrant for the house. They had a warrant for Kouri.
It looks familiar, yes.
Okay, so we think that's the warrant you reviewed before you did your assignment that day?
Who's we?
They both would have been there.
Okay.
So
And this warrant, what is the date that it was dated? If you could look at the very bottom of the page of the last page of the warrant. What's the date that this warrant
Oh,
was
Fern's
issued
mom,
by a
that's also a good
judge?
point. Sometimes it's slow mode. Slow
12th
mode's the
day of
other
April,
issue.
April the 12th of what year, sir?
2022.
Okay.
always on slow mode
And
a
you
little.
guys executed the warrant the next day, right? The
Correct.
13th. Lucky 13, right?
Correct.
Okay.
Ma'am, we know this.
If you go back to the first page of this warrant, again, this is Exhibit 1 of the government's exhibits.
I'm
I
going
won't
to be
renumber it.
impatient because we don't need all the foundation because this is a motion to suppress and the motions have already been made to the court and we just need to get to the point that they think is a problem. We don't need the whole like background of it because the court doesn't need it and we don't need it. So I'm just like, can we get to the point that you think is a problem? So I'm going to be impatient with that because the defense doesn't need this background. It isn't their witnesses.
With our own, we'll just use theirs. This is a warrant for the premises of the house, 282 Willow Court. Is that Ms. Richins' home?
Was.
Yes.
Okay.
I mean,
And it's also for the person of Kouri Richins. Is that right?
Correct.
And it says that you're looking for electronics, phones, watches, computers, that type of thing, right?
Yes.
Okay. So, you reviewed that warrant, and that was your authority by which you pulled her over. Is that right?
That's correct.
So let's talk about when you saw her leave. When you saw her leave the house, they live on a cul-de-sac. Is that right?
That is correct.
Kind of at the end of the cul-de-sac.
Yes, ma'am.
So you watched her go to the stop sign, right?
Yes.
And turn, I think, right.
Correct.
And were you in a marked police car?
I was not.
It was an undercover police car.
Unmarked, correct.
unmarked.
I'm sorry, unmarked.
He was very
I get my
careful.
terminology mixed up. An unmarked,
unmarked.
police car. But it had a siren you could put on or lights on your front
It has lights, red and blue lights.
that are like in the grill?
Yes, and I think probably the top part of the windshield.
The top part of the windshield.
Correct.
Okay. So if someone just saw you, they might not right away know you were an officer, but once you turned your lights on, they would be
I
able
mean,
to
it
tell.
didn't seem like she went
Okay.
very far.
And what were you dressed in that day?
Plain clothes, I would imagine.
I don't remember.
Were you wearing a uniform?
No.
Okay. Did you have a breaker, a windbreaker, or a coat on that identified yourself as law enforcement?
Yes, I would have had a jacket and a neck badge.
That's in plain view?
Correct.
And that's because when you execute warrants, you want to make sure that people know you're a law enforcement officer so they don't shoot you thinking you're some kind of a burglar or something, right?
That's correct.
Okay, so you
That's
had your
all of a
badge on
hypothetical.
in plain view, right?
Yes.
And a jacket that identified you as law enforcement, right?
Correct.
And you executed the stop using police lights, right?
Yes.
And
Is there a
when
problem
you
with the
stopped her,
stop?
could you see
No.
the house from where
They have a
you were, or
warrant.
were you far enough that you couldn't see the house
Ma'am.
anymore?
No, even leaving the cul-de-sac there's a slight turn to the right, and then after the stop sign, there's a, you turn to the right again. So it was behind houses.
Okay. So you weren't even on her street anymore when you pulled her over, correct?
Correct.
Okay. And when you approached the window, did you tell Ms. Richins, I'm a police officer or I'm a sheriff? What
She's
did you say?
leading-ish because
Yes,
it's
I
cross.
identified myself and just told her
She could lead
that
more.
I was detaining her for a minute or for a short period of time until some
She
other
could lead a lot
investigators
more.
arrived
I
to
wouldn't be
execute a
mad at
search
it.
warrant.
But did you tell her who you worked for? Like, did you say, I'm a detective, I'm a deputy?
Yes,
What did you say?
I'm Detective Maynard with the Summit County Sheriff's Office.
Perfect. That's what I needed. Okay.
Great.
When you told her
Are we
that,
done?
you mentioned that you knew that one of the things you were looking for was a phone, right?
Correct.
Where did you see that phone?
I believe it was in her hands, her lap.
Do you remember that? Or you,
Yes.
Okay, it was in her lap. All right. So when you told her did you tell her to get out of the car?
Yeah, I asked her to come out of the
Whose
vehicle
feet are we
and
looking
come
at
sit in the
now?
car with me.
Did you
Oh,
tell her
good.
she had the right to refuse to
The
get out of her
defendant.
car?
Let's look at the
I did
defendant.
not.
Were you wearing a gun?
Yes, I was.
Was it in plain view that you had a gun on?
That would have been covered up by a coat.
Okay. But you did. Sorry. I had coffee
The
this morning.
the video is sealed as to this
you
witness only.
Did not tell her she
Looking
had a
at the defendant
choice.
works for
You
me
said,
with
get
this
out of the car.
circumstance.
Yes,
And you removed her from her vehicle.
I did.
No, she doesn't have a
And
choice.
What happened to her phone when she got out of the vehicle?
She left it in the car.
Right. Did you tell her to leave it in the car?
I don't recall.
Unlikely.
So you know the
bec-
phone's in the car.
He had a search warrant for her person and wanted her phone. It is unlikely that he said, leave your phone in the car. They didn't have a warrant for the car. They had a warrant for her. So, no, it's unlikely that he would have said anything about it. He could have said, bring your phone, but didn't say that either.
What happened to her car keys?
They were left in the vehicle as well.
So you separated her from her car keys and her phone.
Yes,
And you walked her to your vehicle. Is that right?
I did.
All right. And did you give her an option about getting into your vehicle, or did you tell her to get into her vehicle?
I don't remember the words I used. I asked her to get into my vehicle.
Okay.
Ma'am, have a seat.
Did you tell her at any point she was free to leave?
I did not.
Okay. And I believe you testified when you were talking to Mr. Bloodworth that about 60 seconds went by from the time you first engaged her till you got her in your car, right?
Best of my recollection, yes.
And in that 60 seconds, did you give her her Miranda rights?
I did not.
Right. And you know what the Miranda rights are, of course.
Sure,
All right. And you never read her rights.
I did not.
All right. And I think you've
No,
already
I
testified
don't
she
think
was
he's gonna
not in
interview her.
handcuffs, but she was in your police car.
Correct.
Right. And the video that you took, were you trying to hide it? Is that why it was down in a weird place?
No, I just wanted to document.
Put it down.
What was going on in the vehicle.
Okay.
It is for
And
backup.
at any point, the whole time that you were with her,
He wasn't there to interrogate
I
her.
know that
He wasn't there to question
there's
her.
a video, and I'm
He
going to
wasn't
play
there
a
to
little
arrest
piece
her.
of it. I'm not going to play the whole video.
He was there, so she
but
didn't
for
leave.
purposes of the judge, at any point that she
And they
was in
could
your car for
search the
about
house.
20 plus minutes, did you ever read her Miranda rights?
No,
Okay.
Right.
All right. I want to show you the first 5 minutes.
He wasn't
of
there to interrogate
the
her.
Car. And there's several things that you say to her. Alex, if you could play that.
This is a
video.
defense motion to
Do we have
suppress.
a-
This is a defense motion to suppress. So they are trying to suppress all of the different parts of all of the different things. They are trying to suppress statements made, things found in the search, things found on the phone. So they are going after every single part of the stop, the arrest, because they're challenging all of it. They weren't super specific in their motions. The prosecution mentioned that earlier, but it's kind of a broad suppress all of the things. We'll listen and we'll see how that's going to go. But so they are going to attack the stop. They're going to attack the warrants. They're going to attack, was this a custodial interrogation where she made incriminating statements without Miranda and therefore that can be suppressed. So we'll see what happens. But if it's not a custodial interrogation, then Miranda does not apply. And if you get into a police car and start saying shit, even if they haven't Mirandized you, if they haven't asked you a question, that's not an interrogation. That's just you saying shit. So we'll see. They're going to play some audio.
I need to, are you
Hold on.
hooked up to the
We're gonna-
screen?
I just need to wait for the court.
Oh, can we put the screen on?
We can. One moment.
Yes, like the suppression motions in Idaho.
Yeah.
Yep.
We can put it on the TV.
We're at this similar
I think I'm
stage of the
connected.
proceeding
I just
here.
need her to turn it on.
Mr. Ramos, do you see the video on your screen?
I do, Judge.
Ms. Sherbanek?
Yes.
Okay. We'll replicate that on the big screen.
Yeah, when
Thank
people
you.
are stressed,
see it
they
in
get
front of
real
you,
chatty.
Yes.
Okay.
Okay.
May I just test the audio real quick, Judge?
Yeah, let's see how it goes.
He didn't need to read her Miranda rights from what we've heard so far.
Make sure I haven't turned my audio off.
We talked about this a lot in the
I don't think so, no.
the Josh Duggar case. All right, I'm going to back this up. She's trying to figure out what's going on. That's not him interrogating her, so let's listen. Her trying to get information from the police is not them asking her questions.
Make sure I haven't turned my audio off.
So let's listen to what Kouri has to say.
I don't think so, no.
Okay, if you could just rewind that. So actually, it's kind of hard to understand the
She's
very
asking
first
about
thing
her
she
sister-in-law's
says, but
taking the
Do you
house.
remember her asking you initially, is my sister-in-law trying to take my house?
I don't think, yes.
That was
not
the
your
first thing she
house.
said when you guys got in the car. And you said, I don't think so. Right? I think that's on there, but we'll
Yes.
just listen to it. Your Honor, I'd like to, go ahead.
One moment. Go ahead, Mr. Bloodworth.
Your Honor, just for the court's ease in following along, a transcript
Yeah, we do have a
of
transcript.
this video is at tab 4 of the binder.
Okay.
I will provide that to Mr. Maynard too, just a moment.
He's
I
got
think
it.
I've got it.
Oh, you got it in front of you?
Which page of the transcript are we starting on?
Remember, this
The
is
very
after
first page, Your Honor.
she and her sister-in-law got in a fight.
Try to get my copy too.
Presumably, she
In the
knows at
video
this
through,
point.
Your Honor, I think
Yep.
Presumably, Kouri knows at this point that the house that her husband owned solely as his separate premarital property was in a trust, and the trust is being controlled by the sister-in-laws. So presumably at this point, just a little over a month after Eric's death, she is aware of that. I imagine tensions have ramped up. This is after she throat punched her sister-in-law, which was immediately following the death in March. So I am presuming that tensions did not go down in the time following Eric's death. So this is after that point in time.
And again, Your Honor, we're only going to play like 5.5 minutes.
It's fine.
If you could indulge us. We're not going to play the whole thing.
We'll indulge you 5.5 minutes. We want to hear what Kouri had to say. We want to know.
Find it right here. What did you say the number was?
Tab 4.
4. Yeah, that's it. Okay, go ahead,
Yeah.
Alex. And then if you could, Alex.
We have a playlist on this case. It came up when the sister-in-law testified during the initial bail hearing. There was a verbal disagreement over the ownership of a safe in the garage in the house somewhere. And Kouri was trying to get into the safe that belonged to her late husband. And the sister-in-law was like, that's not yours. And that's when they had a verbal argument that Kouri then went full hands-on with the sister-in-law. And the sister-in-law testified to that at the first bond hearing.
Stop when I ask you to stop, okay?
He's trying to take the house.
I don't think so, no.
And that's her body you can see there, just part of her sweatshirt.
Yes.
And that's the thing for the laptop that's blocking the view.
Yeah.
Is the lady, the one lady coming that I've been talking to, Detective?
You turn it up at all, Alex?
Is the one lady coming?
Woody?
It's probably Woody.
Yes. Yeah, she's coming over so shallow.
Why didn't you just talk to me on the phone? Why didn't I just go? What is going on?
I don't know. I'm just helping out, okay?
Ma'am, I'm just doing my job.
Knock on my door.
Huh?
Why didn't you just knock on my door?
Or would have.
said, I'll just let the detective explain when they get here, okay?
She wants to know what's happening. This officer's like, ma'am, I'm just helping out. I'm making sure nobody leaves the house. You left. Here we are.
Can you just call my mom?
I just need to sit with you here until they get here, okay?
Okay,
No,
stop.
I'm not calling your mom.
Did you hear just then when you said, I know it's really quiet, I don't know if the TV can be turned any louder. I think my computer's as loud as it will go. But did you hear yourself, you need to just sit here until they get here? Did you hear that?
I said, I just need to sit here with you.
He did
Until
say
they
that.
get here.
Here.
All right. So
can we
at
just-
1 minute and 38 seconds
We're just staying here, ma'am.
your give or take, while you have her in your car, you tell her that she needs to wait and sit with you, right? Okay, keep playing, Alex, please.
Okay. He's doing the opposite of interrogating her. His voice is giving, ma'am, please just be quiet.
Need some air?
No, I'm right in front of my neighbor's house. Like, this is so embarrassing. I don't want any air.
I'm in front of my neighbor's house. This is so embarrassing. Right.
Why did they tell me not to go down? I don't know why they told me not to just go. Detained, does that mean I'm arrested for something?
No, you're not arrested.
Do you think I don't know why it's happening?
Are you arrested? No.
Okay, if we could stop there for just a minute. So looking at the transcript, it appears that what she just said was, and I know you could kind of hear it a little bit, but she said detained. Does that mean I'm arrested or something? So had you told her when you first brought her in the car that she was detained briefly?
I told her that at the window.
So she's following up and saying, detained, does that mean I'm arrested for something? And
No,
you responded,
it's
no,
cop
you're
for
not arrested,
you need
right?
to stay here now.
Okay, keep playing, Alex.
Detained is you need to stop here now and wait.
Sorry. At this point, Ms. Richins does not know she's being recorded on a phone, right? You didn't tell her you were
I didn't
recording
tell her, no.
Okay.
Okay. She sounds stressed and possibly scared if we can see what her face looks like.
1346. Will you show me traffic at Aspen Road?
And he just called in the traffic stop.
In Camas. Echo 201, their Delta.
She didn't say, do you have any more information about what happened to my husband?
What is going on?
Thank you, Court TV. We appreciate it.
You can get everyone that's involved in the warrant service dispatch over to task one. Copy.
Is this because my sisters bought stuff at my house?
Stop.
What's that?
So again, under the transcript, and you could barely hear it, but
What
she
are my
says,
sister-in-laws
"Is this because
doing?"
my sister-in-laws want all the stuff out of my house, right?
Correct, that's what she said. Yeah.
Okay, keep going, Alex, please.
I mean,
Because my sister-in-law saw all the stuff at my house. You can take it.
I don't know about that. Look, you're not in handcuffs. You're just detained for a minute.
No, ma'am,
Okay,
the
stop
cops.
right
I
there.
don't know what that.
You just said, look,
No, ma'am, the cops would like some shit out of your house. This is not this. Your sister-in-laws did not call the police to have them go and take property out of the house. Though, in this circumstance, there might be a circumstance in this where they could have done so, but that's not the situation here. There's an investigation into the death of your husband. Ma'am, this is not about your sister-in-laws. She's very worried about her sister-in-laws.
You can take it.
I don't know about that. Look, you're not in handcuffs. You're just detained for a minute.
okay, stop right there.
You're just detained for the moment.
You just said, look, you're not in handcuffs, you're just detained for a minute, okay? Is that what you said?
Yes, ma'am.
Okay, so once again, you're telling her she's detained for the second time and have not told her she's free to leave, right?
Correct.
Okay, keep playing, please, Alex.
Doesn't make it a custodial interrogation.
Like eyes on, has picked her up leaving house, so she is in hand right now. We'll still plan on staging the,
She's like, I don't know what's going on. That's why she keeps talking, because she wants to know what's going on and doesn't.
Let's make sure everything's secure, and then I'll head over to the Star building and make sure everyone's on the same page.
Why would I be in handcuffs anyway? I don't know what you're talking about.
Why would I be in handcuffs
I
anyway?
just need to hold on to you till I get here to talk, okay?
You asked if I was under. She asked if she was
Okay,
under
stop
arrest.
right
He's
there.
like, "Ma'am, are
So
you in
what
handcuffs?"
just
No.
told her, she asked, why would I be in handcuffs anyway? I don't know what you're talking about. And you said, okay, I just need to hold on to you till they get here to talk, okay? Isn't that what you just said? So once
Yep.
again, you're telling her she has to remain.
Yes.
Okay, that's all I need on that.
She
right
doesn't get
now.
to go anywhere.
Alex, thanks.
She can be detained.
Okay, so then you remain a little bit longer, maybe another 15 minutes. I don't want to play the whole video.
Yeah, he said she's
But
not in handcuffs,
when
and she's like,
she
well, why would I be in
arrives-
handcuffs? Am I under arrest? He's like, no. His voice is so. Can we just wait for Detective Woody? You need to just stay here. That's it. And she is like, I don't know what's going on. She keeps, it seems to me, trying to get him to explain what's happening. And he's just like, ma'am, I was just supposed to be advanced. I was just going to sit here and make sure nobody left. And then you left. And now you're in my car and I have to deal with you. There's going to be paperwork. I was just supposed to sit on the house. So now I need you to just sit here. So sit here. And she wants to know what the fuck is happening. And he is not going to tell her anything.
That is,
The less he says, the more she talks.
I don't know if her title is Investigator Woody, Detective Woody to arrive, right?
Correct.
And at one point, Detective Woody or Investigator Woody does arrive. Is that right?
Yes.
And when she arrives, Ms. Richins is still seated in the car, right?
She is.
And
yes.
you're still video recording.
Correct.
And they have a little conversation that's on your recording.
They have a little chat.
At no time did Detective Woody issue Miranda rights, did she, in your presence?
Not in my presence, no.
And then at some point, Detective Woody instructs Kouri to get out of the car, right?
My recollection is she asked Kouri to exit the vehicle.
Okay. And that's maybe less than 30 minutes, but more than 20 minutes from the time you detained her, right?
Your Honor,
The
this is all
timestamps
recorded.
speak
The
for
time
them.
is all recorded in the video. I think a memory test of time that is clearly recorded is unproductive.
May I ask you a related question? Any argument that the transcript is inaccurate?
No.
Okay,
We could just,
I can read it.
yeah.
Okay.
So at some point, you guys get out of the car and you no longer have your phone recording, right?
When I left the car, I believe I left my phone in the car recording.
And I believe you said that you were behind Detective Woody and Ms. Richins as you all walked to her car. Is that right?
Yes, ma'am.
All right. And again, in between the time you walked from your car to her car, did anybody tell Kouri Richins she was free to leave?
Well, she wasn't free
I
to leave.
didn't.
Okay. Did you hear Detective Woody?
No, ma'am.
All right. And
Right,
then
'cause
did
she
you
wasn't free
hear
to leave.
Detective Woody instruct Kouri to hand her her phone?
I heard her ask her if she could go get her phone.
Out of the vehicle.
I just heard her ask her if they could go get their phone.
And the phone
Your
was
Honor,
in?
again, this is all on the recording.
The
and
video speaks for
transcript.
itself.
I think she just may be laying foundation, but we can, if you can just keep it moving.
I will.
We don't need all the foundation. It's an
So-
evidentiary hearing for suppression.
The
Just
phone was in her vehicle, which she returned to at the direction of Officer Woody in your presence.
right.
She gave it to Officer Woody or Detective Woody, and Detective Woody handed it to me.
And she got it by leaning into the car and getting it.
Can we have some specificity about who she is?
Sorry, there's
Woody,
two women.
and then Kouri.
Thank you.
Woody
Ms.
did not reach
Richins
into the car.
handed the phone to Detective Woody, is that what you're saying?
Yes.
Okay, that means she had to go in the car to get it, because you left it there,
Correct.
right?
No, Kouri left it there.
At that point, you mentioned that
I know, we
Detective
fixed
Woody
it.
gave the phone to you? Is that
Yes,
right?
ma'am.
The all caps
she
are
asked
very
you
on
to
brand for
keep it?
TV.
She asked me to hang on to it. She had lots of things in her hands, and
Okay. And when you
Detective Woody was busy.
took that phone, you had reviewed the warrant that we just went over, right?
yes.
And that warrant didn't authorize you to search any vehicles, did it?
He didn't.
No, ma'am.
Okay, but you took the phone anyway.
He didn't
Right.
search the vehicle.
Yes.
Okay. And you guys go back to the house. Is that
Here's
right?
what would have
Yes,
happened.
ma'am.
If Kouri had said no, Detective Woody said, hey, can you hand me your phone out of the car? So Kouri went into the car and handed the phone. Okay. If Kouri had said no, which she could have, no, I'm not going to hand you the phone from the vehicle, then they would have put her back in the front seat of the police car and said, okay. And then Woody would have said, that's annoying. And then Woody would have called back to the department and said, hey, based on the affidavit that we have and based on what happened, I'm here with Detective Maynard, who did a traffic stop with Kouri. We have a search warrant to search her person for a cell phone. During the traffic stop, she left her cell phone in the vehicle. Can you please issue a warrant for us to search the vehicle for a cell phone? Thanks. And then they would have had Kouri sit in the front seat of the police car. They would have waited for a judge to sign the warrant. Somebody would have driven over a warrant for a search of the vehicle to get a phone. They would have opened the door to the car, and they would have picked up the phone and said, thanks. So Kouri could have said no. She just would have been sitting there longer. But instead, Detective Woody said, can you hand us your phone out of the car? And she said, sure, because they can search Kouri's person for the phone. So either way, they were going to get the phone on this day. Nothing they've done here is screaming improper. Let's keep listening and see what else they're attacking with this.
And you let Kouri drive her own car back?
Right, she wasn't under arrest.
Right. And when she arrived, how long before you engaged with her again?
It would have been less than 5 minutes.
Did you follow her in your car?
I don't recall. I was behind her, so I can't say.
Okay. So when you guys get to the house, about how many officers were in the...
I had to guess 10-ish.
Okay.
Officers searching
They're
the
all
house.
dressed in police clothing, or
They were probably in
detectives or
plain clothes with
deputies
jackets
and
if
law
they're serving
enforcement.
a
They're
warrant.
wearing marked items of clothing to indicate that they're law enforcement.
And there was law enforcement vehicles there.
Correct.
And she pulls into her driveway. Did you hear any instructions she was given about whether she could stay, whether she had to leave, anything?
He said that. He said she wasn't allowed to go in
At
the
the
house.
house?
Yes.
I didn't hear any instructions there, no.
So when you next engaged her, where was she?
In the garage.
In the house where the search was going on, right?
In the garage of that house, yes.
And there were officers in the garage, more than one.
I don't recall. I know I was there.
And when you went up to her, you asked her to tell you.
Were
the
there officers in the
passcode
garage? Well, me.
to her car, her phone,
I
right?
was.
At that point, she had wanted to be able to get some contact phone numbers out of her phone.
And you're
She's
saying
Kouri.
that's why you asked her for the passcode?
No, I asked her for the passcode so we could have it.
Why did you need it?
We have a warrant for her. We had a warrant at that time for her phone.
And you wanted to open it up and look in it?
No, it's just easier when you have the passcode
Well, somebody's
Easier
going to
do
look at
what?
it.
to get into the phone.
Right. So that's why you got the passcode from her.
Sure.
Okay. And
They asked her for the passcode.
the
You don't have to give over your passcode.
you mentioned on your testimony that at the time
They'll
you
get
did
into your
that, Ms.
phone.
Richins was not being
Either way.
detained. Is that right?
That's correct.
And when you finished all your duties that day, you did a report.
He asked her for her passcode when they were in the garage of her house. And she said, I need contacts out of my phone. He says, well, we need your passcode. And she gave them the passcode. So it's easier for forensics, but we'll hear more about that later.
Did you not?
I did.
And it's important in your training, you're taught that every detail matters in your reports. Is that right?
Yes.
And the chronology matters in your reports. Is that right?
Yes.
And you know that because you're an experienced detective,
I don't know what happened.
right?
That was not me.
Yes, I know that.
And you prepared a report maybe a day or
Sorry,
two
y'all.
later. Is that right? That's like the next day, it looks like.
I don't remember which day it
May I
was.
approach, Your Honor?
Yes.
You prepared a report. On the report, it has a date. Okay. Sure. Well, she is approaching.
Your Honor, I'm approaching Detective Maynard with, can we mark this because the government doesn't have it? I think it's 151 now. Is that right?
Good. May I have a copy to market?
Yeah.
Brianna N. in the chat said, EDB, is it possible he actually did not know why she was being detained and literally was just there to watch her? He read the search warrant affidavits. So,
Appears to be the report that
Had
you
a
made
general
following
idea.
your duties that day. Is that right?
Yes,
at
You
minimum.
recognize that report?
I do.
Can you tell by looking at it when you prepared it?
It's timestamped the next day.
Okay, so a day later.
Correct.
All right, and if you can go down in that first paragraph to the, let's see.
I thought they were just looking for the date.
All right, so
Missy, I try to
first
make
of
it
all,
fun
it does say in
and
here that
informational.
you initiated a traffic stop, and I made contact with Kouri
Casey
and
Cat,
informed
thank
her I
you.
was detaining her until the case agent arrived to speak with her. Is that right?
Correct.
That's consistent with what you've testified to, correct?
Correct.
All right, and then if you can go down a few more lines where it says,
Again, they're allowed to hold her, and so
Kouri
far we don't
gave
have an
her phone to
interrogation.
Detective Woody, and I held on to it for a short period of time. Do you see that?
I do.
And then you say I turned the phone back over to Detective Woody at the home.
I did.
Okay, and can you read the next three sentences of your report?
I asked Kouri what the passcode to the phone was, and she voluntarily gave it to me. I also gave that to Detective Woody.
Keep reading.
At that point,
Okay.
At that point, I released Kouri from my custody and went to the home.
So according to your report, she was in your custody until she gave you the passcode. Your own words.
Custody was a poor choice
Presence.
of words on my part.
It's the ones you used, right?
I used that word in the report, but she clearly wasn't in my custody.
So your report's wrong?
That was a mistake on my part to use that word.
I don't think that's the serve she
And
thinks it
here, you
is.
don't say anything about her asking you
But
for
again,
phone
that's
numbers, do you?
their job.
I don't.
Okay.
It's her job.
And when you say she voluntarily gave it to you, did you tell her she had a right to refuse?
I did not.
He's like,
Tell her
no.
she had a right to remain silent?
I did not.
No, I didn't give her Miranda rights. I
Tell her
didn't
she had a right to
interrogate
ask for a
her.
lawyer?
I did not.
She already had a lawyer. She could have asked for her lawyer, and they could have said, if they did, if Kouri had said, I want to talk to my lawyer, they would have said, that's fine. You can talk to your lawyer when we're done. Because they're not interrogating her. They're not questioning her. They're not asking her for any information. In the sequence of events, she says, I want to get contacts out of my phone, or at least this is the way it sounds. It might not be that right sequence. I want to get contacts out of my phone. And they're like, okay, well, we need your passcode. Can you give us your passcode? And she said, I will give you the passcode. She's not in custody. She's at her home at this point, and she's free to leave at any point now that she's at home. So it's not really going to go very far with that, but That's what they are trying to get to with, we have a warrant for the phone and we asked her for her passcode and she gave it to us.
Okay. And that'll be Exhibit 51 offered by the defense, Your Honor, the report.
151.
So
Yeah, I mean, I'm sorry.
if she
Thank
had
you.
asked for a lawyer, they would have said, okay, well,
Both these.
you can call your lawyer when we're done
That one I have.
That was a second.
from a different phone
Yeah, thank you.
because she's not being interrogated.
Thank
So
you, sir.
nothing's going to stop.
Court's indulgence for just a moment, Your Honor.
Of course.
Yeah. So there's no need. They have no plans on interrogating her. It seems at this point they want more information. They just want the phone and the house. In the house, I mean to search. Good to see the law nerds in the chat. So Stephanie, this was your question. If she said she wanted to call her attorney, they would have said, okay,
The
well,
phone that you gave,
not on
that
this
you
phone.
took from Detective
Go
Woody
find another
and then
phone.
eventually gave back to her. Can you describe it? What kind of phone was it?
I have no idea. I can't remember.
Okay.
What kind of
that's
phone
fine.
was it?
What
Phone.
did you do with it? Did you ever put it in an evidence bag or seal it or put it in what's called a Faraday bag?
I did not.
Do you know what a Faraday bag is?
I do.
What is a Faraday bag?
My understanding is it
Phone cage.
basically kind of encapsulates the phone so that it can't transmit or receive cellular signal.
Okay, so you did not do that.
I did not.
All right. Once you got the passcode, did you open the phone yourself?
I did not.
Did you ever look in it at all?
I've not looked in her phone, no.
Okay.
He's like, ma'am, he's the definition of that's not my job.
All right, that's all I have, Your Honor. I tender the witness back to Mr. Bloodworth.
Ma'am,
Mr.
that
Bloodworth,
is
anything
not
further?
my job. That is not my job. That is not my
Detective, You
job.
can step down. May we release this witness, counsel?
Yes, Your Honor.
All right.
You're free to go, sir. Thank you.
Not my job. All right. That was witness one for the motions to suppress evidence hearing in Kouri Richins in Utah. Again, this is from the 23rd. And we will get to the state's second witness. And if the judge is not talking, I'm going to zoom.
That's okay.
I don't know what they're waiting for, but
Mr. Bloodworth, are we ready to go?
Yes, Your Honor, we're ready to call Detective Woody.
Okay.
all right, Detective Woody.
Brittany, are we on the record? All right, let's call the state's next witness, please.
All right, next witness.
Your Honor, the state calls Detective Jayme Woody.
And again,
Detective, if you'd step in front of Brittany, we'll get you sworn in.
this is from January 23rd. This judge does not allow the hearings
Please
to be
raise your right hand.
streamed, but Court
Do
TV
you
was
solemnly
pool.
swear the testimony you're about to give in
and
the matter
put the
before
hearings
court
up
to be
today.
The truth, the whole truth, and nothing but the truth, subject to the pains
So we
and
have
penalties
everything
of
that was
perjury.
not sealed.
Thank you. Have a seat.
I can imagine nothing less comfortable
Good afternoon, Detective Woody.
than having to wear all of that stuff.
Are you a K-9 patrol deputy with the Summit County Sheriff's Office?
I am.
Doggies.
Back on April the 13th, 2022, were you a detective with the Summit County Sheriff's Office?
I was.
And at that time, were you the lead detective investigating the death of Kouri Richins?
Yes, sir.
And at about 10 o'clock on the morning of April the 13th, 2022, were you preparing to execute a search warrant on the Willow Court address where Miss Richins then resided and on the defendant's person?
I was.
At about 10 a.m. that morning, where were you physically preparing to execute that warrant?
At the sheriff's office.
And were you planning how you were going to execute the warrant at that time?
We were.
I love that the
Did there
chat's like,
come
can
a
we hear more about the
time-
puppies?
Right about 10 o'clock when you received word that Deputy Maynard had
I'm just going to say now. Just because friend shaped, not necessarily friend when working. Working puppers, not friend. Not friend. Those are working puppers danger floofs. But I love that the canine unit has its own patch for the sheriff's department on her arm. I am living that it has that the canine unit has its own patch. So yes, the working dogs are friend shaped. Some working dogs also friend, but those are not the type of dogs that she is working with. I do not get the sense that she is working with the community outreach dogs. So
Stop the defendant a short distance from
them's
home.
danger floofs. No touching.
What did you do upon receiving that word?
I proceeded over to that location.
To the location of the stop.
Correct.
Once you were at the location of the stop, what did you observe?
I observed Kouri in the vehicle, the detective's vehicle.
And was she in the front passenger seat?
I believe so, yes.
Did you record this interaction with the defendant at all?
I did an audio recording.
Have you recently reviewed that audio recording?
I have.
Sorry, I was covering
And is
Judge
that
M's
audio
face. That is
recording
unforgivable.
a fair and accurate representation, meaning it's not been altered
Apologies,
at all?
chat.
Correct.
Your Honor, that audio recording is found at Exhibit 5 in the state's binder.
Exhibity.
A transcript of that audio recording is found at Exhibit 6.
I mean, I'd love to hear the whole thing, but we're not going to at this point because Bloodworth is judicious with his time and his binder.
At any time during this interaction with the defendant, did you observe her in handcuffs?
No,
Did you place her under arrest?
I did not.
Did you observe her crying? Did you observe any tears?
I did not observe
Why
any
are you
tears,
so worried
but,
about the tears?
She sounded like she was crying.
She was.
But no tears.
No.
Bloodworth, can we just not worry about the tears? The audio speaks for itself of the state of emotion of Kouri Richins. I don't think we need to worry about whether or not there were tears. Bloodworth, move on.
Do you recall a time when you asked
There was lots of
the
sniffing.
defendant if she wanted to come with you and grab her cell phone?
I do.
What happened then?
She said, sure. Here's
We
my
walked
phone.
over to her car, and I believe she reached in and grabbed the phone and handed it to me.
Ouch. I see chat saying hi to Runkle. Runkle, hello.
When she
Congratulations on
handed you
your
the phone,
Gundy.
or as she was handing you the phone, do you recall a discussion about the phone?
And everyone's saying, feel better. Uh-oh.
I do.
Did Vegas get Runkle? I've been reading Onyx Storm. I have not paid attention to
There's an
anything.
exhibit binder.
Vegas
in
will do
front of
that.
you.
Recover from Vegas.
Can
Vegas
you
will
turn,
Vegas.
please, to tab 6 of that exhibit binder.
And again, if the police say, can you hand me your phone? You can say, do you have a warrant for that? And in this case, they would have said, well, actually, ma'am, we do have a warrant for that. We just don't have a warrant for your car yet. So if you don't mind reaching into your car and handing it to us, that would make it a lot easier for us.
Is that a transcript of
If
the
she had
audio
said no, they
recording of your interaction at this
Would have
time
gotten a
and date
warrant.
with the
She would have had
defendant?
to wait there.
Yes, sir.
Either way.
Can you turn, please, to page 11, look at line 1, right at the very top, where you say, do you want to come with me and grab your phone real quick?
Do you want to build a snowman?
Okay.
And is that the point where she exited Detective Maynard's truck and walked with you to her car
Correct.
and reached into her car and retrieved her telephone?
Yes, sir.
I mean, she made it easy for them. She didn't have to, but they would have gotten it either way.
Do you see down at line 11 where you asked, do you want to take it out of the case or not?
Yeah, I see that.
At the point you ask that, who is holding the phone?
Kouri is.
And
That's kind.
why did you ask her if she wanted to take the phone out of the case?
My
I
cases are
usually ask
expensive.
that if there's something attached to it, cards, driver's license, something like that, that I don't want to take with me.
I don't want to have to put that shit in evidence. I just want the phone. Look, I'm just here for the phone. Take your case. I am just here for the phone. That is so real. I don't want your wallet. I don't want any of it. I just want I'm here for the phone. I just want the phone. Give me the phone. It doesn't matter. By the time Kouri Richins has another phone, that case isn't going to fit it anyway. That's not gonna be a thing. So
Ultimately, she did not remove the phone from the case?
Not that I recall.
And after you asked her, do you want to remove the phone from the case, that is when she handed you the phone?
Yes, sir.
Okay. Please turn the page to 12. I want to clarify one thing. On line 9, it talks about an unidentified male speaker. Is that male speaker Detective Maynard?
It is.
That's in the
In
transcript
line
of the audio.
10, you say, kind of in a conversation that's unclear, I'm looking to clarify it here. You say, give you that and then I. Is the that in line 10?
They're going over
cell
the
phone?
transcript.
Overruled.
It's foundational.
If
They're
you could,
going over the
please read
transcript of
below to
the
line 13.
audio
At this point in
recording of
time,
the
it appears you're
handoff.
speaking to the defendant. You say, then he'll follow you back and you can do that. Is the hill Detective Maynard in that sentence?
It is.
Is the that provide you with phone numbers out of your cell phone?
Correct.
I appreciate that the prosecution is just clearing up anything in the transcript that's unclear, and then he's just going to submit the transcript as evidence for the court. If the court needs to read it, the court may not.
After your audio recording, where do you go?
Such a
I
clear
go
question.
over to Becky's house.
And
Not another Becky.
Was Becky an employee of Eric Richins' company that had some electronic devices that you were interested in recovering?
Yes, sir.
And is Becky's house
I appreciate the foundation of like, let's just get us to why this matters.
right in front or right off the street where Detective Maynard stopped the defendant?
It was.
So you wanted to walk straight from the stop kind of to the closest house
Correct.
to retrieve some electronic gear?
Yes, sir.
Okay. When your audio recording stops, do you have any other interaction with the defendant at the location of Detective Maynard's stop?
Not that I recall.
Okay. When do you next have any interaction with the defendant?
At the home. At the Willow, I think it's Willow Court.
The Willow Court address. Okay.
So Becky being an employee
What
of Eric
interaction do you
Richins,
have with the defendant at the Willow Court address?
decedent here,
I believe we
had
asked
some
if she would
devices that
either
may be his.
provide the safe code or open the safe up at the home.
And did she?
She did. She wanted to ask a few questions and ask about the warrant and what we found and stuff.
Okay, set the scene. What are you doing at the home?
He's like,
I'm
be more
walking
specific.
around trying to help serve the search warrant.
At this point in time, other than asking for a safe code, are you at all questioning the defendant?
No, sir.
You said she was asking you questions. What does this look like? What are you doing and how is she asking you questions?
Can we expand on that?
We're just kind of walking back
What are
and
you-
forth to the safes, and she's kind of
Safes.
following behind me, asking different questions.
What types of questions?
Questions about the warrant, I think questions about what we were looking for, what we found, things like that.
I don't doubt any of that. I can, after
At this
listening to the
point in
audio,
time, What was your interest at the house?
I can see Kouri
Just to serve the warrant.
trying to pause. I can see Kouri walking around behind the police. What are you looking for? What are you trying to find? What's going on? Why are you here? What did my sister-in-laws say? Are you here to take stuff from my sister-in-laws? I can absolutely picture her following Detective Woody. And she and Detective Woody had prior conversations before the warrant is served in the house. I can see Kouri following them around, asking all of the questions about all of the things, and Woody being like, can we just have the code to the safe? Because the safe could hold what we're searching for. We're searching for, at a minimum, narcotics, but also electronics, and a safe is a place where you could keep those things.
At this point in time, were you at all wanting to interact with the defendant?
No, sir.
What did you want to do?
I just wanted to serve the warrant.
Wanted her to
and
shut the fuck
finish
up.
it.
I just wanted to do my job and leave, because we're gonna have so much paperwork to do. It's a warrant day.
No further questions, John.
Did you want to interact with the defendant? No, sure didn't.
Ms. Nestor.
That's a nope.
Thank you, Your Honor. Good afternoon.
Good afternoon.
My
We're
name
on
is Kathy
cross.
Nestor. I'm one of the attorneys representing Ms. Richins. I do have some questions for you today.
Okay.
We guessed
I wanna
that by you
talk
standing there to
about
ask
the
questions.
search of the home. You were the person that went and asked the judge to issue a warrant, correct?
Correct.
And the way that process works is you fill out an affidavit.
Ma'am, this is a motion to suppress. We all know how this works. We don't. What I don't need is a lesson. What I do need is for you to just cross-examine your witness on this motion to suppress. We know how it works. The judge signed the warrant. Can we just? We know.
Of a sworn affidavit saying all the facts that you believe support a search of a home. Is that right?
Correct.
And you specifically tell the judge what it is you would like to search, correct?
Correct.
I'm sorry. And then you also tell the
What
judge
they're searching
what you're
for.
looking for generally,
And
right?
where?
Correct.
To try to keep it narrow as you can, right?
Correct.
Specific.
And in this case,
Can't
before
have
you
broad
all
warrants.
showed up at the house and executed these warrants, at that point you had gotten 2 warrants, is that right? Signed by judges.
I believe so.
Okay. The first warrant you got maybe 2 days before that authorized a search for.
It wasn't 2 days before, it was a day
and any
before.
kind of mailing or tracking instruments that would indicate purchasing something, right?
I believe so.
And then the second warrant you got, and again before you executed, was asking to search the home and Ms. Richins' person for electronics such as phones, computers, things like that. Correct?
Yes, ma'am.
And boy, did they get electronics.
Neither of those warrants did you seek authority to search a vehicle. Is that right?
Not in those 2 that I remember.
Okay. As a matter of fact, you
Which is why they didn't search the vehicle. Where's the vehicle search, counsel?
went back later while you're in the middle of your search and asked a judge to issue a third warrant authorizing you to search vehicles. Is that right?
That sounds correct.
And do you remember what time you did that?
I do not.
Okay. And was that warrant issued?
I believe so, yes.
Okay. And did you go ask for that to be issued after you got back to the house, after you had already talked to Kouri with with Detective Maynard?
Yes, it was after that we left the stop.
And that's not uncommon
So at the
at
time
all.
that you got the phone out of Kouri's vehicle,
When law enforcement is doing their job well, it is not uncommon that during the course of a warrant or a stop or whatever, they will go, hey, we probably have grounds to maybe grab the thing. We might have an exception, but we're not in a hurry. So let's not worry about that. Let's just get another warrant and then do the things. And so that's exactly what they did. They got another warrant and then they did the things. So that's not uncommon that warrants will beget warrants no matter what time of day it was. When I did search warrant duty we had after hours search warrant lines where it would sometimes be all through the night talking about issuing search warrants and reviewing warrants before they went to a judge so that you don't wake a judge up at 2 a.m. with an insufficient warrant, because then they get real fucking cranky. So it doesn't surprise me, again, that you have warrants and then warrants can beget other warrants. This does not surprise me.
Vehicle, you did not have a warrant
That is
authorizing the
preferred.
search of any vehicle. Is that right?
I didn't get the phone out of the car.
Okay. We'll get to that in a minute. When you were at the car with Kouri, you did not have a warrant authorizing you to search a vehicle, correct?
No, ma'am.
That's right, ma'am.
And
That's
in
why we
fact,
didn't
you knew
search
you
the
needed another warrant because
vehicle.
later that day you went back and got another one, right? That authorized vehicles.
Objection, Your Honor. That needed another warrant is unclear as to why she needed another warrant.
He's like, that calls for legal conclusion.
I'm going to allow you to answer the question. I can weigh the testimony as needed. Do you need it or repeat it?
I do.
Okay, so you knew you needed a third warrant to be able to search vehicles and actually went back and got a third warrant, correct?
For the vehicles at the house, yes.
Correct. Okay.
Right.
All right, I want to talk about when you first arrived, where Ms. Richins was seated in the vehicle. You had an audio recorder on,
Yes, ma'am.
but not video?
I did not.
Okay. And the transcript the government has referred to, the state, I'm so sorry, that the state has referred to, is it in front of you? Yes?
It is, yes.
Okay, great. All right, so
She
can
was
we
drinking.
turn
The
to
is having water.
page,
Toesies are getting cold. I'm gonna have to turn my
here.
heater on. It's just that time of year.
All right, can we turn to page 7? Oh, wait a minute, I'm sorry.
Are you looking at exhibit? Is this exhibit 1?
Your Honor, motion to
Yes,
keep the
6.
readers on.
Sorry, I should have said that.
The
Thank you, Your Honor.
Lawnards.
Let me back up even further.
have
than
strong
that, just a
feelings.
minute.
Emily, you can't just say Lawnards when it's what you're thinking. I can though. but I can.
Okay, so let's go to page 3, where Kouri's asking you what's going on. And starting at line 7, what do you tell her the purpose of your search is?
It's to make sure that there's nothing there, there's nothing dangerous, and there's nothing dangerous for her and the kids.
And when you say nothing dangerous, you were talking about what?
Drugs.
Specifically,
Drugs.
what kind of drugs?
Deadly drugs.
I don't know if it says in the warrant or not, but in this instance,
The
I was
ones that
talking about
were
fentanyl.
like 5 times a lethal
So you're
dose in the
telling
victim's
her
system.
that you're checking to make sure there's no dangerous fentanyl in her house that could harm her or her children. Is that right?
Correct.
And in fact, you guys kind of had a conversation about how if there's just any little
Counsel, your client told them it was an overdose. It's reasonable for law enforcement to be like, well, if it's an overdose, there's probably more drugs somewhere. So we should go see.
bit of fentanyl, it can be super dangerous, right?
Yes, ma'am.
Okay.
Kouri was calling bullshit because
Then, if you could go to
she had journaled about it previously.
page 5. No, I'm sorry, not page 5. I think it's page 7. Sorry, page 7. Line 16.
The camera
And
work
you
does
ask
give the
her,
office vibes.
Do you
It's
have
a
a phone with you? Is that right?
it's a solo cam court
And this
day.
is when she's still sitting in the car, being detained, right? And then she answers, I have my phone, yeah. And what do you ask her?
I ask her, is it in your pocket?
And what does she say?
She says, we have phones. We have no, it's in my car.
It's in my car. Okay? So there's really no dispute that at the point she's sitting in that car, it was not on her person, correct?
Correct.
Okay.
And the defense again is working with
Then,
what they have.
If you go forward to
They have a client that was like, sure, let me help. There's not much they can do with that. So,
page 11 at the very top,
but they're going to ask.
you say to her, do you want to come with me and grab your phone real quick? Is that right?
Correct.
All right. Prior to that, did you ever give her her Miranda rights?
I did not.
Did you ever tell her that she had an option whether she cooperated with you or not?
I don't believe I did say anything like that.
Yeah, it's not our
What were you
job to
wearing that
inform
day?
you at this point.
I was wearing a blue shirt, like a polo, and a black jacket, and I usually had either gray or khaki pants.
Right. And on that blue shirt, there's an insignia for the Summit County Sheriff's Department. Is that right?
Correct, but it's covered by the jacket.
And the jacket identifies you as law
It
enforcement?
probably says police.
Did you tell her? She knows you're law enforcement, right?
She should, yes.
Because you guys had talked before.
We have, yes.
You had asked her to be interviewed, right?
Yes, ma'am.
And then you knew she had a lawyer
Correct.
because you had talked to her lawyer about arranging an interview with her.
Correct.
And you knew she had a lawyer at the time you were talking to her that day out on the street, right?
Correct.
And did you advise her she had a right to call that lawyer and get advice?
I did not.
Okay. All right. And then on the last page, page 12, I'm sorry, you guys walked to the car, is that right, together?
Correct.
Where were you standing when you guys walked to the car?
I don't remember.
Okay. And when you got to the car, where was the...
I always wait for law enforcement, and they don't because they're more patient than I am, but I always wait for law enforcement. Where were you standing when you walked to the car? On the ground? I was standing on the ground. And then we walked to the car. Ma'am, I don't understand your question. They don't. It's too snarky. But I always wait for the most literal answer to come out, as opposed to the, no, I know what you mean. I don't know exactly where I was standing.
phone?
I don't remember.
It wasn't on her. It was in the car.
Correct.
And you asked her to hand you the phone. Is that right?
Your Honor, again, this is recorded, or I guess it depends where.
The transcript says what it says. What's your question, Ms. Nestor?
You asked her to hand you the phone.
I would have to look. I can't remember.
The prosecution is like, the thing speaks for itself, and the defense is like,
Let's
we're going
look
through
at
this.
Page 11.
And the prosecution's like, we don't need to, though. Can we?
Where you say, do you want to take
we're
it
not
out of the case or
contesting what
not?
happened.
Right?
Correct.
This is what happened
And
in
then
order.
you take the phone from her. So you didn't even ask her. You just took it. Because it looks like you're not asking her. You just take it from her.
No, I asked if she wanted the case, and then she handed it towards me.
Okay.
Do you want to keep the
Did you tell her
case?
before that she
No.
didn't have to?
I did not.
Well, she did have
And
to.
when she handed you her phone,
Once she had it in her possession, they can just take it. Once it's on
you
Kouri's
then
person,
told her that
they can take
Detective
it.
Maynard would follow her back to the house. Is that right?
I'd have to look. I may have.
Look at the last page, page 12.
Correct. I did say he would follow you back.
Right. And he did follow her back, did he not?
I assume so. I wasn't there at that point.
She's like, I went to
You'd
Becky's.
gone to Becky's house?
I don't know what he
How
did.
did you arrive? Were you in a police car when you got there, or a sheriff's car?
I assume I was in my unmarked vehicle.
So
How'd you get there?
at
In
what
my
point did
car.
you give the phone back to Detective Maynard?
Would have been probably when we walked back towards his car, towards where he was standing.
You say probably. Do you remember?
I'd have to look at this to remember exactly when and what I said.
So if it doesn't say here, you don't remember?
Some things I do, yes.
Do you remember when you handed him the phone?
When I walked back to the car.
Okay. How long did it take for you to get back to the house?
I am not sure.
When you got back to the house, did you ever take the phone back from Detective Maynard?
At some point, I did.
Did he advise you that he had obtained the passcode from Ms. Richins?
I don't recall.
Do you know what you did with the phone when you got it back?
At some point, I would have taken it back and put it into evidence.
Okay, but you don't remember.
No, ma'am.
Okay. That's fair. I know it was a while ago. Just trying to get the difference between what you remember and what you don't, okay?
She's like, in my report, I would have taken it back and put it
so-
into evidence.
At some point, you said you had another conversation with Kouri where she helped you go to the safes in the house. Is that right?
Correct.
In fact, did you go out and ask her to come in and open the safes?
And
I
again,
believe I asked if she would provide
if Kouri had
either the
said
code or
no,
open the safes so that we didn't have to damage them.
they would have
And when you did that, did you advise her she had a right to
destructively
refuse?
opened them.
I did not.
Had she been Mirandized to that point?
She had not.
Doesn't
How
need
many,
to
that I
be.
know of.
how many police officers were on the scene? or
Again,
sheriff?
Kouri could have said, they said, hey, can you give us the codes to the safe? And Kouri could have said no. And they would have said, okay, well, we will either check with a judge or we will crack them. So if she had said no, they said, well, we'll get into them one way or another. If you'd like your safes to be preserved, then you can help us. If you don't want to help us, that's fine. But it's just easy way, hard way at that point because they have a warrant and it's just going downhill from there.
Sheriffs were on the scene while you guys were doing that search.
I'm not sure.
Okay. Help you with that.
Jen, this would have worked
Sorry,
too
just 1
because
minute,
the
Your Honor.
sisters, it could
Were
have
there
been a
more
little
than 10?
stickier.
I'm
but
not sure.
The victim's sister is in control of the and this is just a month after death, but the sister-in-law, Kouri's sister-in-law, the victim's sister, is in control of the estate and of the trust, and the home is in the trust. Whether or not they would have known the codes to the safe is different, but yes, they had numerous ways to tackle getting into the safe. So it wasn't going to be, the defense is asking, was she Mirandized when she gave you that information? No. Did she need to be? No. So, but the defense is doing their motions to suppress, so they're going to ask all those questions.
Were there more than 5?
More than likely.
Okay.
So
All right, so you asked her to open up the safes. You mentioned that while you were going from
she helped.
place to place in the house, before you went in the house,
I can't wait
where
to see
was she
the,
when you
if
asked
there's
her
ever
to
body
open up the
cam of this.
safes?
I'm curious.
I believe she
the
was
questions
in
she's asking.
her car or a car.
All right. And when you asked her to open up the safes, you guys went inside the house and you also went in the garage and the removed garage. There's kind of 2 garages, right?
Yes, ma'am.
Okay. You mentioned when Mr. Bloodworth was talking to you that she was asking you questions about what you had found. Is that right?
Correct.
Was she asking you if you had found any dangerous fentanyl that was a danger to her or her sons?
I believe she was asking that, yeah.
Okay. All right. Okay. At what point were you removed from this case?
I left
She redirected
a
the
little
word
while after
removed
I got
real
the
quick.
dog. So I'm not sure what date or anything that would be.
When
The
you
law nerds
first
have
got
questions
this
about the dog.
case, you're from
Name,
a
age,
small
breed.
town, is that right?
Correct.
And I'm not going to say it, but you knew the Richins family before all this happened, right?
1 second.
Objection, Your Honor. This is
Bloodworth
far
is like,
afield of the scope
excuse
of
me, Your Honor, WTF.
Mr.
A
Credibility.
little confused where we're going.
Give me just a little bit of leeway, and I think I'll show you. Just give me a couple more questions.
You got to give it a name, though. Is this a...
Credibility.
All right. I'll give you a...
You got to give it a
limited
name, though,
rating.
counsel.
So you knew the Richins family before you were investigating this case, is that right?
No, I don't think I knew any of these guys. There's a lot of Richins that live there, but I don't think these guys specifically.
You did not?
Not that I recall dealing with them.
Okay, thanks. That's all I have on that, Your Honor.
I like the defense questioning is like, but don't we all know each other? She's like, I don't know what you're on
Just
about.
a moment. I think I'm almost finished.
There's a lot of people with that last name.
Oh. After you guys did the search on the house, you heard from the defendant's lawyer, did you not?
I don't recall.
May I approach,
Objection,
Your Honor?
Again, anything that happened post-search is irrelevant to the pending motion.
Your Honor, this is because we're going to have a little bit later today a challenge to Detective O'Driscoll's interview of Ms. Richins when she was uncounseled. And this is the individual that got the assertion from the lawyer. And so I'm just laying a foundation for when I do O'Driscoll later.
Proffer the assertion.
I do. I have it.
What is it, though? Help me understand.
Oh, that her lawyer asserted Sixth Amendment rights and told him not to speak to her client again.
We'll allow them to lay this foundation.
Your Honor, we're going to have to put a lot of objections
Bloodworth's like,
into the record.
where would you like me to start with my objections, Your Honor?
I'm a little bit blind here, so if you
Sure.
can just provide a little context.
So, as Ms. Nestor just said, she's making a Sixth Amendment challenge to a later interview. That later interview was conducted on April the 14th, 2022. By April the 14th, 2022, or on April the 14th, 2022, judicial proceedings had not begun. Thus, the Sixth Amendment had not attached. Therefore, any discussion about a Sixth Amendment violation is irrelevant. The Sixth Amendment right to counsel had not yet attached.
I mean, that's your
Okay.
argument. But they're making
still
a
have to
different argument.
Well, I don't know what Detective O'Driscoll is going to say.
Right? Just let her mark
This
it.
sounds like 2 or 3 questions. Am I right?
Yeah, just let her mark it.
I'm going to allow some limited latitude here. We'll see if it matters or not later.
Right.
Okay, Your Honor.
It's a motion to suppress.
What I understand Ms. Nestor is going to ask about is a communication or two sent to her by Ms. Richins' prior counsel. Correct, Ms. Nestor?
Yes, sir.
And after that, are we done?
Yes.
This seems reasonable, even if ultimately irrelevant.
I am trying to comply with your request that we lay foundations through the
He's like, we can
appropriate
just,
witnesses.
there's no jury.
So that's, I mean, this
He's
would have
like,
been
I'm
part
the
of the case
finder of
file at the
facts.
time she left and O'Driscoll took
Fine.
over.
I guess what I'm saying is, why don't we just let these 2 questions come in, and then we'll see if we need to ever address this again.
Fair, Your Honor.
But objection. Fair, but I
The state
object.
would not object to the admission of these emails. The only thing the state would say is there is also metadata that attaches to the emails that, to the extent the metadata becomes relevant, it's in discovery, of course. That
And if we need to get into that, we
consider
can.
that
Is there any reason to suspect that the header of the email regarding to, from, and time and date is incorrect?
No, Your Honor,
Okay.
that's not.
All right. Can I just see him, Ms. Nestor?
The court's like, we're just going to allow it. And again, they're going back and forth about whether or not Kouri Richins, and this is going to come in with later testimony we've heard, whether or not Kouri Richins was interviewed in violation of her Sixth Amendment rights because a lawyer emailed police and was like, do not talk to my client. So Bloodworth is like, she's not been arrested. They're investigating the suspicious death of her husband. She is not there. There's been no charges. Nothing has happened. So the prosecution's argument is, hey, there's no Sixth Amendment right attached yet. There's no proceedings. The defense is like, no, she had a lawyer. Her lawyer told you, don't talk to my client. Y'all are still up here talking to my client. You know what it seems that the client didn't say? What the client didn't seem to say is, excuse me, where's my lawyer? Seemed that was not happening. So this is a later argument, but the email was received by this officer. We're in a motion to suppress. The judge is the finder of fact here. So the judge is allowed to say, you know what, I'll hear it. And if it's not relevant, then I'll just disregard it, because judges and lawyers can, multiple things can be true in their head, and they can hear it and say, I'm not considering this for this purpose. So it doesn't matter that I've heard it because I can parse those things out. That's literally the job, that you parse things out and go, this isn't the evidence I'm considering that. So that's why the judge is like, it's fine. Can we just make this fast? It's fine. Let's just go. This is not in front of a jury. And because the judge is the trier of fact, the rules of evidence are significantly less stringent at a evidentiary hearing like this.
Thank you.
So I think for the court, considering more versus considering less saves everybody time, because bringing this witness
just a
back up for
minute,
one thing would be dumb and a waste of
Detective
time.
Woody, Deputy Woody, are you still detective? I want to call you the right title.
Just deputy.
Deputy. Will you take a minute to review that and see if those look familiar to you? And I'll give you just a minute, and then I'll ask you
But
about them.
I wouldn't be surprised if we ended up in a circumstance where the detectives are like, hey, we'd like to talk to you about what happened with your husband. And Kouri's like, I wanted to know what they were going to say, so I'm going to go and figure out what they had to say. And now Kouri's like,
In just
fuck.
a moment, my apologies.
Well, yeah.
Well, damn it. They wanted to know what I had to say, not the other way around. Right. Right. I see a number of you asking, was she demoted? No. Not that we have any indication of. However, a lot of departments will rotate your assignment. She's no longer in a detective assignment. She is now a canine officer. So she is a canine deputy instead of a detective. She was previously in a detective assignment. So not all departments go by rank, where if you move up rank, then that is an issue. If you move back down rank, it indicates that something happened. A lot of departments and smaller departments will rotate through, and detective is an assignment because you are assigned to the detective bureau. And then if you're reassigned to traffic, then you are a deputy. If you're reassigned to canine, then you're a canine deputy. And so it's a rotating role versus an indication of rank that indicates that you've been somehow promoted or demoted. And it seems to be when she said, I rotated out to canine, she's a canine deputy versus in the detective unit. So that's not uncommon. And happens in a lot of departments. And a lot of people like going back to like patrol. They're like, ugh, being a detective is a lot of paperwork. So they rotate through.
Just let me know when you're ready. I don't want to rush you.
Okay.
Oh, I was talking to her. Sorry, not you.
That's okay. If you would hand this to
The
Mr.
judge is like,
Bloodworth for me,
that's fine. I'm good. So yes, it's a job assignment, not a rank. Trust me, if she had gotten in trouble, the defense would ask her about it.
I've scanned through it.
Okay.
So I can,
Does it ring a bell? Do you vaguely remember it?
yeah.
Okay. And as I understand it, that is an email and letters that were forwarded to you as the case investigator, informing you that the lawyer did not want Ms. Richins spoken to again outside the presence of counsel. Is that right?
That's what it
Your
looks
Honor,
like.
objection. That mischaracterizes the emails.
The email says what it says. Can we just have some foundation as to whether or not that email ever made its way through this witness to Detective O'Driscoll?
My next question.
Okay, let's
Thanks,
just get
Your
that
Honor.
out, and then we can move on.
When you got this email and these letters, what did you do with them?
The judge is like, race up so loquitur.
A while ago, I don't remember. I probably showed my boss, or I would assume.
Who was your boss?
Back then, it would have been
We're talking April
probably
2022.
Detective Davis, maybe?
Davis. And is it your practice that when you get documents that are related to a case that you take them home or throw them away? What do you do with them?
Generally, they go into a case file.
And did you have a case file on Ms. Richins?
There was a case file, yes.
Physical file
Yes.
that was yours as the chief investigator?
Yes, ma'am.
And did you put those documents in there?
I believe I did, but I can't answer for sure.
And when you left the case, did you provide all of your materials to Detective O'Driscoll?
I did.
Okay. Really quickly to go, that's all I have on that, Your Honor. And we do offer 152.
152 has been offered.
To go back to the warrant, when you came up on Kouri, when she was in Detective Maynard's car, did you ever serve a copy of the warrant on her so she could see that you had a search warrant?
Not at the car, no.
Did you ever give her a copy of the warrant?
We did, yes.
When?
I'm not sure. I know she had a copy at the house, but I don't know when.
Okay.
Okay.
And is there some reason that you quit working on this case other than you're wanting to go train your dog?
No, I didn't have enough time for the dog, pretty much.
Ma'am, the dog was preferable. You just wanted to go train your dog? Yes. Ma'am, no one faults you for being like, let me just get to the canine unit. You just wanted to go train your dog? Mm-hmm. Apps. 10-10.
Respect that.
I like the counsel's like, I respect that. Yes.
I just need to get that back from you when you're done, Mr. Bloodworth, to add it to the...
Detective Woody, dogs are better than people, ma'am.
Thank you.
Dogs.
Let Ms. Nestor check with co-counsel, and then we'll...
Oh, counsel.
Your Honor, we tender the witness. Thank you.
Mr. Bloodworth, anything further?
No, Your Honor, thank you.
Thanks,
Okay.
Bloodworth.
May we release this witness, counsel?
Yes, sir.
Okay, you're free to go. Thank you, sir.
Bye, Detective Woody. I'm sure
Bloodworth.
Corey's pissed because Corey and
Does
Detective
this
Woody had been
include the state's
talking. Detective Woody was doing the initial investigation into Eric Richins' death. So I'm sure that Detective Woody and Corey had pleasant conversations, and Detective Woody was keeping her in the loop with what they wanted to keep her in the loop with as they were developing her as a potential suspect. And I'm sure Corey thought that that relationship was great, that this detective was fully on her side, and absolutely, once she ended up getting arrested, was turning around going, wait, what the fuck? Yeah. Mm-hmm. Yep. I'm sure she's not thrilled in hindsight.
Initial case, or do you have more witnesses?
No, Your Honor, the state has 2 more witnesses.
Rough estimate of how much time you have with the first of those people?
15 minutes.
Why don't we call that person?
Okay.
Yeah.
Not me
Your Honor, the
today.
state calls lead crime scene investigator Chelsea Gibson.
Okay.
Yes. Jury selection starts at the end of April. Testimony should begin at the beginning of May. So lead crime scene investigator. I'm going to zoom while the crime scene investigator comes up. We're going to continue to zoom. Mr. Bloodworth's like,
Is Chelsea in the Galabi? Be calling somebody else next, or we may be taking...
oh, hold on. What happened?
You may be calling somebody else next, or we may be taking a lunch break. Zag,
Oh.
is Chelsea in the Galabi?
No, there's a miscommunication. She's going.
That's okay.
Yeah,
All right.
Your Honor,
That's fine.
when we thought we were
Yeah.
going to break for lunch, we sent her back to her office.
Would you like to take a break now? Would that be better for everybody? We got to take one eventually.
Your Honor, I think we do it. I should be here in a minute.
Okay, sounds good.
The office can't be far.
Ms. Nestor, Ms. Lewis, you okay with that?
Yes, sir.
Okay.
So they are waiting on lead crime scene investigator Gibson. They thought they were going to take a lunch break, then they didn't.
He didn't eat, yeah. We don't feed him.
I'm just convinced that you're running the show.
Did they just say we don't feed him about their co-counsel? Counsel. He doesn't need lunch. We don't feed him. Lord. They're like, he's the one that has to sit and explain everything to Corey. He takes lunch back and lock up explaining everything to her. All right, we're going to zoom as they get to I feel counsel being like, wait, these are my far glasses. I need the close glasses for the computer.
Mia will get you sworn in.
All
Thank
right.
you.
We are now at lead crime scene investigator Gibson.
Raise your right hand. Do you solemnly swear the testimony you're about to give in the matter before the court to be the truth, the whole truth, and nothing
This
but
is
the truth,
the
subject to the pains and
prosecution's
penalties
third
of
witness in the
perjury?
motion to suppress,
Please have a seat.
or motions to suppress. There are numerous. Oh, Seamus, not at all. All questions are welcome.
Mr. Bloodworth, please proceed.
Thank
No.
you, Your Honor. Ms.
Trial
Gibson,
starts in
are
May.
you the lead crime scene investigator for Summit County Sheriff's Office?
Yes.
And
Motions
have
to
you
suppress.
been a crime scene investigator with the office since, at minimum, April the 13th, 2022? As a crime scene investigator for the sheriff's office, do your duties include phone extractions?
Yes, they do.
What computer forensic tool does the sheriff's office use for phone?
Probably Celebrate.
Celebrate?
What training and experience do you have in using
Do you know
Celebrate?
Mr. Whiffen?
I'm certified in downloading and analyzing the phones.
And approximately how many phones have you downloaded?
50.
Are you familiar with the defendant's phone taken into evidence on April the 13th, 2022?
Yes.
How are you familiar with that phone?
It was booked into evidence.
And were you the crime scene investigator that took it into evidence or runs that evidence room or whatever?
Correct.
Or whatever. Or whatever.
Was that phone an white iPhone Model 12 with an IMEI number ending in 2558?
Yes, it was.
Did there come a time
I like Bloodworth's
when
manner of
the
questioning, too.
Celebrate forensic
just-
tool that the sheriff's office used had the capability to extract data from an iPhone Model 12 without using a password?
Yes.
At what point in time did the sheriff's office have that ability?
December of 22.
Did there come a time when the sheriff's office or a partner law enforcement agency extracted the data from that iPhone Model 12 IMEI 2558 without using a passcode?
Oh, smart.
When did that occur?
September of 24.
And did that extraction occur pursuant to a warrant issued on September the 27th, 2024?
Yes.
Right.
Thank you. No further questions.
Right.
Ms.
So
Master.
they did it. It sounds like they probably did it twice. The first time they may have done it with the passcode Kouri provided. And then as a, hey, if this is going to be a headache and if there's going to be fuss over how and when Kouri provided her passcode, can you guys go ahead and they got a second warrant for it. Can you guys go ahead and extract the phone for a forensic copy with Celebrate without the passcode? Meaning if the passcode is an issue and the court was ever to say, okay, well, we'll just suppress anything from the passcoded extraction, they can say, fine, go ahead and suppress that copy. We have another copy and we have done another search and we have done it without the passcode. So if it is an issue, it doesn't really stop it being an issue, or it doesn't really make it a massive issue for the case because they're like, right, we can just go back and do it again. And they got a warrant in December 2024 to go back and do it again and went back and did it again. So, and that was not actually that long ago, probably after these motions were filed or shortly thereafter these motions were filed.
Sure.
So, okay, we've got 2 extractions.
Thank you, Your Honor. Good afternoon.
Good afternoon.
My name's Kathy Nestor. I'm one of the attorneys representing Ms. Richins. I do have a couple of questions for you.
So we're on cross?
Do you work in the Regional Computer Forensics Lab?
No.
So you actually work for Summit County Sheriff?
Correct.
And I heard Mr. Bloodworth ask you, are you the one who took this phone into evidence? Can you expound on that for me? What was your connection? What did you do with this phone?
So when phones are brought to the sheriff's office, I manage the evidence room.
Keep going. I'm sorry. I just need to grab a document.
You're good.
Keep going.
From what I recall, Detective Woody at the time booked it into evidence, placed it into a locker, and then once it's in the locker, then I take custody of it and put it into evidence storage.
And you, every time you touch a piece of evidence, you guys keep a log. It's called a chain of custody form. Is that right?
Correct.
Your Honor, may I approach?
Yes.
Okay. I see you guys talking about notebooks. I am using the Remarkable 2 today. I like it.
And we would mark this number.
I like the Remarkable Pro Fine. This one's a little bit smaller and a little bit lighter weight.
What is it?
And I don't really need it color coded.
Okay, give us one moment.
Yes, they have procedures. I know. And they're just like, I did this. And it sounds like they also have a regional forensics lab, which is probably why she's only extracted 50 phones. I would imagine they extract them and send them off to regional forensics.
A document that's
And each
marked
county's not
as
doing
a
it.
chain of custody.
Not all
form, I
counties
guess.
have the money
Yes.
to do
Can you
that.
look at that and tell me if it looks familiar to you?
Yes, it does.
It makes sense
Is
to do
that
them on a
your
regional
handwriting
level.
on it?
Yes, it is.
And can you explain what this document is?
It is releasing the phone from me to Detective Crowley to RCFL, back and forth all the way to the RCFL to get the download from the
regional.
phone, and then chain of custody of that phone coming back to the evidence room.
Let's look at the dates on this. I think you testified earlier that the soonest you were able to download off of phones, the soonest the sheriffs had the software capability to basically crack a phone and download it without a passcode was December of 2022. Is that what you testified?
Correct.
Okay, and the document
Oh,
that you
I
have
thought
in
she
front
said
of
24,
you.
December
What is the
2022.
date that you turned
heard that
over the
wrong.
phone to the RCFL?
5/4 of 22.
May of 22.
Correct.
All right. And at the bottom, there's a comment. What did you write on the comment?
RCFL for phone dumps.
So tell me what that means.
It means it was released to RCFL to obtain a phone download.
For them
And
to download the
RCFL,
phone.
just to clarify for the record, it's the
Regional Computer
Regional
Forensics
Computer
Laboratory?
Forensics Laboratory that often does do phone dumps, right?
Correct.
Okay. So you gave it to them in May of 22. When did they return it to you? Or to, when did it get returned, I guess? Who's Crowley? Do you know who Crowley is?
Oh.
Detective Crowley. He was a detective for some.
When did you check the phone back into custody from the Regional Forensics Crime Lab? Just when?
County Sheriff's Office at the.
Yeah, they mean 2022. So, okay, it wasn't me. Thank you, Chad. Previously, she had said 2024. They mean 2022.
Time.
Okay, so when did the RCFL send the phone back? In other words, we're done with it. Here it is. It's back.
Yeah, no
to you.
exposition. Just,
July of 22.
Again, before you had the capability to crack it without a passcode, right?
Yes.
And when you got the passcode, were you advised? I mean,
RCFL might have had the capacity to break it without the passcode.
when you got the phone, when you got the phone, were you advised they had a passcode for it?
When I received the phone, I believe there was a passcode on the property
sheet
tag of the device.
Right. So you already, and you provided that to RCFL, right?
It was provided, yes.
Okay. Okay. Were you on the scene of the search of this home on April the 12th, the 13th of 2022?
Yes, I was.
Did you ever have the phone in your hands that day?
No, I do not believe so.
Were you aware of anyone looking in the phone that day when you all were at the house, at the Richins home?
Not that I'm aware of.
Did you prepare the what's it called? The property seizure form from the search that day, or was that not your job?
I'd have to look at the handwriting to verify if it was me or my coworker at the time.
Okay. May I approach, Your Honor?
Yep.
Okay. I'm gonna zoom.
Exhibit 154.
There we go.
Thank you.
It doesn't look like that's your handwriting
No.
from what I just looked at. Did you prepare that form?
I did not.
Okay. Did you ever
She's like,
see it
I just
that
answered
day?
my own question, but I'll
All right,
ask it
Can you look
anyway.
through that form? As part of your duties on the scene that day was to kind of make sure that all the evidence that was being gathered was properly accounted for?
Yes.
That was part of your responsibility?
Correct.
Can you look on that form and tell me if you see anywhere that a phone was seized from the home?
It wasn't
There's not
seized
on
from the
this one.
home.
That's
Technically, it was seized from the defendant at the traffic stop, not at the home. They had it at the home. That's not where it was seized. So I wouldn't be surprised if the forms note that it was seized prior to being at the house because it wasn't in the house. So I'm going to zoom until they talk again. All right, there we go.
Thank you.
I'm going to hand you another form that is titled Evidence from Search.
Mary Lou Crafts, that is why they put phones either in a
Form that
Faraday
says
bag,
Evidence from Search?
Yes.
It
Or-
looks like an Excel spreadsheet, something like an
airplane mode, or
Excel.
turn them off.
Yes.
Did you prepare that?
I did.
You did?
I did.
Okay.
They try to prevent them from getting
On
wiped.
that document, the very last,
And most labs don't have any cell service coming in, so they can't be wiped. It's generally one of the things they do. If they don't put them in a Faraday bag, they put them into airplane mode.
entry refers to an iPhone.
Yes.
All the other documents, or most of them, not documents, things that were seized, appear to be linked on your spreadsheet to where they were found. Is that right?
Correct.
We love a
Where does it
spreadsheet.
indicate the phone was found?
I did not have a location of the phone on this document.
So is there any other thing on that document that you don't know where it was found other than the phone? Or is that the only item?
It looks like there's an item that's titled pills and one titled scene photos.
Okay.
Pills.
The pills one, does it say how many pills were seized?
Not on this spreadsheet, no.
Okay. All right, I think that's all I have, Your Honor.
Mr. Bloodworth.
Can we,
Yeah.
can the witness keep that? I'm going to start.
Yeah, I just want to show this to Alex for 1 second, make
Sure.
sure there's not one more question.
Okay.
Yeah.
Bloodworth is just like blinking.
This one.
I'm going to zoom until we get to whatever document they're asking about. Are we done?
Let's please pick up where the defense counsel left off. 155, I think it's on there. That's the spreadsheet that
And
you
we
said
are
you prepared.
on
Why did you prepare that spreadsheet?
Redirect with Mr. Bloodworth.
There's a lot of items regarding this case, and there's also several different case numbers regarding the sheet, so it made it a little bit simpler to combine the several cases onto a spreadsheet at that time.
Was it simply a tool for you to use?
Correct.
It's like she didn't want to miss anything and wanted to make sure she had everything organized. So because there were multiple case numbers, which isn't surprising because it was a suspicious death investigation before it became a prosecution, and there was like a year period in there before Kouri was arrested, it doesn't surprise me that she was like, no, I wanted to make sure we had everything accounted for. And if there are multiple case numbers, we had them all under an umbrella. So I made a spreadsheet to make sure we didn't miss anything. Wow. We love to see it. Look at that. It's like, it's all right there. And the defense has it and the prosecution has it and everybody has it all combined in one place. It's her notes so that everybody's on the same page. It's the little things sometimes.
Please return to Exhibit 154, the property seizure form. You testified that there is no cell phone identified on that property seizure form. Why is that?
And sorry, there is one on here.
There is one on there.
Yes.
But is this the property seizure form for the Willow Court address, right?
Yes.
And it's not the property seizure form for any property that was seized off of the Willow Court address, is that right?
Sorry, repeat the question.
It's not a form that documents property that was seized off of the Willow Court address, is that correct?
Correct.
So if a phone was seized off of the Willow Court address,
would it be on that
you would
form?
not expect to see it on that property sheet.
Correct.
Let's return, please, to the discussion regarding the RCFL. You recall looking at the chain of custody form, which transferred custody of the phone from the sheriff's office to the RCFL and back to the sheriff's office, right?
Yes.
Do you know whether or not the RCFL extracted that phone?
Yes, they did.
Did there come a time when the RCFL transferred, I don't know, tell me if it's on a hard drive or however they transfer extractions back to you, the Summit County Sheriff's Office.
Yes, on a hard drive.
Okay, so there came a time when the RCFL transferred the extraction to the Summit County Sheriff's Office, and the Summit County Sheriff's Office has a copy on a hard drive of that extraction.
Correct.
Were you able to access, was the Summit County Sheriff's Office, as far as you know, able to access that extraction?
Not for a while.
Okay. And why not for a while?
And we did not have the capabilities at the time to look at the download.
Okay. Do you know if the Summit County Sheriff's Office ever reviewed that extraction?
Sometime after December of 22.
Okay.
That's a good clarification.
If at all.
That's a good clarification. So the clarification is that Summit County Sheriffs did not have the capacity with Celebrate or whatever version they had of Celebrate to get into Kouri Richins' phone without a passcode until December 2022. They had sent it to the external regional lab, and the external regional lab extracted the phone before December 2022 and sent it back to the sheriffs. But the sheriffs couldn't get into the download until after December. So they did not access any forensic downloads from the phone until after they had the capability to get into the phone without a passcode. So it seems that the passcode for the phone provided by the defendant was not used. So whether or not the passcode is determined by the court to be a problem or not, with everything we've seen, probably not. It is pretty much irrelevant because they didn't access any phone extraction until after December 2022. And remember, Kouri Richins was not arrested until into May 2023. So, you know.
Can I follow up on that? That was just newly brought in, just very briefly about the extraction.
Yes.
So I want to make sure I understand. So we looked at the fact that you sent the phone to the RCFL
Recross.
in May of 22, right?
Correct.
And they sent it back to y'all saying we're done with it in July of 2022.
Yes.
And then they sent you what they got off of it on a hard drive.
Yes.
And it just took you a while at the sheriff's department to have the software to open their hard drive, right?
Yes.
And have you ever seen, let me back that up. You never went back and got a second hard drive from the RCFL. You just ultimately were able to open the one that they gave you back in July of 22.
Correct.
That's all I have. Thank you.
And then they got another warrant, it sounds like, to search it later. For those in the chat asking about
we
the
release this
kids,
witness?
Colleen asked,
Yes, sure.
and others have asked, they are with the decedent's family. I know, it's so linear. It's
Do you
been
want those copies back?
linear.
Here's the one that's marked, Your Honor. I might swap it. I got the one that was marked.
54, 55,
It's
what
just-
do you have? 53. Yes, thank you.
We love it, just moving right along.
Over here are the unmarked copies of things.
Yeah, we're not zooming the judge. I know, sometimes we do.
Okay, Mr. Bloodworth, who's next?
Mr. Bloodworth.
In the order.
Your Honor, Detective O'Driscoll.
He might take a little while, is that correct?
He might.
Okay, why don't we take a reasonable lunch break? Ms. Nestor, tell me, what's reasonable?
An hour, Your Honor?
All right, why don't we come back? We'll be ready to go at 2 p.m. Court's in recess until that time. Thank you.
All
Folks,
right.
we are back on the record.
Hey,
The
Court
WebEx.
TV. Court TV just is like, lunch break, we don't know her. Zoom. So they have gone to lunch. They are back from lunch. We are zooming because this court, for whatever reason, is not a fan of the streaming. So all of these hearings in Kouri Richins get uploaded later. So we are going to continue on with the next witness. At some point, we will be getting into the walk the dog letter. I will link below the the breakdown of where I covered the walk the dog letter. If you have not yet experienced the walk the dog letter, in this case, you're gonna need to do that at some point.
This audio feed is unmuted.
It's
Mr. Bloodworth,
something.
the state's next witness.
Thank you, Your Honor. Your Honor, the state calls Detective Jeff O'Driscoll.
We'll get Detective O'Driscoll sworn in.
Do you solemnly swear the testimony you're about to give in the matter before the court to be the truth, the whole truth, and nothing but the truth, subject to the pains and penalties of perjury?
Mr. Bloodworth's like, okay. He's easy to follow. Snarky in writing, but easy
Detective
to follow.
O'Driscoll,
It's
I want
just-
to turn your attention to and discuss your interaction with the defendant on April the 14th, 2023. Do you recall that day?
Yes.
Great, we know
At that
why we're
point
here.
in time, what was your relationship with this case?
I had just been assigned as the lead investigator on the case. I was not familiar with all the details of the case. I was trying to get a fresh perspective and pretty much starting from scratch.
And as part of your start from scratch, did you want to introduce yourself to the defendant?
Yes, I wanted her to know that there had been a change, not only in the assignment of the lead investigator on her case, but
I'm sorry, sir. We
there
didn't
had been some.
We didn't mean to close caption over your beard. Apologies, chat. I know. Sorry, guys. We're deepest and sincerest apologies. We can't block the beard. I know.
Supervisory changes to the investigations division as well.
And when you say her case, you mean the case at that point in time investigating the death of Eric Richins?
Correct.
What was the change to not only you as the lead investigator, but you said, I think, the supervision of the division?
There was a new sergeant over the detectives, the investigation division, Sergeant Hoffmeyer.
So we were going to tell Kouri,
So
hey,
I take it you
we're handling your
determined to
husband's
then
death investigation.
Personally call on the defendant on April the 14th, 2023.
Correct.
And why personally instead of over the telephone?
It had been a year since Eric's death. I felt it was more professional considering the loss that she had gone through in the family, and felt that it was more appropriate to show up in person to speak with her and to introduce myself than over the phone.
Okay. There came a time then when you appeared on the doorstep of the Willow Court home where she was then residing. Is that correct?
Correct.
And thus began your interaction with her on that day, right?
Yes.
Did you
So we're now in
record that interaction
2023?
with her?
Yes, I did.
A year.
How did you record it?
We're a year after the search warrants were served. We are in April 2023, after the March 2nd, 2022 death of the decedent victim, in this case, Eric Richins, leading up to her ultimately being charged in May of 2023.
I had a audio recorder running, and then later I activated a body cam that I had with me.
Okay. Let's talk about the body camera. When did you activate it?
After we were invited into the home and asked to sit down.
And did you activate it roughly contemporaneously with the point on the body cam, or the point on the recording where you say, "Do you mind if I record this interview?" or something to that effect?
Correct.
Can you please describe
And Kouri, I imagine, and this is me speculating, I imagine when they came and said, hey, we'd like to give you an update on the investigation into your husband's death, Kouri, much like Alec Murdaugh, went, yes, please tell me everything. And they're like, this interview is being recorded. At that point, she should have been like, interview? What interview? I thought you were going to tell me information. Yeah, ma'am, they're also gonna ask you some questions.
body camera, not only the how the body camera itself looks, but where it was sitting.
She's like, but they said they were just going to tell me.
Rather to the defendant.
My chair is pissing me
Yes,
off.
I wasn't dressed in a law enforcement uniform, and so I didn't have a mount that's typically available to officers to mount their camera to their body. I just had it loose. It's a small square black body cam that's similar to those
I'm not
worn
putting a
by
GoPro on
patrol
my head.
officers at that time. And when I activated it, I sat it on the armrest of the couch between myself and Miss Richins.
Was it in Ms. Richins' plain view the entire time it was active?
Yes.
Does the body camera itself make any noise or light?
Yes.
What noise or light does it make?
It beeps and vibrates every few minutes, and there's a red flashing light that also indicates that it's recording.
And would Miss
Which we've also seen in
Richins,
Murdaugh.
the defendant, have been able to see from the location of the body camera vis-a-vis her, the blinking red light, and
the beeping?
Hear the vibration and beeping?
Yes.
You mentioned it was similar to body cameras that officers on patrol wore at the time. Was it similar to the body cameras that the officers on patrol were wearing while they interacted with the defendant in the early morning hours of March the 4th, 2022?
Yes, at least some of them were wearing the same body camera.
Have you reviewed both the audio recording and the body camera recording that you made that day?
Yes.
Are those recordings true and accurate?
Yes.
He's just laying foundation. Hey, wait! Counsel also is using a remarkable look. At some point, there will be a remarkable sponsor. I'm going to keep working on it, chat, just because I want to get you guys a discount also. I love it. But the way I would have lived when I was in court for this damn thing. Counsel twinning. Twinsies. I love it. Us and the Remarkable Twos. Here for it. Here for it. Not surprised. So for all of you asking, what is it? It's an e-writer. So that is the defense counsel also using their Remarkable, the Remarkable 2. Ian, you would love one. Ian's like, I want one. You would love one. You would love one. They are great. And as long as you have this one, all of your notes are just in one spot. I love it. So, love it. Sorry, squirrel. I got distracted.
Your Honor, the body camera recording that we're discussing is Exhibit 10.
Yes, he just laid the foundation for the recording.
Transcript
and the
is
transcript.
Exhibit 11.
Got it.
Yes, there were lots of options. I like the feel of this better than writing on like an iPad. The battery also lasts a lot longer than like an iPad.
Did there come a time when you were on the front
I'm just
stoop of her,
like
the defendant's home, that she invited you in?
Hey,
Yes.
And is that accurately reflected in the recording?
Mr.
Yes.
Bloodworth. I mean this with all due respect because we only tease those that we are fond of. Do you also need to be invited in the way that counsel need to be invited in? The chat really would like to know. So that's just a little bit of a question. So Kouri invited detective in to have a conversation. This is all getting to the fact that Kouri didn't say, why the fuck are you here? Call my lawyer. Because that doesn't seem how this went. So, and the sock snatcher said, if EDB secured a discount, I would finally buy one. I'm working on it. I have asked.
Did you then, upon her invitation, enter the home?
We just want to know.
Yes.
Can you describe how you entered the home, how the home was laid out, and where you and Sergeant Hoffmeyer was with you?
Yes, correct. He was.
Where you, Sergeant Hoffmeyer, the defendant, and ultimately the defendant's mother, Lisa Darden, were sitting?
Yes. So the front door of the home opens into a short foyer. Directly in front of the door, through the foyer, is the main living area of the home. There were couches and love seats in the family room. Miss Richins sat on one end of the couch. I sat on the other end, and Sergeant Hoffmeyer sat in a separate piece of furniture near us. When Miss Darden entered, that Lisa, the defendant's mother, she seated herself on a entertainment center.
So defendant's mom was there
across
also?
from the couch on one wall of the
Defendant's
living room.
mom didn't say, get the fuck out and I'll call a lawyer? Nobody said, GFO, let's call a lawyer. So defendant
What was
and her
your
mom are
observation
present.
of the defendant's mood throughout the conversation?
She seemed very cheery, very open, happy to be
Did she ask-
talking with us, happy to have the opportunity to talk to.
Did she ask for a hug? Because I'm kind of traumatized a little bit after watching the body cam in the Sarah Boone case. I have questions.
Investigators. She was outgoing.
At any time throughout your interaction with her on that day, did you observe her cry or become, did you observe tears fall from her eyes?
I didn't see tears, no.
The chat knows the questions as they're coming.
I want to turn your attention to, in the binder before you, tab 12.
Look, isn't it easy? Can we all just go to tab 12 together and then everybody in court can just go to tab 12 together? It's
Okay.
just a lovely thing.
Are you familiar with the emails at tab 12?
Yes.
What are they?
They are emails that Miss Richins sent myself and Sergeant Hoffmeyer a few days after we spoke to her in her home.
Do those emails follow up on the conversation and interaction you had with
She's
her on April the
emailing y'all?
14th at the home where she resided?
She's emailing y'all?
Yes, she was providing us additional information, follow-ups to the things that we had spoken about in her home. I'm sorry. Yes, that's correct.
And are they true and accurate depictions of those emails? You don't see them altered at all?
No, not as far as I can tell.
I asked you two questions, which was sloppy form. Are they true and accurate depictions?
Yes,
Were they altered at all?
it does not appear so.
Thank you. No
he's
further
like,
questions.
No one has objected to compound but me and my soul. The compound question hurt me. Let me fix that, counsel. I cannot let that compound question stand. I love it.
May it please the court. Good afternoon, Detective. We've met before, but Kathy Nestor again on
Yes.
behalf of Ms. Richins.
And to cross
All right, so I want to talk to you
on the
about
defense motions to suppress.
your deciding to go visit Ms. Richins.
We were feeling like a chat.
And you said that you had just been appointed, or not appointed, but assigned to the case, right?
Correct.
How long before?
Chitty chitty chat chat.
I'm not sure. Less than a month, I think.
I forgot to feed my Snorlax.
And when you were assigned to the case, there was a case file, wasn't there?
Yes, there were different locations that information about the case were stored or recorded.
All right. And you've been a law enforcement officer for some time. I'm certain you didn't go to her house unprepared to interview the primary suspect of a murder, right?
No, not entirely unprepared, but again, the intent to go to the house was not solely to get an interview. It was mainly to introduce ourselves and the change that had happened with the Eric Richins death investigation.
How long would that have taken?
Because they had been in contact with her off and on.
I'm sorry, how long would what have taken?
An introduction.
Not long.
Okay, how long were you there?
3 hours.
Right. Okay, so before you went to her house, isn't it
That's a
true
little
that
more
the
than
day
just an
before
introduction.
You went to her house. You had applied for an affidavit for a search warrant of her phone and a computer.
I'm not 100% positive on dates.
Your Honor, can I approach?
Yep.
He's like, yeah, I am going to need to see what date it says on the thing, and the thing that it says on the thing is the thing. Because I don't know. She's showing that to counsel. Oh, chat, don't worry. Next witness.
This is
And counsel are talking about what is going to be shown to the officer.
The affidavit was on the... May I approach, Your Honor?
Yes, thank you.
Handing you a warrant. And Your Honor, if we could just mark this really quick as 150.
Well,
Yeah,
Your Honor,
I-
that's Exhibit 9.
I agree with you, Chad, that the reason it probably lasted 3 hours is because Kouri wanted to
Yeah,
talk
I
to
can use
them,
this if it's in
and they're
here.
like, well, if you want to chat, we're here all day. We're not.
Okay, if you could turn
We're
to
not
that
going
exhibit
anywhere.
number 9 in the binder and just look at that for just a moment. And is the affidavit along with the search warrant there in
Exhibit
tab 9 or just the warrant?
It has the affidavit.
Okay, can you go to the last date, the last page of the affidavit and tell me the date that you executed it?
It says executed on 13th day of April 2023.
The day before you interviewed Ms. Richins, correct?
Correct.
And in this affidavit, you have multiple pages of why you want to search her phone, right?
I appreciate them going step by step. Ooh, baby. No, Emily, stop it. I appreciate them going step by step with the search warrants instead of saying, we're looking for all of the things. They are
Looks like
looking for
two-
specific
basically
things
two
based on
pages
the
of facts to support your affidavit.
investigation as it grows.
Yes.
Single spaced. And in this affidavit, you refer to
I mean, I feel the
things
single
that
space shade.
happened on the night of Mr. Richins' death and things that Kouri had told detectives before you. Is that right?
Yes.
And things the toxicology report had recorded, right?
You know what police can't do? They can't put things you told them into their report if you shut the fuck up. But that's not what happened here. Have you noticed a similarity in a lot of the cases that I cover? Is that at some point they're talking about what the defendant said to law enforcement? Right. Right.
Yes.
And you refer to
It's like they
an
use your
interview
words
that
against
was
you.
done of a friend of Ms. Richins that you refer to here as CB, as in boy. Where
As in
she had been
radio,
interviewed
CB
and
as
that
in
you
radio.
suspected she had deleted messages, correct?
Yes, that's correct.
And did you interview CB or are you referring to what someone else did?
I believe in this affidavit, I was referring to an interview that was conducted, that I did not conduct. That was conducted by other officers.
Shelley
And
is,
specifically Detective Woody, correct?
as myself and others will say, everyone has the right to remain silent. Most don't have the capability.
Correct.
I believe from my recollection, it was Detective Woody and Sergeant Davis.
And was in charge of the case before you.
Yes.
And you obviously had access to her notes or someone's notes from that meeting with Detective Woody and CB, right?
I don't know if I had access to notes from that interview with CB at that time. From my recollection, what I knew about that interview came from oral statements from Sergeant Davis and Detective Woody.
So you talked to Detective Woody about this case.
Somewhat.
How often did you talk to her?
Not very often.
When did you talk to her first?
I don't recall.
Before you interviewed Kouri Richins?
Yes.
All right. So before you interviewed Kouri, you
Amanda, mother of cats, nerd at loss. I question, what is a respectful way to tell law enforcement I'm not saying a damn thing? Well, it's not I'm going to shut the fuck up. We'd like to speak to you. Okay, I would not like to speak to you. So, or if you have a lawyer, you can say you can contact my lawyer. Their contact information is this. Hey, you can leave me any information you want to leave me, but I am not going to talk to you. You don't invite them in to sit down on the couch and have a chat. Of course, your mileage may vary if law enforcement needs to tell you about a death investigation. I mean, there are times when law enforcement needs to give you information. I think those times become very self-evident, but there are also times when the minimal is appropriate. Hey, can I have your name and license? Yes, here is my name. Here is my driver's license. I am disinclined to acquiesce to any further request. Things like that. What, do you know what speed you were going? No. Not at all. So there are times when you will need law enforcement to give you information, but if they are going to be asking you lots of questions, it is perfectly okay to say, no, I do not wish to speak to you. And they don't always have to give you your Miranda. Like when they are sitting in your living room, they do not have to Mirandize Kouri at that point. So they let him in, had him sit down, and had a 3-hour chat.
You had enough information about the case to prepare a 2-page affidavit with specific facts that had happened in meetings with Detective Woody, right?
Enough for this affidavit, apparently, yes.
And did Detective Woody provide you with her file from the case?
Well, it's his file
Again, there's
now.
not one file, but yes, I had access to the information about the case.
That she had put together.
Yeah, I mean, even from the beginning of Detective Woody's investigation, from what I understand, it was a collaborative effort of multiple investigators.
Okay, but you had what she put together,
Yes.
and you talked to her about it.
Not about all of it, but some of it, yes.
Okay. And you certainly looked at it before you did this sworn affidavit to a judge, right?
Again, not all of it, but some of it, yes.
Because you don't have personal information. You weren't at this meeting with Woody and CB.
No.
Okay.
Ma'am, he's not going to say he reviewed every page of
So is
everything
it-
because he didn't.
Would you agree with me, sir, that in this affidavit it is extremely clear that Kouri is a primary suspect of this investigation?
Well, it's clear to them. It's apparently
I
not
would
very
have to
clear
take
to
time to read
Kouri.
the whole thing to answer that. I
Please
can if
do.
you want me to.
Please do. The thing is, it didn't seem clear to Kouri at this point, but their argument is that Kouri's prior lawyer had sent an email saying, do not talk to my client. Kouri's lawyer should have also told her client, do not talk to the detective. It's got to go both ways. So we're gonna zoom through the. I'd like you to read the whole thing because he's gonna go okay and sit there and literally read the whole fucking thing because you're on the stand and that's what you need to do. So he's gonna take his time and read the entire multi-page, single-spaced affidavit. And this isn't even the snappiest affidavit.
Okay, I've read the whole thing. Could you repeat the question for me?
Yes. Would you agree with me that when you prepared this affidavit that it was clear that Kouri Richins was a primary suspect of your investigation?
I still don't think it was clear to
No,
Kouri.
I wouldn't agree with that statement.
You would not?
No.
You didn't think she was a suspect at this point?
I didn't have definitive information that she was a suspect.
Okay.
What
But
talked
wanted to
you
look at
into
her
it?
phone, and you were asking a judge to let you look into a phone, right? Her phone.
Correct.
And you're asking to look into her phone, by your own words, to see if she tried to obtain fentanyl on her phone.
Yes, that's the part that's recalling my memory is at that time, with the limited information I had, the most important fact that I felt we knew was that Eric died of fentanyl overdose. So the biggest question to me was how the fentanyl got into his system. And in my opinion, there were basically 3 different ways that Eric could have died of a fentanyl overdose. It could have been an accidental overdose, it could have been a suicide, or it could have been a homicide. In order to be thorough, I was trying to investigate all 3
options.
of those possibilities.
Right.
So 1 year after he died, you still had no idea whether it was a suicide, a homicide, or an accident.
That's correct.
The crime scene gives some information in that direction
So you show up
to me.
to have this friendly introduction with Ms. Richins. Do you tell her that you had just applied for this affidavit?
No.
Ma'am, we're not new
When you
here.
say you started from scratch, I mean, you didn't start from scratch. You'd spent a month reviewing the information prior to talking to Kouri, right?
No. I had not spent a full month reviewing that information. I still had a full caseload besides this case. When my time permitted, I reviewed what I could.
Okay, so you reviewed the files, right?
Right.
Enough to do this affidavit.
Enough to submit this affidavit, yes.
You had talked to the previous case investigator, right?
Yes, but not a full debrief of the case.
Okay, but you'd talked to her, right? You'd reviewed the ME report, because you just said that.
Yes, I have.
Right? Had you looked at the material that was taken off of her phone previously?
No.
Wait, you didn't
All
even
right,
know
so you
about the
show
Google
up,
searches
you don't
yet?
tell Kouri that you just applied for a warrant to
Oh,
search her private
boy.
information. Actually, what you tell her is that you all coach soccer together or something? Is that what you said when you came on to the house?
Your Honor, let me kind of renew this objection. What he told her is documented in audio.
I want to know who
and,
coached soccer with who.
Video recording. There's no dispute. It's not a game of gotcha. It is what it is.
We just want the tea.
Are you just trying to jog his recollection, lay foundation, or can we just move on?
All three.
Okay, thank you.
The court's like, it's all
Can I just get him to answer that one question?
Bloodworth. We would just want to hear all the recordings now. Bloodworth's like, it's in all the record. We don't need to put it back on the record. It's in the record. We want to hear, though. We're here to hear. We're here to hear. Bloodworth's like, but Your Honor, you have all this information. We don't need to tread this ground again. I know. He's right, but also we want to know.
You talked about the fact that you all had ties in the community through soccer coaching and things like that, right?
Correct.
And then maybe she knew your wife or something?
That sounds familiar.
Okay. But you didn't tell her you were investigating her for homicide at any point in those 3 hours?
That's not,
No.
ma'am, that's
You
not how
also
that
didn't
works
tell her
here.
you had a hidden recorder on your person, did you?
It
Can
wasn't.
you be specific at which
Yes.
point in time you're talking about?
When you first arrived at her house? Thank you, Your Honor.
No, the intention was not necessarily to hide it. The audio-only recorder was brought as redundancy in case of failure of equipment technology.
Because they
Where
showed
was
her
it?
she was
In
recording.
my pocket.
Okay. Did you tell her
It
there
wasn't visible to her.
Right. Did
But
you
my
tell-
intent was not to hide that I was recording her.
Right, that's why they put the body cam on the
Did you know
couch.
whether Sergeant, it's Hoffmeyer, right, that was with you?
Correct.
Did you know whether Sergeant Hoffmeyer had a hidden recorder on him?
So our memories have been a bit confused on this point. Originally, I thought I had remembered
Was
that he
Imogen
had the
involved?
recorder. The recorder was his piece of equipment and tools, but I think after listening to the recording from how far away he sounds from the microphone, I think I had the recorder on me, but it was just the one audio recorder and the one body cam.
And you intended to go in there and ask Kouri questions directly about what happened with her husband's death, didn't you?
Yep.
After she invited us in and consented to having us interview her, yes.
When she invited you in, did you Mirandize her?
No.
Right. Did you know she had a lawyer?
No, I did not.
You didn't.
Ma'am, what part of her home is custodial? I have questions.
Not? All right, let's look at the transcript for just a moment. I believe it is number Exhibit 11
Did
in front of you.
Kouri ever tell you she had a lawyer? Because it sounds like she
Can you
didn't.
Go to page 7.
It sounds like she didn't mention that at all.
And can you, this is, I mean, literally, you guys have maybe exchanged pleasantries, and you've only been there like a couple of minutes at this point, if it's page 7, right?
Yeah, it looks like about the time we were sitting down.
So can you read what Kouri said to you on line 3 of page 7?
So my attorney has been pushing to, obviously we just wanted her off the case because we're not getting anything done, anything accomplished.
And who's she talking about wanting off the case?
Ooh, Woody.
I think she was referring to Detective Woody.
So minutes into your meeting with her, she advised you she had an attorney.
Yes.
And you knew that you were going to elicit information from her that could be used against her, did you not?
Ma'am, it's up to
I
your
didn't know what information she would
client.
provide. I just
To
wanted to
assert
know the facts surrounding the night of his
her
death.
rights.
If she had said, hey, I killed my husband, would you have used that against her?
Yes.
Likely.
Okay.
Yes, ma'am.
So
That's
you
a
didn't
10.
Mirandize her at that point.
10 out of
You knew
10.
she had a
Having a lawyer is not the standard for Miranda.
lawyer. You knew you were looking for information about her involvement in her husband's death, and you did not Mirandize her, correct?
Correct.
Did you tell her that she didn't have to meet with you, that you were only there if she wanted you to be there?
She invited us in. We asked if we could come in. She could have said no.
I don't remember the exact words that were exchanged before we entered the house, but I didn't say that specifically, no.
And you didn't record those, did you?
Yeah, they're recorded on the audio, just not on the body camera.
Okay. Were you wearing a gun?
I think so.
Was Sergeant Hoffmeyer in a uniform?
He's like, ma'am, always. Hi, ma'am, we're the new
I
detectives.
think so. I don't remember specifically.
We'd like
Did
to have
he
a
have a
chat
gun?
with you.
Probably.
Okay. Ma'am, yeah, we're not going anywhere without a weapon. It's not how that works. Did you have a gun on you? Ma'am, always. Yes.
Prior to your meeting with Ms. Richins, when you were applying for the warrant of the phone that had been seized from her in April of 22, did you review the reports about the seizure and the investigation on the 12th?
No.
The 12th a year before? The 12th a year before.
When you were reviewing Agent Woody's file, do you recall seeing correspondence from her attorney, from Kouri Richins' attorney, instructing that no one investigating the case interview her client again without the lawyer being present?
Your Honor, objection that wildly mischaracterizes the correspondence.
Those are the prior
correspondence is in
objections.
evidence. It says what it says.
Would you rephrase the question?
Do you remember reviewing correspondence from Ms. Richins' attorney in
Why don't we just pause there?
At what point in time?
Detective Woody's file?
There you go.
No.
Yeah, at what
Do
point
you remember
in time?
discussing it with Detective Woody?
No.
This is a year
So prior
later.
to going to interview the key suspect of a murder investigation, you didn't take 1 minute to check and see if she was represented by counsel after a year?
Well, there's no case pending. So
All right.
she hadn't been charged.
Your Honor,
If she had been charged, that
The state's going to object to this line of questioning. The state renews its objection based on the Sixth Amendment, in that the Sixth Amendment has not yet attached.
So you say, but we're going to have to get into some briefing about whether
Yep.
this proceeding had reached a quote-unquote critical stage under the case law, and
Right.
whether we'd begun to focus on a particular suspect or other critical stage. Let's just get the facts in.
Thank you, Your Honor.
Your Honor, let me make the record.
Sure.
Then let me finish the record on the Sixth, quick move to the Fifth.
Sure.
I think the Sixth Amendment case law in Utah, the Padaki case, says it attaches at arraignment. And so I think it is a clear decision that there is no Sixth Amendment point. The Sixth Amendment has not attached at this point in the narrative. Moving to the Fifth Amendment. Your Honor, the Fifth Amendment, of course, attaches when there is a custodial interrogation.
Truth.
And Utah's Perea case,
Facts.
really citing to McNeil,
I love the judge. Truth. Sometimes your living room might feel custodial, but it is not, in fact, defined by case law as custodial.
v. Wisconsin of the Supreme Court, says one cannot anticipatorily.
I like this
invoke
judge so
the
much.
Fifth Amendment. You need custody before you can invoke the Fifth Amendment. And so.
Also, the rights are
all this business
Kouri's,
about whether
not
the defendant
Sky's.
was represented, whether Detective O'Driscoll knew she was represented or otherwise, is immaterial
To the Fifth,
to the Fifth.
Mm-hmm.
not necessarily to the Sixth. We'll see if your citation to Utah case law is correct. But I understand your point regarding the Fifth. I think the Fifth Amendment issues, right, are why they keep asking her if he had a gun on and
Yes, it
show of
is.
force, free to leave, Mirandized, all that stuff.
Correct, Your Honor.
Correct. I believe that line of questioning goes to the Fifth Amendment argument.
Correct.
That's why they keep asking them if they're strapped.
Here's the state's concern is
And I think the camera's trying to avoid putting the rest of the court staff on
The
TV
state
blast.
is certain that we can select a fair and impartial jury from Summit County potential jurors. But the state is very cognizant that the more information, and in this instance, the more false information put into the potential jury pool will
Bloodworth.
make it more
He's like,
difficult
nope,
and
I don't
take
want this
longer
televised.
to select those fair and impartial jurors.
Well, I have shared this concern generally in this case from the detention, the first detention hearing, given the level of media attention. But the reason I don't think that cuts one way or the other with respect to Summit County versus Salt Lake County versus, candidly, Washington County is because the outlets that are covering this, 95% of them are national or international outlets or new media outlets on YouTube that do not respect any county boundaries. And so
Okay.
I think the concern...
Your Honor, we are the law nerds. We are all about respecting boundaries, and sometimes consensual disrespect of boundaries. We're all about it. But I understand that the court is saying, hey, some of these outlets are beyond our reach because we are outside of your jurisdiction, which, Your Honor, I completely get. We respect your boundaries. We have been respectful. I think this is a good opportunity to remind everyone, if you are worried about your right to counsel, saying, I don't want to talk to you without my lawyer can help. And then it makes it a lot easier for your defense attorney to stand up and say, but Your Honor, my client repeatedly said, I'm not talking to you without a lawyer. Also, don't invite them into your home then. So there are two separate constitutional issues that they are talking about right now before Kouri is interviewed in her living room by law enforcement, a little less than a month before her arrest, a year after her home is searched and her phone is taken. That is this a custodial interrogation where Miranda attaches? And does her Sixth Amendment right to counsel attach? And did she invoke her right to counsel, or does her attorney a year before emailing the prior investigating officer saying, do not talk to my client without me, does that assert the right? Which I imagine with case law, it's not going to assert the right because Kouri didn't assert it. Kouri was like, and this is me just being hyperbolic, I think Kouri was like, would they look nice? Come on in. And Kouri was like, Kouri told them, my attorney was sick of the other detective because we weren't getting any information. So Kouri's in a full Murdaugh situation where she thinks she's going to get information about the death investigation. The information is going to be her talking to them. Do we know what she said in this investigation? No, it's not come in any of these filings yet. So we will see. Laura said, if not friend, why friend shaped, right? If not friend, why beard friend shaped? Why? Why? His beard is so nice. Surely he's here to tell me because I am grieving and he is here to tell me that everything is going to be okay. And we got rid of that other detective that we really didn't like anyway. And that's what my attorney and I wanted. And I'm sure Kouri was trying to be very helpful. But the argument over Sixth Amendment and Fifth Amendment will be interesting. So, but Your Honor, we respect boundaries. We've got you. We're not in Utah, but we've got you.
Expressing, while valid,
I mean, we flew there for the day.
Applies to every potential jury pool.
Well, yes, Your Honor, I agree with that. I think we will argue that one day in the future. The reason I mention it is the gratuitous publication of false information through the course of these moving papers and this examination is unhelpful.
Bloodworth's like, let me set the record straight here.
Quickly filing a fair and impartial jury.
Her rights weren't violated.
Whether it's Summit or Salt Lake or wherever.
I appreciate your concern. I don't think we are even approaching, never mind beyond, the point of no return in that regard.
Don't make me start singing Phantom of the Opera, Your Honor. It'll happen.
Okay.
Just
It'll
pointing
happen.
out, Your Honor, all of these materials have come from the state, and this is the
Ms.
first.
Nestor, we can just move on.
Okay.
Thank you.
Your Honor, will you start singing Beyond the Point of No
All right,
Return?
so
Maybe.
I want to
How are we
move
feeling about
now
musical theater, Judge?
to,
We have questions.
the search that you did and the arrest. By the way, Kouri was arrested. You sought an arrest warrant for her within a couple of weeks of having this start from scratch interview of her, right?
Yeah, that time frame sounds correct.
So in the space of your interview with her on the whatever the date is, the 14th, and her arrest on May 8th, which is about 2.5 weeks, in between that time, you decided it was a homicide and she was the one who did it.
We're in 2023
And
now.
that's 3 weeks. Okay. All right. So then you apply for a warrant of her house, which you applied for on May 3rd.
And yes, Chad, I think my love for
And let
Phantom
me
of the Opera,
approach with this, John.
at least as of, I don't know, junior high, maybe late elementary school. I'd have to look at dates. I think has deeply influenced my adult reading material. So, yeah, yes. Also, Your Honor, we're just here to talk about the law and the facts. Please let us stream the trial. Please let us stream the trial. All right.
Yeah.
We're going to mark this as Exhibit 56.
Emily Ippolito said, God damn it. Is that where it comes from? Isn't Phantom coming back to Broadway? I've seen rumblings that Phantom's coming back to Broadway.
First. I just need it back when you're done. Okay.
It'll make me so happy.
By the way, in that period of time between when you had this interview with her and were open to hearing however it happened, the death, and the time you issued the warrant for her and the search for her house and her arrest on May 3rd, did you investigate any other potential suspects in that 2.5 week period of time?
To an extent, yes.
Okay. And I assume you have reports about that?
Yes.
That you prepared? Okay. I'm not going to go into that, Your Honor. Okay, so what is the date that you applied for the search warrant to go search her home? When did you ask a
The
judge
second time?
to give you permission to search her house again, a year later?
May 3rd, 2023.
Okay, so again, like less than 3 weeks after you interviewed her, right? And in this interview, I mean, this warrant,
Second, would you repeat that for us?
I just said I believe that math works out. Yes.
in this warrant that you got, you asked to search for 2 things in the house, right? 2 things.
Correct.
Counterfeit pills and copper cups. That's it.
Yes.
Okay. And that warrant was issued by a judge, correct?
Yes.
And that's the warrant that gave you authority to exercise a search of her house on the day she was arrested, correct?
Oh, did they
Yes.
wait? So they waited
Right.
a few days?
On the day she was arrested,
May
Ms.
8th?
Richins was located in another location from her home. She was down in Salt Lake, is that right?
Yes.
And you were there at the location where the arrest took place, right?
Correct.
And other officers or deputies were involved in the search of the house up in Camas.
They're looking for copper cups because it
And
was believed that, and there's been some conversation about this in other hearings, that the fentanyl was in a Moscow Mule, which is traditionally enjoyed in a copper mug. So that's why I think they were looking for that specifically.
While you were, let me see really quick. While you were arresting Ms. Richins, when you arrested her down in Salt Lake, did she have a phone on her at that time?
Yes.
On her person?
It was in her hands, yes.
And when she stepped out of the car, what did you tell her to do with that phone?
She didn't step out of a car.
You pulled her out?
No. She was exiting a business building.
He's like,
And I approached her while she was walking out.
neither.
Sorry, my bad.
She was just
So when
in
you
public.
approached her, what did you tell her to do with the phone?
I didn't tell her to do anything with the phone.
she do with the phone?
Your Honor, objection. This seizure is not the subject of any of the
Motions.
three motions that today's hearing set for.
Your Honor, are we fishing?
I think
I
that's
didn't
right.
think we were
Isn't that right?
fishing.
No,
No.
it's relevant to Mr. Ramos's.
I will say,
Electronic data?
Yes.
I like a Kentucky
'Cause
mule.
I'm just identifying the foundation of where that phone came from.
Your Honor, that motion, the electronic data motion, challenges the four corners of the warrant itself. The actual seizure of the phone is irrelevant, other than the fact that it was seized pursuant to that warrant.
Bloodworth's like,
Yeah,
bing.
forgive me. I listened back to our discussion regarding burdens. Is there anything about the execution of that warrant that defendants believe was unreasonable?
About the execution of the warrant of arrest?
Bourbon or
The
whiskey, depending.
search warrant, or is it that you believe the phone was seized without the benefit of a
I'm
warrant?
about to get into the statements she made at the time of her arrest prior to Miranda that directly deal with the phone that was in her hands. So I'm just laying a foundation for which phone it is and what they say to her and what they
The
get her to
phone
say.
was in her
None of
hand.
that information is relevant to the three pending motions.
Yeah, forgive me. This is new to me. I don't know that have you filed a Rule 12b3 motion that
No.
regards this topic? Help me.
No. Not that's on the docket.
We just need to make sure the state had noticed that this was coming.
Right. And Mr. Bloodworth already made a record saying that some of the defense motions were vague, and he thought that they were a bit overbroad, so they are kind of operating without as much notice as they would like. And so when Mr. Bloodworth is like, literally no, that motion challenges the four corners of the warrant, this is well outside the four corners of the warrant because this is how it's being executed, and that's not
Correct
what's
me
in the
if I'm
motion.
wrong, Ms. Nestor. I believe it's undisputed that Kouri was arrested. A phone was seized from her during the course of the arrest.
Right.
2
Right.
hours later, a warrant was issued with respect to the contents of that phone, correct?
Right. We are not actually challenging the search of the phone. I am
Are you
dealing
challenging
with
the
the
seizure of the
issue
phone?
of the statements that she made after
Then
her
what's that have to do with
arrest,
where-
but-
That topic is not, and forgive me if I missed it, that topic is not a part of Mr. Ramos'.
Hold on just one moment, Your Honor.
Yep,
Can I talk that?
no problem.
All right, we're gonna zoom. The court's like, yeah, I didn't see that in the motions. Counsel's like, yeah, I didn't see that in the motions. And you just told Mr. Ramos that he wasn't getting lunch, so
Okay. I'm sorry, Your Honor. I got confused. I don't need to go into that. So I will move on. That is a different issue.
Okay, very good.
Okay, so you're down there, you're with her when
Great.
she's being arrested. Meantime, there's officers
Also, I
searching
will-
her home up in Cameron.
I know not everyone's a fan of her questioning style. I will just say that the defense attorney is left with the facts their client gives them. And there's not a ton that they can do with, please come in, let me chat with you. So the reason it feels like these motions are a bit difficult is because the facts the defense are working with are difficult. It doesn't mean they're not going to make the motions. It doesn't mean they're not going to do their job. It doesn't mean that they're not going to try to zealously advocate for their client. Part of what they're running into is that law enforcement has been fairly methodical, pretty slow actually, in moving forward with this case, and has really taken each step in sequence. They haven't, jumped to conclusions. They've just gone through their processes, and there's not a ton that counsel has to work with at this point because there's just not a lot there.
Right?
Correct.
And at some point, you get a phone call from one of the officers on the scene. Is that right?
I don't recall. I'm sure I took lots of phone calls that day.
Did they advise
it was
you
a
that
busy
they had
day,
found
yeah.
something in the search that was not within the permission of the warrant?
I don't recall.
Recall being told?
Go ahead, Mr. Bloodworth.
Your Honor, I think this goes to the seizure of the orange notebook, which is issue 4 in the defense motion to suppress statements and evidence.
Right.
As we discussed last Thursday,
Bloodworth's memory is
state has
just
conceded that the state seized that notebook on May the 8th, 2023, beyond the scope of the warrant that Ms. Nestor is addressing.
Correct.
okay.
The state, I understand, will be arguing inevitable discovery.
Yes, Your Honor, and
Which is an
that
exception.
argument relies exclusively on paper, various warrants, their tabs. I think it's
We'll get there. We don't need to name them all now.
13 through 17-ish.
Okay.
The point being is this examination is nothing more than to prove a fact that the state has conceded.
I think that
Okay.
that concession matches my notes after re-listening to the
Well, that's
last
why-
status conference with counsel.
That's
Anything
why
else we need
council's
from
like, we
this
don't need to get
witness
into the
regarding
orange notebook. We
Yes.
agree that the orange
Proffer for me
notebook
what
was
else
not.
it is you need.
Your Honor, all the steps that are made
Properly
and the
seized.
chronology of the steps that are made about the search file into my entire fruit of the poisonous tree argument. I need to lay a foundation if I ever need on appeal. I need to be able to make clear the steps that they went through to,
Respect to the orange notebook?
yes,
Once they have it, though, outside the scope,
yes.
it's a problem that they now need to invoke some kind of exception to
Right.
fix. Isn't it the steps after the orange notebook that would be relevant to the fruit of the poisonous tree?
That's what I'm getting to right now. Is I just asked him about the orange notebook
Okay.
and what he does next. I mean, that's where I'm going.
My apologies. Okay.
No worries.
It was
Okay,
not what
so-
you asked, but
May I
okay.
proceed? I'm sorry. So you get this call that they find a notebook in her house, right?
So what the state has said is, hey, when we're getting to the orange notebook in the home, on the 8th, there was a search warrant for 2 very specific things for the home: counterfeit pills, copper cups. You know what a notebook isn't? Either of those 2 things. So if law enforcement took a notebook, which it sounds like they took an orange notebook during that search, then the state is arguing that was inevitable discovery. The defense is saying, no, from that orange notebook, other things afterwards happened. That orange notebook is, by that, the poisonous tree. And then anything that they discovered from the orange notebook, not within some other exception, is going to potentially be fruit of the poisonous tree. And that's where they're trying to head that off. We didn't spend a lot of time on that yet. And it sounds like prior to this hearing, the state conceded that that orange notebook is not within the scope of the warrant. Does that mean it will be suppressed? Not necessarily, but that, it seems, is where most of these arguments are going to lie, more so. But what happens after that, well, I guess we'll find out. So that's the argument, but we're not there yet because they're not arguing yet. So we'll see. Also, I'm going to say I appreciate the state saying, no, Your Honor, we're not going to fight you that this was taken because of plain view or taken because of something else. They're going to say, no, it was not part of the warrant. They took it. We think it's inevitable discovery, but we're conceding that there has to be an exception for it because it was taken outside of the scope of the warrant, which is what the state should do. Look, we have other exceptions to argue, and we'll argue them, and the court will decide what it decides. But the state's not hiding the ball on that. They're like, right, no, we all agree. We don't need to tread this ground. We all agree with you because the facts are the facts, and then we go from there, which I appreciate.
Go ahead.
Your Honor, I don't know that we're fully clear on this issue.
Let me sound out what I understand is the possible benefit of this.
The court, where are we?
Are you preserving
reorient.
the ability to argument that there was a gap in time between when the notebook was actually found and when it would have inevitably found?
Yes.
And during that gap in time, they learned some things that is
Yes.
fruit of the poisonous tree.
Yes.
Here's the gap I'm not sure we're square on, Your Honor. State has conceded that the search on May 8th that discovered the content of the orange notebook
Right.
was beyond the scope of the initial May 8th warrant to search the home. Based on information obtained
This is the
from
interesting
the
part.
Orange Notebook.
At that time.
At that time on May 8th, there was a second warrant written to search the home on May 8th for a notebook. The state is conceding that that second warrant, the portion of that second warrant to search for notebooks, there were other collateral issues that don't touch on this, was invalid because it relied on information discovered in the notebook pursuant to a search beyond the original warrant.
Okay.
The state's inevitable discovery argument is about warrants that occurred way after May 8th. All the information those warrants relied on are in the affidavits of probable cause for those warrants.
May we pause here for just a moment? I think this discussion would
Interesting.
be more detailed and fruitful if you both weren't worried about seeding the public record with a bunch of stuff you don't want
And this
potential
is why
jurors to
they
know about.
seal part of the hearing.
That is a sufficient basis to
For now.
close these proceedings briefly to have a more detailed discussion about this topic. So, everybody
they
who is
seal-
on that side of the bar, including all of you, I
And
need
they
you to
kick
step out
everyone out.
now.
And they turn off the cameras. And they closed down the audio access. They completely sealed the hearing at this point to argue over inevitable
Bloodworth?
discovery.
Sir, you're under oath, correct?
Yes.
Very good. Mr. Bloodworth, please proceed.
All right.
Thank you.
So now we are back with a different witness. Let's talk about what happened real quick. So, what happened at this hearing with Kouri Richins before portion of, or a substantial portion, actually, I don't know, it was 45-minute portion of the hearing was sealed, is that they are arguing over whether or not the hearing on the motions to suppress needed to go further into an area regarding a notebook that was seized from Kouri Richins' home the day that she was arrested, May 8th, 2023. What the prosecution has said is the prosecution concedes, Your Honor, that the notebook in the home on May 8th was not part of the first search warrant on May 8th. They saw the notebook, they looked at the notebook, and then law enforcement used information from that notebook to get a second search warrant on May 8th for the notebook. The state then said, we concede that that portion of that search warrant was also not valid because it relied on information from the notebook that they did not have the right to search or seize at that time. So that portion of the second search warrant on May 8th for the house, he said that part is also not valid. We've conceded that because they looked at it and went, that is what it is. We've conceded that that's not the proper process. What he then argued is, Your Honor, there is more information because then there were subsequent warrants and this inevitably would have been discovered and not changed or altered because Kouri Richins is now in custody. Kouri Richins is now no longer in control of the home, the property of the home. So they are saying, but as we get to the notebook now, there is something that happened in between that time that shows us that the notebook would have been discovered. So there is an exception to it and conceded where the issues were with that particular notebook. What is in the notebook? We don't know. But the prosecution's not going to say, hey, we're going to argue tooth and nail over this thing. The prosecution's like, these are the things that are improper. We concede those. And this is how the notebook is still inevitably discovered and then still allowed to come in as evidence, shouldn't be suppressed, etc. We have heard that Kouri Richins wrote quite a lot. I wonder if the things that were the most significant were in the orange notebook, because we heard the prosecution mention in other hearings that Kouri Richins wrote that she learned that she was going to need stronger fentanyl to kill her husband between the day he ate the sandwich and got sick on Valentine's Day and the day that he died on March 2nd. So with all of that, the state said, yes, these things were an issue, but inevitable discovery, so this shouldn't be suppressed. And then they sealed the hearing because the judge said, look, it sounds like you all are talking around more specific information that is not at this time proper for the public domain, because the information regarding the notebook may or may not be suppressed. So talking more detailed about it may put information out into the public that is not information that will come in at trial, that could skew perception against Kouri Richins before a jury is ever picked. So that's when the court said, nope, sealed. And then we're going forward. If there was nothing in the notebook that was relevant, they wouldn't be having this conversation. Something is in the notebook that the defense wants to seal, and the prosecution is arguing that they don't have to. We will see what happens down the road when the court orders. And now we have gone to the next witness under oath. So we have had lunch, we have had a sealed portion of the hearing, and now we are getting to the next witness. So O'Driscoll and his beard are no longer on the stand. And now we are getting into the next witness. So let us swoop back into the next witness. Hopefully that summarized everything that happened, where the prosecution's like, yeah, we don't need to argue over this. There's only one part at the end of this we need to argue over, and that was sealed. Let's go back to court. No, that was the wrong button. Emily, wrong button. Back to court.
Your Honor, for the record, the state is called and the clerk has sworn Clint Benson. Mr. Benson, are you familiar with the trust relating to the estates of Eric Richins?
Is Clint Benson a banker?
And who is the trustee?
This might go to some of the inevitable discovery because they are talking about the trusts now with regard to the estate of Eric Richins. So I don't know if Clint Benson is banker, lawyer. We'll find out maybe, and we'll see.
Of that trust.
Katie Richins Benson, well, it'd be the Eric Richins Trust. And then Katie Richins Benson would be over that trust.
And what, if any, relationship do you have with Katie Richins Benson?
I'm her husband.
Oh, okay. That's not what I was expecting.
With the Willow Court,
the brother-in-law
address where
Katie's husband
lived.
Yes.
Well, there we go. Eric's brother-in-law.
Does the trust own the Willow Court address?
Yes.
Does the trust have control, like physical control over the Willow Court?
And the trust, if they had gone in and seen the notebook, would have immediately handed it over to law enforcement and said, hey, there's some shit you're going to want to know in this notebook. We own this house. We've owned this house for a year. There is stuff in this house that is within our property, and we are going to give it to you. This is the type of question that you end up with law school exams. It's like, what happens if a roommate whose name is on the lease lets police in to look for something, and they take something and arrest the roommate whose name is not on the lease? Like, whose property is it? Who can give consent to search? We're going to get way potentially nerdy with the Fourth Amendment here. So,
address.
Yes.
Did the trust gain control, physical control over the Willow Court address upon the defendant's arrest on May the 8th, 2023?
Yes.
Who, on behalf of the trust, has controlled access to the Willow Court property?
That would be me. So after Kouri's arrest, locks were changed, cameras were installed, and I have monitored all access to that property.
Okay. In monitoring all access to the property,
did her mom ever come by and try to get
other
shit?
than law enforcement,
I got questions.
Who, if anyone,
what about her brother?
has entered the property?
We have had Todd Gabler has entered the property.
And let me just break you there. Is Todd Gabler an investigator retained by the state in connection with the civil litigation?
Correct.
Other than law enforcement and Todd Gabler, has anyone entered the home?
We did have one instance where It was a bank matter where someone did try to enter the home. Law enforcement was quickly called, and he was stopped at the garage man door and garage entrance.
Okay. To wrap a little specifics around that, a bank holding a lien on the property had asked a locksmith to go to the house and change the locks. Is that right?
Correct.
When that person was at the house to change the locks, that generated a call to the police?
Correct.
I would imagine
Deputy
so.
Shane Norton responded to that call.
Because
Yes.
mortgage fraud is a part of this here.
He contacted that locksmith in the garage before that locksmith entered the house. Is that correct?
Correct.
Okay. Other than police, Mr. Gabler, and the locksmith, has anybody else entered that house?
I did have assistance from a family member on installing cameras in that home, but that was right after Kouri's arrest, and that would be it.
So cameras were uninstalled from the home. Interesting.
Have you personally escorted those who've entered the home?
Yes.
In each instance, I guess. except
Right,
for
no
that
one else could have
locksmith
put
who was
something
trying
in
to
or
change
removed
locks?
something.
Correct. Yes.
Okay.
Right.
In escorting anybody that entered the home, did you observe anybody bring something from inside the home and place it, or sorry, something from outside the home and place it inside the home?
Never. No.
Right.
That's never
The
occurred.
notebook was in the house. Nobody brought it in
Other
after
than
her arrest.
police removing items from the home pursuant to warrants, have you seen anybody remove any items from the home?
No.
Thank you. No further questions.
This goes to that inevitable discovery argument that no one else had access or control of the home, that the home did not have anything brought into it, only things taken out of it. It was secured.
afternoon.
They set up security cameras. They took down
Mr.
other
Benson, you and
security
I've met
cameras.
before, but just to remind you, my name's Kathy Nestor.
On cross.
Okay.
For those of you
So
asking
your
about the
wife
lock
is
change,
the
yes, the bank or a bank tried to change the locks. A bank had liens on the home. If you watch the hearings with regard to bond, in both hearings, there's conversation about the liens that were taken out against the home that was owned by Eric Richins as his separate, not marital property, done by Kouri Richins, seemingly by forgery, based on all of the information. Kouri had quite a lot of debts that were being serviced as part of her real estate flipping business, and there were substantial debts on the home. So it sounded like the bank was coming to change the locks and being like, hey, we're in control of this property. And there are, I think, 4 civil litigations ongoing with regard to the estate, the properties, the mortgages, the debt. There's a lot of civil going on to the side of this. A lot of that is paused because of the criminal processes, but 1 or 4 of the counts that were separated out of this case are those mortgage fraud and forgery cases where it is alleged that Kouri Richins forged Eric's information to take out liens against the home and to take out lines of credit against the home, even though that home was not her property. So there's a lot that there was a lot of financial stuff going on as well ahead of this homicide.
Trustee of a trust that the house has been folded into, is that correct?
Correct.
And there's litigation surrounding that trust at this time, is that right?
There's numerous litigations.
That's
Civil litigation.
correct.
I think they're paused because of the criminal
And,
case.
Since the day that Kouri was arrested, the family was not aware she was going to be arrested, right?
No.
Okay. And she has 3 young sons,
Correct.
and they were at school.
I believe so. I
He's
was
like, I
not
don't-
there when that occurred.
I don't know.
Beyond objection, relevance as to what this has to do with the state's direct examination regarding security of the home.
Because I think she's laying foundation that there was a time when some stuff was taken out of the home regarding the kids. But I think we could just fast forward to.
I'll get to it.
The court knows exactly where she's going.
After Kouri was arrested, someone who was not a member of your immediate family was the guardian for a brief time of those children, is that right?
Correct.
And those children had to come back and get their things out of the house?
I believe so. Yep.
And they were with that other person that was not you?
They came to the home, but I believe I was there when they arrived.
Ma'am, the kids are not bringing the orange notebook in from school. Yeah.
To do that, and they were escorted.
And in fact, hasn't there been, in another matter, hasn't there been an order entered that the children are permitted to go into the home to get items whenever they need it?
They are permitted, but they have not gone to the home.
At least once they did.
And it sounds like
Not
they
to
were
my knowledge.
You
escorted.
just said they went in there with their guardian.
No, you asked if someone had gone to the home, but it was the guardian.
It was not the
that
kids.
had gone to the home to pick up their stuff.
Oh, okay. So the children weren't with them.
Correct.
Oh, I'm sorry. I didn't understand. That's what you were saying. I apologize. So the guardians were there at least once.
They were there once, to my knowledge.
Okay. And Mr. Gabler has been in the home, correct? And Mr. Gabler's been assisting this prosecution with providing them with reports and interviews and all kinds of things to assist this prosecution. Is that right?
Your Honor, objection. Anything Mr. Gabler's provided has been pursuant to subpoena.
We can keep moving here, Ms. Nestor.
Mr. Gabler's working
I
with this
imagine the family's not
prosecution team, as far as you
thrilled.
know. He's
That's-
provided them with materials for what, however he provided it.
He's
to
been
them.
subpoenaed?
Correct.
All right. And he had authority to be in that home because
Counsel's
he was
Remarkable's
working
just
for your
on full
family.
display.
Is that right?
I wouldn't say he had a authority to be in that home. He was accompanied by me when he was in that home.
How many times did he go in that home?
I don't recall the exact number.
More than 5?
I don't recall.
More than 20?
Not more than 20.
Okay, so less than 20 times.
There are a number of written items taken from Kouri Richins' jail cell. I would imagine that the notebook and the items taken from custody look similar in the way that they are written and read similarly in the way that they are written. So I don't know if authenticating who wrote in the notebook is going to be difficult because Kouri likes to write.
But more than once or twice.
Correct.
And when Mr. Gabler would go in there, he did search for items that he thought would be relevant and helpful to the prosecution, didn't he?
He's an investigator. He can do that.
I believe so.
He can do that.
Your Honor,
It's their house.
renewing the objection.
I think Ms. Nestor is about to move on to a new
I am?
topic.
I love the court. That is the court telling you to move on. I think Ms. Nestor is about to move on. I am, Your Honor. Yes, I am. The house was Eric Richins, the decedent and victim in this case. It was his separate property. It was not marital property. He put that separate property into a trust. That trust is governed by the sister of Eric Richins, who is this witness's spouse. So they or the sister have control of the home. They are allowed to do what they want with it. If a private investigator needs to come in and look for things because there are multiple civil litigations going on, they can do that. And then if the state says, hey, we have a subpoena for any information that you gathered from the home pursuant to this civil litigation, they can do that. If they found something in the house that they thought is relevant and wanted to give it to law enforcement, they could choose to do that too if they wanted to. But the state stood up real fast and said, anything we have obtained has been subject to subpoena. It is their home. They can do what they want with that home, with the property inside that home. So none of this is like a served moment, but they are making their arguments. Because now we all want to know what's in the orange
times that
notebook.
the warrants were executed. We just took some testimony about 4 different warrants that have been executed since Kouri's arrest on the house. 4 times. Were you there for each time they did the warrants?
Yes.
And you saw the searches every time?
I would let them into the home to perform the search.
Okay. And how many people would be in the house, give or take, when that was going on?
You're talking 4 searches, so you'd have to be more detailed.
How many officers would you see? Typically, was it one? Was it multiple officers that would come in?
It's like,
It
when
would be more than one.
are you talking
Couldn't
about?
be with all of them the whole time, right?
Correct.
How big is the house?
It's 4,300 square feet.
Okay, and there's multiple floors, is that right?
Correct.
Okay. And how long did those searches take, average, when they would go in and search under these last 4 warrants over the past 12 months?
It depended upon the case and what they were looking for. So it depended upon,
It would
dependent upon
depend.
the warrant.
And as the trustee, the person that would be present, did they tell you what they were looking for?
No, in some instances they would, some they wouldn't. So
Tell me the instances you remember in the last 12 months, what they were looking.
I don't recall exact items. There were a lot of items.
Okay, so they did take items out of the house? Every time?
I don't recall if it was every time, but
He's like, right,
they
I
did
wasn't-
give a list of items that were taken on the, in regard.
They
to the
gave him a
warrant.
return or a property sheet, I guess is the technical and
And the
specific.
first time the house was searched,
And she would have that too,
did it
by the way. She would
appear
have
like
the list of what they
were-
took out.
Was the house in disarray after the search? In other words, were things thrown on the floor? Was there?
Would you pause for 1 second,
Yep.
Ms. Nestor?
Your Honor, this is beyond the scope and irrelevant.
I think this is beyond the scope of the motions you filed. I don't recall any arguments regarding unreasonable execution of a warrant.
No, that's not why I'm asking.
I think we need to move on.
Yeah, the court's like, no, ma'am. No, ma'am.
Has
No,
Katie been in the
ma'am.
house?
No.
Never? Not since the death of her, not since the funeral?
You got to, hold on.
Sorry, let
Would
me
you
rephrase.
redefine the time period
Not
that you're
since,
describing?
not since the time of Kouri's arrest. Katie
Right.
has not been in the house?
She has not,
And Amy has not been in the house?
not that I recall.
And your father has not been in the house?
He hasn't been in the house, no. He's there, you'd have to be more specific. Do you mean the house or the detached garage? What
Anywhere
item
on
are
the
you talking about?
property?
He has been on the property.
Okay.
Okay. Counsel, where are we
Were
going?
you
with
present
this?
on the day of Kouri's arrest when they were searching the home?
I was not.
Were you the person that came and changed the locks that day, or did someone else do that?
I didn't change locks. We hired a person to come and change the locks.
Right.
So you
I
personally
like,
didn't appear at the house that day?
he's very direct in his answers.
I was at the house.
Were you there while the search was ongoing?
No, I don't believe so.
So do you know how many people went inside and outside the house that day?
Objection, Your Honor.
Sustained. We need to move on.
Do you know, you were not at the house the day that the arrest happened?
No, he said he was there later in the day.
Your Honor,
He just answered that. He just answered that. Your Honor.
You're going to have to be more specific,
Well,
and we're going to have to move on. You need
I
to
will.
stay
I will.
reasonably tethered to the motions that the defense has filed.
The
You
day
don't
that
get to
Kouri was
just
arrested,
ask shit.
there was a lot of people on the property. Is that correct?
Law enforcement.
And were there others?
I don't remember seeing anybody but law enforcement there, as well as a locksmith to change the locks.
Were you there the entire day?
I was not there the entire day.
Okay. What portion of the day were you there? An hour, half an hour, 6 hours?
Well, it
Just as
doesn't
long as it took the locksmith to change the locks.
time
So
frame
at the
help?
very end, when they were finished?
Correct, I believe so, but I
Okay.
don't recall.
Okay, that's all I have. Thank you, Your Honor.
Anything else for this gentleman?
no, Your Honor, thank you.
May we release this witness?
Yes, sir.
You're welcome to step down. Thank you.
Okay.
Mind pouring your water in that plant there?
The judge is like, look, if you're going to get rid of the water, do you mind watering the plants in the courtroom?
Mr. Bloodworth.
I like this judge so much. Oh, Judge M. Sir, if you're going to get rid of that water, can we just,
Your Honor, the
the plant?
state has no further witnesses on this first motion to suppress statement and evidence.
And so I believe this is the point where the state would say all burdens either are with or have shifted to the defense. Is that correct?
That is correct, Your Honor.
Okay. Ms. Nestor, Ms. Lewis, Mr. Ramos, give me a sense of where we're headed.
Can I approach for just one?
The reason that the judge is talking about that is because there are multiple motions to suppress. And so the state presented their witnesses to rebut the defense motions to suppress where they bear the burden. And there are parts where the defense bears the burden. And then we'll have to call the witnesses and do the direct examination of the witnesses. So there are numerous motions to suppress. So let's continue.
Minute.
Sure.
Mr. Blevins.
And they are approaching, so we're going to zoom while they approach. No, Kouri, they're not going to let you go up and water the plant. No matter how much you ask your attorney, if you can just go up and water the plant, they're not going to let you. I'm being facetious.
We believe there's sufficient evidence on the record for us to brief at this time. We're not going to call any more witnesses on my motion. The only two left are Mr. Ramos and then Ms. Lewis's.
Ms. Lewis, tell me, your motion is
The 6-page document,
to suppress the letter?
yes.
And who do we need to call, if anyone, on
We
that?
have the two officers. who
Amanda,
did
the
search
water, the
of-
plant emoji can just be
Okay, are they present?
water drops.
Are they present, Mr. Bloodworth?
Your Honor, they are both working in the back. I need about 2 minutes on each, but I need a break anyway.
That's no problem.
He's
Let's
like, I would
take
like to pee.
We'll take a 5-minute break, and then 2023. 157 is May 8.
Thank you, Your Honor.
Okay, so they are going to take a brief break. We're going to zoom.
Brittany. I may have jumped the gun there.
Yes, Rando from Iowa, that one. That one. That one. Also, StreamYard with the emojis. We love it. That's the one I was thinking of. So the court is taking a brief break. And then we will be back on the record, moving into other motions to
may we
suppress.
please
They're going to
go back
argue
on
them
the
all
record?
together.
All right, folks, we're back on the record. Counsel and Ms. Richins are present. Ms. Lewis.
Yes, Your Honor, we would call Sergeant Barrett.
All right. Sergeant, let's get you sworn in if you don't mind.
They are shifting to
Do
different
you solemnly swear the
motions.
testimony you're about to
And
give in the
because
matter
they are shifting to different motions, the defense is now calling witnesses. The state called witnesses to meet their burden on the motions. The defense is now calling witnesses to meet their burden on the motions. And I believe we are going to start getting into the motions to suppress regarding the walk the dog letter, because I think those are the ones that Lewis filed.
before the court to be the truth,
So
the whole
beyond
truth,
the
and nothing but
statements
truth,
and the
subject to
tech
pains and
data.
penalties of perjury.
Good afternoon.
Good afternoon.
Sergeant, what's your full name for the record?
Braxton Ray Barrett.
And where is it that you're employed?
Say again.
Where are you employed?
Summit County
Doing-
Sheriff's Office.
And what are your duties?
I'm a corrections sergeant.
All right. And were you acting in that job capacity in September of 2023?
Yes.
And were you involved at that time in a search that took place of the pod and the cell of Ms. Kouri Richins?
Yes.
All right. So could you tell me what initially led to the search at that time?
Do you have a specific search?
Yes, let's start with, I believe there was
what
a
are we
search
talking
of Ms.
about?
Richins' cell on September 13th of 2023.
Okay. So Miss Richins had a medical episode, and so there was a brief search initially after medical had treated her. That was a quick search to look for any obvious contraband left over from
That could cause a medical
EMS
episode.
personnel. And then
Or that.
shortly after that, there was indication that there was possibly something held up on a video chat.
Okay, I'm going to ask you about that, but let me just take it one step at a time. So initially, she was taken out of the jail for a medical situation.
Yep.
And there was a search on September 13th, and all you were looking for was if anything was left behind by the EMTs, is that correct?
Initially, yes.
Okay. And then when was it you became aware of a video call that led you to want to search the cell further?
So it was while she was away from the jail that was brought to my attention that there was possibly something held up in a video chat. So we searched the cell looking for a piece of paper with cursive handwriting on it.
And that search took place on September 14th, is that correct?
13th, I believe, is my dates.
So, all right, so the first search on September 13th, you
Correct.
didn't seize anything from her cell at that time, is that correct?
No.
And you believe the second search was September 13th?
So there was an initial search of just immediately nothing to do with any case. It was just
Right.
a contraband search of any medical items left over.
Right. You
in
don't
the
want
immediate
EMTs
area.
to leave stuff that's
And
going to
then
be a
while
problem.
she was away,
Then
there was a indication that there was possible
other contraband.
issues with a video
Call.
conversation where she held up a piece of paper.
And on that occasion, did you search just her cell or did you search the entire pod?
It was just her cell on that one.
All right, and that was also September 13th?
Yes.
And nothing was collected on that search either, correct?
Nope.
So what led to the search on September 14th of the pod and Ms. Richins' cell?
So there was random cell searches of two different sections, Gulf Pod and Bravo Pod. And then also with her medical condition, she was going to be moved to a different cell for observation.
All right. Alex, can you just put on, I'm going to show you some videos of the search on September 14th. We'll try
A
not
pod
to
is
go
generally
through every single one of them. Could you start? pulling up?
Housing unit.
It's States Exhibit 69, but it's number 8 on our list. And before we start that,
Ma'am, the fact
well,
that you
actually,
don't
no,
say
go ahead.
69 with any confidence at all is going to make the law nerd sad. Can we not? Can we just?
Your Honor, can I just offer the court some context?
No, Mr. Bloodworth. Is there an objection? Mr. Bloodworth's like, I would like to say something, Your Honor. I have a comment. For those of you that are newer to this case, I'm going to pause here real quick and show you what was ultimately seized, or one of the things that was ultimately seized. This has been the subject of several motions with regard to this case, and the motions thus far have been denied. Oh, this does not want to play nicely. It's like, girl, we're not playing with you today. Okay. This has been the subject of several motions. So far, all of those motions have been denied. And so we're going to take a look. When he's saying she was holding something up to the screen, it seemed that there was concern that she was holding up notes on her jail calls, that perhaps to avoid everyone listening into your jail calls from being able to hear you, because they can't see what somebody on the other side of that video call sees. And so if you're not saying anything, then law enforcement can't hear what you're saying on the jail call. This has been on the docket as what is known as the walk the dog letter. That starts with, walk the dog, but take vague notes so you remember. Sky is saying even if the gummies have fentanyl in them, the prosecutor will say, I tried to put the fentanyl in the gummies so Eric would have them. Stupid, I know, but that's what she's thinking. We will still test them, though. However, Sky was the previous defense attorney. She wants to link Eric getting drugs and pills from Mexico, so we need some kind of a connection. And that letter continues to go on, seemingly to family members, saying this is what we need to tie together. And if this is being held up, then that is potentially a issue. So when they were talking about searching the cell, and when we are talking about suppression of the walk the dog letter, I have a whole video going over the walk the dog letter, but the reason it is called the walk the dog letter is because it very clearly says walk the dog, which is just funny to me, because oftentimes when attorneys, I don't know if this is true everywhere, but when attorneys are saddled with cases that maybe they don't want to take, or they don't think are the strongest, sometimes they are told that they just need to walk the dog. So, telling the witnesses what they need to say is not going to be easy for the defense, because the walk the dog letter is going to be the walk the dog letter coming in to trial is going to be fascinating. Just fascinating. All right. So Bloodworth has comments. Your Honor, I have comments.
Because it's so data heavy.
It is not cursive. It is loopy.
It's fine.
It is loopy
Pause
print.
it for now. Let me just. So before we
And there are
start,
parts of
can
it that are
you tell me,
loopier,
is that you
but
in
no.
the video there?
It is loopy print.
Yes.
And which of those cells belongs to Ms. Richins?
I believe at this time Miss Richins was in 4, which is upstairs.
In fact, it's the
Pod.
top right cell, is that correct?
Correct, yep.
That one that is being pointed to on the screen? All right. And the video camera where's that video camera?
It's elevated. It's on the back wall.
Is that the only camera in that pod?
It is, yes.
And
Next to an observation cell that's in cell 5.
where's that at? Can you,
It is the bottom left corner.
that we can see? Or,
It's-
left corner over there?
Yeah, so that will be just directly in the cell. It won't view anything else.
All right. So who runs the video camera?
What do you mean?
T just got home from school.
Is there someone
Yes,
in
he's rocking a
charge?
Led Zeppelin shirt.
I love this fit.
I know you do. All right, buddy. Thanks for saying hi. Yep. All right. Let me resume playing the questions about the search.
It's on. It's like an ongoing thing. Observation cells can be turned on and off.
Is the video camera run all the time or just?
The main section cell, yes.
All right. And that video camera, as we're going to see in these videos, it freezes a lot. Is that correct?
I believe it is a motion-based.
You believe it's emotion-based?
Yes.
So if it's not,
If there's no movement, I don't believe it records until it senses movement.
all right. We'll talk about that as we look where some of it is where nothing is moving. Who is it that collects the videos?
And yes, if you're asking, was that George? Yes, it was George. Why was it George? Because George follows T everywhere T goes. So George was coming in to get T's attention, and then T and George went out. And yes, PJs to high school. It is apparently the 90s in 2025, and those are the pants that everyone wears. So the cat had to come and claim his human, and T had to talk to me about dropping off his uniform for dry cleaning. So that's what we were chatting about. So yes, that is all the things. So George was like, my person is home. I will emerge now. All right, let's resume the search of the pod.
From that camera?
I believe it is our administrative sergeant,
Who is that?
Sergeant Thomas.
Okay. And is he the one that would have provided the videos
I
that
did
we
too when I
have
was in college.
in evidence at this time?
He probably be one of them.
Okay. Alex, you just play that video. Now, these videos, I think each is about 1:30, but it's an ongoing search, right? They're happen one right after the other. And
He's not wearing slides. Tennessee's weird about toes, but also it's a bit
is this
cold
of
for
the
open-toed
13th?
shoes.
this is the, I believe
So
this
no.
is the
Sneakers.
This is the 14th.
Okay.
I believe. If I'm wrong, please correct me.
There's
Let
probably
me
a
ask you
date
while
on
we're
this
looking
video
at this. So
somewhere,
the stuff that's
Council.
on the tables downstairs, is that stuff that's been taken out of cells, or is that stuff that was just left by inmates?
Without knowing exactly what date of this search, I can't see the date, but
There's gotta be
that
a date
looks
on
like
it
it's indicative
somewhere.
of somebody being in the day room, inmate wise, and then being either locked down or moved abruptly.
Your Honor, if I may.
One moment.
There's got to be a date there somewhere.
You can't see it, but if you were to shrink the video, the date and time are in the top left corner.
Right?
I can't see the top left corner.
The video of the 14th and the time and date stamp are on the video.
Remind me the exhibit number for this one.
This is State's Exhibit 69. All right, so go ahead, Alex. In the video there, you've just entered Ms. Richins' cell, is that correct?
Okay.
That appears to be me, yes.
And she doesn't share that cell with anyone, or she didn't, correct? She was there alone. So what is it you're
So
doing
she
here?
did get a luxury prison. She got her own room. Look at that.
Looking, if this was on the 14th, this would be doing a search and then also moving her gathering up her belongings and moving it down to cell 5.
They're allowed to search your cell.
Oh, that's okay, because she was moving to cell 5.
Correct.
All right. Now, this was after you had already searched for handwritten notes the day before.
Yes, the cursive letter.
Okay. All right, Alex, it's okay. You can, let's go on to the next video, which is State's Exhibit 70. That's number 9. I'm just going in order.
Great. I love it when we just go in order. It's fantastic. So. Rad poker, I did.
Can you close?
Pretty closely at sometimes.
Zoom in a bit, Alex, on the cell so we can maybe see better what's.
He's an incredibly smart attorney. And
Okay,
very
there we go.
funny.
So what is it that you are, all right, there in your hand? It looks like you have an envelope.
Correct.
And is that an envelope that you had looked at the day prior?
I observed it, yes.
But you didn't look in it
Nope,
that day?
not looking at it, nope.
Now, is this the envelope that on the front has Ms. Richins' prior attorney's name?
I believe that would be the one.
Okay. And it says attorney privileged or something to that
I don't recall
effect.
it saying that. I just recall it saying Sky Lazaro, who I knew was.
Writing lawyer on an envelope does not automatically imbue it with properties of being privileged.
Her attorney at the time.
All right. And if a report indicated it said attorney privilege, do you have any reason to disagree with that?
Well, yes, if she's holding shit up on a call.
I didn't see that, so.
You don't recall?
I don't recall seeing that on there. But
Okay. So on this search, you opened that envelope, correct?
yes.
And go ahead, Alex. You can
They've
just
made
play it out
motions
well.
regarding this before.
And what was
They're
it
now
you found
making
in that
motions to
envelope?
suppress regarding
In
this.
inspecting that envelope, there was numerous paperwork. There was obvious court heading, court minutes. There was some, what appeared to be like some cards that were made from children.
Which are not going to be
I didn't observe any
attorney-client
obvious
work.
other contraband.
There were handwritten notes in that envelope,
Yes.
correct? Quite a few, isn't it?
Yeah.
Accurate. There were a lot of handwritten notes. And you looked through those notes that day?
Well, she said it was, in fact, a novel
I'm
that
sorry.
she was writing
I know I'm bad at that.
on her
Let's
jail
try her.
call. She said, I'm writing a novel. Those aren't notes to your lawyer if you're
All right,
writing a
let's
novel.
just go to Exhibit 71, Alex, number 10.
I don't think they ever found Crest White strips. Though the Crest White strips are mentioned in the Walk the Dog letter.
Can you
about-
tell me who the other two
sneaked them in.
individuals are who are coming towards the cell at this point?
It's fair.
That is Deputy Watts, and that
We hope the
is,
cards were actually
Sergeant
made
Thomas
by
in the bottom,
children.
and then the one in the white shirt is our nurse.
All right. Now, were you still going through the papers in the envelope at that time?
Yes.
Can you give us a rough idea of how many pages were in that envelope?
Hundreds.
Hundreds?
It was, yeah.
That's a lot.
So what did you do with the papers that were in that envelope after this search?
After the search, they were put back in as best as I could, back into the manila folder.
And given back to Ms. Richins?
It was left in her property and then put back in her cell when I moved her to 5.
And is it your testimony that none of the papers in that envelope were seized?
To my knowledge.
All right.
Well, at some point they were.
Let's skip to State Exhibit 74, number 13.
Say the date again.
State Exhibit 74.
What was the next thing you said?
Oh, I was just telling Alex what number it was in our
Got it.
list.
Okay.
All right, I think a lot of this is frozen. Let it run and it'll start to move. Now, is that
The Walk
Sergeant
the
Thomas
Dog letter
standing
has
outside the
not
door?
been excluded.
Yes.
What are you doing during this time? Do you recall?
I recall I'm still searching the folder.
All right. At some point during this search, there is a document found that is a 6-page document that is, I believe, at docket number 214, which says walk the dog on the top. Are you familiar with that document?
Yes.
Are you the one that found that document?
I I am not.
Okay. Did you view the document that day?
I cannot specifically recall. I remember Sergeant Thomas, when he indicated he had found it, that was a brief, maybe a brief look at it.
All right.
But did not get a good description of it at that time.
You read that document at another time?
Not specifically like full on, but got more of a briefing from it.
So the documents were in the envelope that you were going through.
Were all the documents
Are
in the
you
envelope?
aware if some of those documents have since been found to be privileged documents?
Are you asking me, were they in that envelope that I
Well,
was
no, right,
searching?
I'm asking you if the documents that you were reading that were in the envelope contained privileged documents.
A, that calls for a legal
Yes,
conclusion.
I wasn't reading them, though.
B, didn't say he was reading them.
Well,
He
you
said
were
he was
going
looking
you said
through to
hundreds of
see
documents.
Yeah.
what was
So
in
you
there.
would have had to have at least read some to get an idea of what they were,
Mm-hmm.
correct?
Inspecting, looking at, the heading on it, like court paperwork to me is pretty obvious, like
Yes.
headings.
Well, there were a lot of handwritten documents in that envelope, correct?
Correct.
And you determined not to seize any of those documents, correct? Mm-hmm. And as you were reading those documents, you determined that
He's not going to determine
some
what
of them
is and is
privileged,
not
you should
privileged.
Stop reading them, correct?
I didn't read them.
Right. He's
Then
not
how
going to
did
make
you
that
know what they
determination.
were?
Just look glancing at them.
Okay.
Yeah, the walk the dog letter says very clearly, take vague notes so you remember.
Let's go to
It's it kind of stands out at you with that heading.
State Exhibit
saying.
75, which is 14.
Okay.
And so right now you can see it appears this is frozen, correct?
No, it doesn't
appears so.
appear to
I
be
see the
frozen.
timer moving in the corner.
I
but
don't
no
see
movement.
Elsa.
All right.
There are no reindeer?
Sometimes it detects, now it starts. So sometimes it detects
not
movement
what we
in the
meant by
cell and
frozen.
other times it doesn't. Is that correct?
To my knowledge, it responds on movement, so I don't know why it would be not moving or not recording.
It looked like it was literally
Is
just
that you on the left side of the bunk?
buffering for. Ma'am,
I can't.
if you are worried about that freeze, I have a case in Massachusetts to talk to you about the video in, because that looked like a system buffer. But I've got some video. If you want to get mad about video, we've got a case for you.
Tell her, are you on the
No, I'm on the right. On
That
the
video
front
buffering, isn't it?
So what is
That's
it
not
that
the
you
one.
are searching at this time?
I believe I'm still
It's
looking
not
at
even
the
inverted or anything.
items in the manila envelope.
All right. And we'll have Sergeant Thomas here in a minute so we can ask him what he's looking at.
Okay.
So I won't ask that with you. So it's still the same envelope that had her former attorney's name on it, Ms. Richins' former attorney's name on the front.
Correct.
All right, then let's go ahead and skip to State's Exhibit 76, which is 15. And if we could zoom in on the corner. Now, what I would like you to take a look at here, this video, it's frozen for some time, but then let's see what happens when it unfreezes.
Let's see what happens.
This
We'll
is
just
15, right?
we'll just watch together. It does appear to be frozen. It does indeed appear.
I'm sorry, it's hard. We
To be
can't
frozen.
pinpoint the exact spot, but these videos aren't too long, so.
Okay. We're all just gonna wait together. He's like, all right,
Just still moving.
great. This is fun for everybody. You guys have some questions. I'm gonna go through some of the questions I've grabbed, because why not? Donnie NIS said, so Fifth Amendment says you don't need to talk to law enforcement. Fourth is when evidence is taken. Fourth is regarding searches and seizures. Fifth, among
All
other
right, the
things,
envelope that's in your hand right there, that's
is
the envelope we've been
your
talking
right
about.
to remain
Is that
silent.
right?
Correct.
They are flipping through pages, it looks like.
And Sergeant
So, yes.
Thomas is looking at some other papers, correct?
Sixth has to do with right to counsel.
I believe so, yes.
Do you know what he's looking at
I
this
do
time? All right, then we'll just ask that to him.
Just thanks, counsel. We'll just ask him what he's doing. Great.
Let's skip to, and I believe
Makes it easy.
16, the entire thing is, I'm sorry, State Exhibit 77. Let's skip to 78.
I appreciate that they're just like, let's go. It's great.
And while we're doing that, let me ask you, so when Sergeant Thomas found the 6-page document that says walk the dog on top, did he tell you about it right when he found it?
He made indication that he thought he had found something.
And did he make indication as to where he had found it?
I don't recall.
Yeah, it's clearly not written
I think he
to
said
his lawyer, to
Could
her
have been in a
lawyer.
book. I'd have to review my report.
I think it might have been in a book.
Go ahead, that's.
Because we did motions on this, but it was quite a while ago. But
I think when this eventually unfreezes, it's going to show you carrying a bin down the stairs.
it says, hey, Sky says it's clearly not directed to the lawyer. It is telling a third party what the lawyer said, which necessarily means it is very much not privileged at all, because once you start sharing that information, it is no longer privileged, amongst other things that are an issue with that letter. But also
Do you get occasion to look at these videos very often?
jail call saying it was a novel.
Do you get occasion to look at videos from that camera very frequently?
Yes, I have the capability to review video.
Is it always these large gaps where nobody's moving?
If there's nobody moving, it won't record.
Are there these
Well, are
gaps
there
when
always
nobody's
gaps
moving?
where- I mean, you are
Yes.
moving in the cell, and it
When
comes
nobody's
on and off. Is
moving.
that how it always is, or is this unusual?
Ma'am,
I haven't come across.
if he's moving in the cell out of frame, then how does the video know he's moving in the cell because he's out of frame?
A situation like this
So this is the first time you've seen big frozen gaps.
with
where-
the timer moving and no movement. Yes.
So you're now walking downstairs with a bin.
Yes.
Now, did you put everything in that bin yourself, or was that stuff that was already in a bin in her cell?
I gathered her items up. Yes.
I don't think she had a bin in her
there
cell.
was items in there, but all her items in her cell I did gather.
So you
'Cause
put
they were
those all
moving
into
her.
the bin.
It may not have been all of them, but I put some in them. There may have been items in them
He's going to be very
in
precise
it already, but there was stuff added to it for sure. Yes.
because they're moving her cell.
Are you aware of a book she had in her cell that was an LSAT study prep book?
Not at that time.
You
think
weren't
it's
aware of
there.
it at that time?
Correct.
So you aren't aware if that is something you put in that bin?
No, I wasn't aware of what.
All right, what was your involvement after this in the rest of this search, after you searched the envelope?
To gather her items up and move it to the cell that you saw me move the box to.
All right, did you personally seize anything from the cell during that search that was?
I did not know.
So you didn't take anything out of the cell, everything was put back in the envelope or in the bin and moved to her new cell?
Correct.
Okay, I just have one moment.
Okay. Yes, for all of you saying, I love that he's just very
I don't
neutral
have
in his
anything
answers.
further
Yes.
from Sergeant.
He's like,
Sergeant
there's
Barrett.
nothing I did wrong. No need to be defensive. Just answering the questions you ask me, which not everybody can do, because even if you know that, there are people who, when questioned, are still going to be like, wait, what?
Sergeant Barrett, you're familiar
It takes
with what I mean when I say the
effort.
walk the dog letter, right?
We're on cross?
Yes.
Docket 214, but every law nerd on the internet calls it the walk the dog letter.
I'm sorry, Mr. Bloodworth. What did you say?
When you searched,
Mr. Bloodworth. Mr. Bloodworth. Sir? Mr. Bloodworth. I would like to know exactly what you said. Because, Mr. Bloodworth, yes, we do all call it the walk the dog letter. So, yes, Law Nerds chat has made the hearing. But I think we're going to need to back that up a minute, because Mr. Bloodworth, sir, tell me you're a law nerd without telling me you're a law nerd in court. Because yes, sir, we do in fact refer to it as the walk the dog letter. For all of you saying one of us in the chat, right? Mr. Bloodworth, there it is, sir. I mean, motion granted, Mr. Bloodworth. We got to back up just a little bit. Mr. Bloodworth, you're right. We do.
Sergeant Barrett, you're familiar with what I mean when I say the walk the dog letter, right?
Yes.
Docket
It's
214, but
such
every
a
law nerd on
moment.
the internet calls it the walk the dog
I
letter.
was talking over it. I rewound it and then kept talking. Naturally.
With what I mean when I say the walk the dog letter, right?
Yes.
Docket 214, but every law nerd on the internet calls it the walk the dog letter. When you
This poor
searched,
witness is like, what the fuck are you asking me? Law nerds. Mr. Bloodworth would like this officer to know that all the law nerds on the internet calls this the walk the dog letter. And we do. Do you know why we call it the walk the dog letter? Because at the top it says walk the dog. Any good law nerd would have known. I mean, we're going to have to clip it with Elle Woods saying any Cosmo girl would have known. I mean, any law nerd would have known. Y'all, I don't think I've ever seen the law nerds referenced in court before, but here we are. I mean, I've ended up in filings before, which, happens if you talk about cases on the internet. But the name drop of the law nerds in this hearing was unexpected, and somewhat hilarious. Chat, the probability that they asked directly about YouTube and voir dire is so high at this point. So with all of that, Mr. Bloodworth, we appreciate being seen. We see you too, sir. We respect you, and we like your questioning style. So law nerds unite, law nerds, because we're gonna rewind it we're just one more time. Just one more time, Mr. Bloodworth, because we have to. I feel like it deserves applause, right? Mr. Bloodworth, you're right. The walk the dog letter is a thing. It is. The walk the dog letter is a thing. It is.
Sergeant Barrett, you're familiar with what I mean when I say the walk the dog letter, right?
Yes.
Docket 214, but every law nerd on the internet calls it the walk the dog letter.
We do. Facts.
When
That is
you
a fact.
searched
The witness
Manila-
didn't even answer. The witness was just like, Docket 214, law nerds. Any good law nerd would have known.
envelope marked with Miss Lazzaro's name.
Oh my goodness.
Did you
Chat said rewind it one more time. All right,
see-
chat, motion grant one more time. And then we're just being self-indulgent. I mean, maybe a little bit. Did I know this was coming? Yes, I did. Because A, we knew it happened in this hearing. B, a number of you called it like immediately. And C, we actually were able to clip this and share this in the app as we were getting ready for this hearing, because it was clocked by Team Baker IRL when listening into this hearing. And the way gasped, gagged, shooketh, all of the things. But the law nerds are ready.
Sergeant Barrett, you're familiar with what I mean when I say the walk the dog letter, right?
Yes.
Docket 214, but every law nerd on the internet calls it the walk the dog letter.
Yes, every law nerd on the internet.
When you
Every law nerd on
searched
the internet.
Manila envelope
There's no
marked with
no
Miss
telling us
Lazzaro's
we're not
name.
internet famous now.
Did you seize the walk the dog letter?
I did not.
In the videos that Miss Nestor just showed you, when you're standing at the foot of the bed, are you going through the hundreds of pages in that manila envelope at that time?
I was, yes.
let's talk about the size
I'll
of the
ask
bed
my
real
kid.
quick.
I don't think
Is
he's
it a normal,
he's going
say,
to be
6.5 foot-ish bed?
excited about it.
Correct. Metal bunk, yes.
So when you're at the foot of the bed and you see Sergeant Thomas in the video at the head of the bed, he's about 6 feet plus away from you. Is that correct?
I would say that's accurate, yes.
So look, Mom, we made it.
Thank you.
Can I ask one follow-up?
Sure.
Did you actually see Sergeant Thomas get what is known as the walk the dog document?
I did not.
Him sees that.
I did not know.
I mean,
So
you
don't
guys,
know where that came from, basically.
I think that Bloodworth is a law nerd. And B, I don't think it's a coincidence that the judge, when he referenced YouTube, particularly referenced YouTube channels with my exact subscriber count. So I feel like it's not a coincidence because the last time that happened, the judge was like, you know, YouTube channels with like 803,000 subscribers. I'm like, y'all, are we at because we're at 803,000 subscribers and it's an awfully specific number. So yes, docket number 214 is now the official law nerd code, but it has been referenced more than once in this trial. And, you know, we have been respectful. And that is what I love about this community, because we are going to continue to be respectful, but also we are the law nerds and we are amused.
Based on your own knowledge.
Correct. I do not know.
Sergeant Thomas also looking
amused.
at the envelope?
I did not see him look at that envelope.
I don't have anything further.
May
don't
we
have anything
release this
further.
witness?
Yes, and we would call Sergeant Thomas.
Nothing further.
You may step down, sir.
Thank you.
All right. Well, Bloodworth got in a law nerd shout out and then this witness is done.
Not the first ones, but let's see. Probably start with
The law nerds know, man. Chat is bay.
probably. Start with 11, that's
Your
where it
Honor,
goes.
while they're waiting, can you confirm that the videos was 69, 70, 74, 75, 76, and 78?
I don't know that we played. Did we play 78?
I think so. That was the last one.
That was the last one where
Sure.
Sergeant Barrett was carrying.
Okay.
Okay. Sounds right.
Perfect. Sarah H. in the
Thomas,
chat
would
said,
you step in front of Brittany? We'll get you sworn in.
this feels like getting a radio shout out in the 90s. It really does. It really does. It's you know,
Please raise your right hand.
it's its own moment.
Do you solemnly swear
So-
the testimony you're about to give in the matter before the
You
court
know.
to be the truth, the whole truth, and nothing but the truth, subject to suits and penalties of
Look,
perjury?
it's not hard. It's really easy to figure out what gets into the law nerd's good graces. Look, there is a snappiness to writing and a sassy footnote that we love, but ad nauseum, hyper dramatics. At some point, you get to this level of hyperbole is not helpful. Direct and clear questioning. You know, really, it all boils down to the law nerds stand competence and a little bit of sass, a little bit of humor, a little bit of we don't take ourselves too seriously. We do not take well to being talked down to. The condescending lawyers are going to get under our skin all of the time, and word salad questions are going to lose all of our focus and make us want to stop listening immediately because our ADHD is going to gallop off in a different direction. So really, competence is our base level, and then we go from there on our level of standum, depending on the sass and the rest of it. But competence, we really over and over again, competence. It just is what we're excited by. You know, no need to be too dramatic, but I mean, a little bit of drama we're not going to get mad at. A sassy footnote is always well taken. And, you know, it doesn't help that the judge is just so, in this case, he is patient, he is respectful, but also will clarify, like when stuff starts getting off the realm, when we're out of the realm. Yes, when we've entered other realms. When stuff starts getting off the rails, this judge just brings it right back and is just like, let's just reset for a minute. I love it so much. Where are we all at? Can we keep moving? Can we move it along? Just love it in a different way than I love Judge H in Utah, who is dry, maybe a bit less patient, and much more of a appellate judge. Very different styles, like them both. So, you know, love it. Loved Judge A. Judge A had a very different demeanor with the attorneys and kept things moving. It was fantastic.
Good afternoon. Could you state your name for the record, your full name?
Jeremy Thomas,
And where is it you're employed, Sergeant
All
Thomas?
right, Sergeant
Summit
Thomas.
County Sheriff's Office.
And what is your
Braxton.
position?
The administrative sergeant over the jail.
Oh, everybody's in the
Can't lean a
twirly
little bit more
chair.
into the microphone.
Yeah. I'm
No,
the administrative.
because
Do you want me
then
to repeat it?
We can't
No, but just going
twirl
forward.
if we
Thank you.
scoot in.
All right.
We want to spin in the
So
spinny chairs.
you were involved in a search of Ms. Richins' cell on September 13th and September 14th, 23,
Correct.
right?
Oh, absolutely.
What happened to initiate
He was very
the
patient
first
with the
search on
lawyers.
September 13th?
Did not rein them in.
The first search that I was involved in, or the
Or were
one
you
prior?
involved in all of the searches those 2 days?
Wasn't. I was only involved in one search.
Which search were you involved in?
I believe it was the second search.
On September 13th?
Yeah.
All right. And what initiated the second search on September 13th?
Your Honor, we have a date confusion.
We have a.
Thank you,
Mr. Bloodworth.
Depicted in the video was involved in the search on.
Mr. Bloodhurst, like, we have a date confusion. Can we just please clarify?
So the 14th.
So you were only there for the search on the 14th. All right, that's fine. So the search on the 14th, what was the purpose of the search on the 14th?
There was a discussion about a role violation that Ms. Richins had engaged in over holding a letter up during a video visit.
Can't do that.
So we were attempting to locate that letter.
Okay, so again,
What
I don't know if we
information
have
is
the dates
being
confused
passed?
now. You were involved in either search on the 13th.
Negative.
Are you aware of the searches on the 13th?
Affirmative.
Vaguely. I don't know the details of it.
All right. So is your recollection that the second search on September 13th was looking for the letter that was held up to the video?
I'm not aware.
You're not aware?
I'm aware of the. I didn't see the incident, but I'm aware that she had held a paper up during a video visit.
And you're aware,
And
or
that's
are
a
you
rule
aware that there
violation.
was a search on the 13th to try and locate that paper?
I believe, yes.
And it wasn't located, correct?
Yes.
And just, that paper turned out to be something that was not related to this case or even contraband, correct?
I wouldn't know.
You don't know?
I didn't see the letter. The letter was never found, so I don't know.
Okay. So the letter was not seized from the cell?
No. As far as I know, the letter that she held up was not seized.
All right.
Right.
So now September 14th, the search on September 14th, that was of the entire pod, correct?
Yes. Or the one that I was involved in, yes, the whole pod was.
The whole
searched.
pod. So the purpose of that search was not just to search Ms. Richins' cell?
Negative.
It was to move Richins and to
search the
search
whole unit.
the pod.
And were you looking for anything specific in that search?
The main goal was to find that letter that she held up.
Right.
That
to
had
figure
not been
out
found the day before?
what
not-
was
All right.
held up.
Okay,
Because rules.
let's go
rules.
ahead and put on State's Exhibit 72 again. Now,
Videos. More videos.
11.
What?
Alex, one moment, please.
Where were we going?
And
Okay.
Now, before we get started, let me just ask you, on these videos, are you the one that collected these videos for evidence?
Yes.
And tell me how that process happens. How do you collect those videos?
You go to the camera and
Sir, are you telling me there's a process beyond vibes to actually preserve video from a search at the time that it's requested if it's going to be an issue? There's a procedure for that. Good to know. Good to know.
on the computer and then just download it onto a flash drive and then submit it into evidence.
All right.
We just
And
save
have
it
you
into
had
evidence.
occasion to look at the videos of this particular search on
What?
September 14th before today?
Wild.
I have seen it before, yes.
So you're aware that during these videos, the
He's like, right, we
the
just
video freezes
save it.
a number of times for
Evidence.
lengthy periods.
Yes, it could. It's motion activated, so if it doesn't detect motion, it would probably shut off.
Okay, let's go ahead and play this. Now that's
So
you
weird.
standing outside of Ms. Richins' cell up on the far right of our screen, correct?
Yes.
With your back to the camera.
Yes, ma'am.
And gloves.
And what is going on in the cell at this time?
Sergeant Barrett is in the process of searching some documents at the foot of the cell of the bunk.
And those documents were located in an envelope, correct?
I have no idea. I wasn't paying attention. He would have
He's
been
like, he's
blocking
doing
my
it.
view of what he was actually searching.
All right.
So I'm looking at his back.
So at this time, you're not clear what he's going through, just that he's going through
Things
documents.
and stuff. He is doing things and stuff. So things and stuff. And we went over that with the other officer.
Now, okay, oh, it looks like it's moving again.
Excuse me. Oh, for the yawns. It's riveting. I know. The riveting moments in court.
All right, have you up to this point been in her cell at all?
No.
All right. Let's go ahead and move to
the next one.
Number State's Exhibit 74.
It's
13
not labeled
for us.
cell block tango, chat, just cell block B. Which is probably, an accurate description, but I always want to know what people
You go
label
ahead and
things
hit play.
after, particularly after the Rust Armorer trial.
Okay, so let me ask you, if this is unusual based on your experience, this is playing, but it appears that it's either frozen or you're standing very, very still.
Yes.
Yeah. I couldn't tell you.
So
I can do
my
that,
question
ma'am.
is,
I
though,
can stand very still.
Have you seen videos typically where there is movement, but it's freezing like this?
No, it's not typical.
This is unusual. All right, I think let's watch until this unfreezes.
I have some unusual to talk to you about, counsel. We're going to watch till it unfreezes. Okay. They've argued multiple times that the walk the dog letter should not come in. They're going to argue it again. I don't know if this video helps with anything. So we'll see. We're just gonna wait for it to unfreeze altogether. Fantastic. That's
It does
delightful.
unfreeze eventually, I promise.
It's great.
I think.
It's great. It's just.
There we go. So
Colleen, thank you for the
that's
5
the
gifted
first time you go
memberships.
into the cell.
Correct.
And are you now looking at
I know we have
what?
others we need to thank for gifted memberships.
Can you
as
pause
well.
that, Alex, right there?
Just because. Thank you. Melanie, thank you.
Zoom in.
Welcome to all our new
You're looking
members.
at what Sergeant Barrett is looking at this point.
We're going to do some member
Well, you
stuff
can see
tomorrow.
what he's looking at. Let me put it that way.
Yeah. I could see. I'm not paying attention to what he's doing.
All right, but you, I'm sorry, I didn't mean to talk over you. Were you finished?
Yeah.
You have an envelope in your hand.
Yeah,
right
I'm
there,
just not
correct?
paying attention to what he's
I
doing.
can't tell what it is.
Right. Do you recall? Well, let's
just-
take another look.
He's
You
just
still
like,
aren't sure what that is?
"All right, sure.
Do you recall seeing the envelope
Sir, are
in
you
the
paying
cell
attention?
that
Nah.
said
Just
the
making a
name
grocery
of
list in my head.
Ms. Richins' former attorney on the front of it?
No.
So you don't know what that is that you're looking at right there? It looks like an envelope, right?
I can't tell what
what
it
is
is.
happening?
It looks like there's papers, yes, but
Okay.
I
I've
don't know if it's
activated
an envelope
something
or
in
not.
my office.
I don't remember touching an envelope in the cell at all.
He's like, yeah, I don't know. Sorry, that was me. Something happened.
So tell me what you did after this point, if you recall.
So my recollection was there on the top bunk, there was papers and books on the top. So I figured I would start searching in that area because we were looking for the document. I remember flipping through some pages on the top, and then there were some paperback books on the top bunk and the LSAT book on the top bunk. And
Were there any
Second
apple
for
bottom jeans?
1 minute, let me just, a couple of clarifications.
Or boots with the fur?
So on the top bunk, there were, you said pages.
yeah, it was nothing of significance. It was like, I couldn't even tell you what they were. They were just
Papers.
letters, or like it was nothing that stood out to me.
Sir, how
so.
dare
All right.
you? It's a
Were there a lot
novel.
of pages, though, on the top bunk?
There was a few. I couldn't tell you how many, but yeah, it was scattered paper on the bunk right
It's
there.
a novel, sir. It was
on
a,
the bunk or the book? I'm sorry, what did you say?
On the metal part of the bunk. And then there was some books off to the side, and then there was the LSAT book on the top of the bunk right there also.
So the book was on top of the bunk?
Yeah.
All right. Let's go ahead then and look at some of these videos, because I want to see if you can point out to me.
the Walk the Dog
where
letter
you
was
might
in the
be
LSAT
looking
book,
at the
not
books.
the
So that was number.
envelope that they were previously talking about. That's why they're
What
going
was that,
into
Alex?
the
We just played.
area of what's in the LSAT book.
All right. I guess let's do State Exhibit 75. And again, this is another one that is frozen on and off.
Which number is it?
14. And if you can zoom in, Alex, up there.
We're looking for fetch, chat. So if you
And then-
see fetch in the cell, let me
Frozen
know.
or is it
Because
stopped?
we're looking for it. We're searching for fetch.
All right, so we can't see what is, oh, there we go, it's moving.
Oh, Allison, I don't doubt.
So at this point,
Kouri's
you are looking
at
at some papers,
learning
correct?
more about law while she's in custody. I don't doubt it.
Sorry, could you answer out loud?
Correct.
I don't doubt it at all. The twist I don't see coming, though, is if Kouri ever tried to say, and now I am my own attorney. That I don't see coming in all of this. But yes, there was an LSAT book in her cell.
Sergeant Barrett just had an envelope. I don't know if you saw that.
I did.
However, it probably keeps her engaged in what's going on, which is at least productive, but I don't see her.
So again,
representing
even though there's
herself.
movement, the camera or
not
the
be a
video
good
is
idea.
frozen at this point, correct?
It would not be a good idea at all.
Appears to be.
But we don't see you looking
She's
at
just
any
asking
books,
questions that
correct?
are obvious, and the sergeant is like,
Not at this moment.
Yup.
On
yup. Sure. Mm-hmm. I'd be spinning in my chair too.
I think this unfreezes again. Oh, that was the end of it?
It's been the end of it for a minute.
All right, let's go on then to the next one.
Mr. Bloodworth is like, we've been
Yeah, it's
done.
hard to keep track of where it starts and stops.
Kind of like those reels that repeat where they loop so well, but
right,
the
let's
end
look
and
at
the
number
beginning are
15,
just, you know.
Which I know a lot of this one's frozen too.
Goody.
But I do think it will pop on in a moment. So really what I'd like you to look at here, Sergeant Thomas, and when this unfreezes or freezes, if you can point out at any time you are looking through books up there.
He's like, I don't know. I can
On
see
the
the back
top.
of my head. Oh, no, wait. He's in the khaki pants or the tan pants. Can you see, sir, when you're looking at a book? He's like, I'm standing there? Did anyone see the fetch happen? I'm sorry, I looked at my phone for a minute. My bad. Okay.
Or I think it's moving now, if you could. Goody. All right, now you have something in your hand. Can you zoom in on that,
I would
Alex?
say right there is where I'm in a book right there where I'm pulling.
Well,
I would think. It's hard to
yeah, it is. It actually
Yeah.
looks like you're going through some papers, doesn't it?
Well, counsel, you asked him a question and he answered it.
I was only in the cell for a couple minutes before I found the letter, so I would say it would be within the first couple minutes of being in there.
There's no,
So your testimony is
there is no contradiction. I don't think that this was found in the cell. And none of their hair is full of secrets. Maybe the beards are full of secrets, but none of their hair are full of secrets. I don't think there's any controversy that this letter was found in the cell. I don't think that's contested.
She found it where?
On the top bunk, right where I'm standing. That's the only place in the cell I searched.
So you only searched on the bunk, all right.
It
And where was it on the
in
bunk?
the cell?
In the book, right where I'm standing.
But all of that is, none of that can be seen on the video. That's all frozen when that may have happened.
Sure, it looks like I have the letter right now, as far as I can tell.
So you have papers in your hand right now. We don't see the book, correct?
Correct.
And those papers are the pages that everyone now calls the walk the dog document.
Yes, everyone.
Correct.
Any good
Those
Leonard would have
pages, when
known.
you found them, they were glued together or stuck together as if pulled out of a notebook, like when you tear a chunk out of a notebook and papers are still together on the side or on the top. Is that correct?
I don't recall.
Did they have like binding on them?
I mean, I remember flipping through them, so, but I don't remember them being secured to each other in any way.
How many pages were there when you found it?
I believe there was like 8.
There were 8.
8 or 9 total pages.
The walk the dog letter
Maybe been 6. There was a letter, and then it was like a.
The walk the dog letter is
like
6.
a checklist after, so I couldn't tell you exactly how many pages there were.
And the walk the
All
dog
right.
letter has
How many
pages written
pages were
on it
turned over
at the
as-
top.
and are part of now what are the walk the dog pages?
All of them.
Well, now actually, and this is, I'm not entering this now, but this is the letter. It's already on the docket, but just so he can refresh.
Docket number 214.
So if you could tell me how many pages.
1, 2, 3, 4,
She numbered them at the top.
6.
They are actually numbered.
But there were 7 or 8 pages. Well, there were 8 pages, correct?
Correct.
All right. So
Not everything was
I think there were
docketed.
9 pages. Did you take all 9 of the pages at that time?
I did.
Counsel, do you not have them? Don't you have all 9 pages? We don't. They weren't all
So when
docketed.
you saw these pages that
Only the walk the dog letter got docketed.
were in a handwriting,
Because there was an issue with
you
a
read all of
motion
them,
regarding
right?
witness intimidation.
I read most of the document on my way out of, because once I verified that there was something in there of concern, then I was taking them out of this section to take to my supervisor.
so the very beginning of that, in front of you, the first couple of lines, and you can just read it to yourself right now,
Okay.
I can read you the first
is
couple
about
of
a
lines.
conversation between Ms. Richins and her attorney, correct?
No, it's... Well,
No. It's saying she's referring to this guy as the third person.
it
Correct.
could...
She's talking about something that her attorney told her, correct?
Correct.
All right. So as you started to read this, you immediately saw that she was talking about something.
When your attorney tells you something and then you tell a third party, it's no longer what? Privileged. It's no longer privileged. So my lawyer said isn't going to be privileged anymore. Also, the beginning of the walk the dog letter says, and I'm reading it off of the screen before we return to this, walk the dog, but take vague notes so you can remember. Asterisks. Sky is saying, even if, underlined, the gummies have fentanyl in them, the prosecutor will say, I tried to put the fentanyl in the gummies. Once the sergeant sees the word prosecutor, I imagine that his spidey sense goes, huh, what are we telling people? What are we saying? What are we saying? The prosecutor will say, I tried to put the fentanyl in the gummies so Eric would have them. Stupid, I know, but that's what she's thinking. We will still test them though. However, underlined. She wants to link Eric getting drugs and pins, drugs and I think it says Pins, something, P-I-N-S, it looks like, from Mexico. So we need some kind of connection. Her private investigator is doing some research on the ranch/cartel place Eric would stay at. Here's what I'm thinking, but you have to talk to Rodney. He would probably have to testify to this, but it's super short, not a lot to it. So I think he would probably have to testify to this, is going to also raise some spidey sense. But that's just me.
Between her and her attorney, correct?
Correct.
But you continue to go on and read it?
Correct.
She's telling us.
So I scanned the document.
Party.
And then
about what her attorney said. That's not privileged.
Fairly quick, she talks about basically what she's telling her brother to say.
Well, I understand that's what your interpretation of the document is, but let me back up a little bit. So when you come
appreciate that
across
you have a job,
documents
counsel.
that are privileged, do you typically go on and continue to read them?
That document's not privileged.
They weren't marked as privileged.
When you come across documents about an individual's case that they've written,
We scan those documents, yes, to look for safety.
Ma'am, you are not new. You are not new. You are not new. You are not new. And you are doing your job, and I appreciate that you're doing your job. But the amount of shit people say about their case that is not privileged from custody can have varying levels of impact, including physical safety concerns and impact. So no, ma'am. I appreciate your efforts.
Safety security threats.
you scan them or you read them?
Scan them. Or you read them until you determine.
Emily, keep listening as he goes, yes, we scan them for security threats. Accurate. It's a large part of the reason people listen to jail calls is to listen for security threats, though sometimes people also say where they've hidden evidence or left things or who they've left things with, and that can be helpful as well.
Documents about an
Among other
individual's
things.
case that they've written.
We scan those documents, yes, to look for safety security threats.
You scan them or you read them?
Scan them. Or you read them until you determine that it's a legal document when it's a handwritten letter that's not in a legal folder or anything like that.
Now, you refer to that as a letter, but is that a letter addressed to anybody? Does it say dear
The dog.
somebody at the top?
Dog.
No, not at the
Chloe.
top. At
It
the
was
back
written to
of it,
Chloe.
it clearly is addressed to her mom.
Well, wait a minute. Let's clarify here. Addressing a letter would, there's no...
Or Bubba.
Oh, sorry.
Bubba would never.
Go ahead, Mr. Bloodworth.
I got questions about
Like all
Chloe.
the other documents.
Bubba would never.
It says what it says.
No,
We don't
let's
need
read it.
A quiz on what it says.
Are there questions about why Sergeant Thomas did or didn't do whatever he didn't do next that you need to ask?
There is, and it's laying foundation for argument that will be made in the briefs.
If you need to ask questions about what he did or didn't do, that's fine.
Well, I think it's important to clarify, for purposes of argument and privilege, whether or not this document was
privileged.
obviously a letter.
Well, but you can
Argue
candidly,
that.
I don't care whether he thinks it was obviously a letter. I can address and I have to, under the law, make an objective determination of that. If you want to ask him why he did whatever he did or didn't do next, that's fine.
Okay. All right. Well, can I get an answer to the first question?
The court's like, I have to ascertain if the letter is privileged or not. And I've already had to address that issue multiple times in this case.
there a salutation on the letter to somebody?
No.
All right. But you continued to read it
Correct.
anyway. And it's not signed on the bottom by Ms. Richins. It's not Love Kouri on the bottom, correct?
I would have to.
Well, go ahead. and take
Don't
it.
worry, I'm
Ms.
scrolling
You
too.
just ask the next question. I'm going to move you along.
I'll tell you. Wait, Chad, I'll answer. It says, you're the best mom in
Was
the
there
whole
an
world.
envelope with that?
Wait, at the end, it says, wait, what does it say? Oh, no, here's the last paragraph of the letter. Hold on. I think we all just need to, Emily, share with the class. I know, it's so rude. If we're all going to talk about the letter, we're just all going to talk about the letter because the judge isn't going to let him read it in. And we need to go to the end of the letter because obviously we need to talk about the letter. Will you buy a box of Crest White strips, open them up and put them in an envelope and have Sky give them to me? You can tell her what's in the envelope. I'm sure she won't care. Inaccurate. Wrong. Your lawyer doesn't want to smuggle contraband into custody for you. I'm sure she won't mind. She'll mind. No, she'll mind. She doesn't want to do that. You can tell her what's in the envelope. I'm sure she won't mind. I'll make sure they can't be found in my cell. My teeth are yellow from so much coffee and tea all day. I love you. I love you. I love you. Hang in there. We're getting there slowly. You're the best mom in the whole world. I'm so lucky to have you. Tell me again that this is a letter to her attorney counsel. Tell me again. Tell me again who this letter's to. She's talking about smuggling things into custody with her lawyer. I'm sure she won't mind. Wrong. She will mind. Hey, T. Okay, glad you're back. Oh, that's why George is here. George is here because you're here. He's just following you around the house. Glad you're home. Did you get it all dropped off okay? All right, we're going to finish up our hearing. It is. George is just leaping into Travis's arms because Travis not holding on to him was not an option. All right, thanks, buddy. Yes, take them with you. We're going back to this hearing, but tell me again how this letter is privileged. If your answer in the chat is no, then you would be correct. You would be correct on that. Did she sign this letter? Love you, love you, love you. You're the best mom in the whole world. Okay. Sure.
To mail it?
No.
Sure.
Were there any letters in her cell that were ready to be mailed out that you found that day?
I don't recall any. This is the only letter I remember. This was the only letter of significance that I felt was a violation of rules and a safety security threat.
All right, and it was attached to 3 other pages that were just notes, correct?
Yeah, it was just like a checklist it appeared to be a checklist. I couldn't really tell you everything that was on it on the last 3
Crest
pages.
White strips.
Check. Okay, but it wasn't part, you didn't think it was part of the first 6 pages?
Yeah, I thought it was part of the actual document, yes.
All right, are you aware that
If the question starts like that, the answer is probably
was
no.
found to be privileged by the taint attorney in this case?
No.
You're not aware of that?
No.
All right, do we need to introduce her? Maybe we should just introduce this. One moment, I'm sorry, Your Honor, if you'll indulge me. So this is, where's the one where he says it's privileged? 6 pages.
We can make that.
I'm going to zoom. They're just talking about the letter.
Okay, Your Honor, I just want to exhibit 158 for the record. And this is not a document that this witness would be familiar with, but I don't think I have any objection from.
What is it?
This is a letter from the taint stating that the 7th page of this document.
A letter from the taint attorney can just go to the judge. A letter from the taint attorney.
Of course, read that letter is that the first 6 on.
Why? Either way, I don't have the 7th page in front of me, do I?
No, you don't.
No, you don't. I can get it to you and we can submit it, but it was determined to be privileged, so the government doesn't have that either.
I've not seen it.
Okay.
Because the taint attorney took it.
Sure, I'm never going to rely on this, but we'll mark it.
Oh, yeah, I just want it for the record that.
Okay.
The judge is like, sure, I'm never going to rely on it. The taint attorney said it was privileged. It might be a list of things her attorney told her to talk about or think about or whatever. It might be a list of things she wants to tell her attorney. That's a different thing than the letter, but the taint attorney gets to make that determination But also, the taint attorney determined that the walk the dog letter was not, in fact, privileged.
This was found with were
It's been offered.
privileged.
Bloodworth is
Okay.
like,
158 is offered.
Bloodworth is like, do I need to go
Now,
on?
you said you don't recall if they were glued together at that time.
Remember them being glued together, no.
All right, then if I could just also offer, I guess this would be Exhibit 159.
When she asked earlier if they were glued together, she was trying to say if they were pulled out of like a notebook and they still had the like binding on the side of a notebook together versus a notebook pulling across at the top, because she indicated the side, but I don't know. She's just, Bloodworth is just like, are we doing, we don't need to do all of this. Can we just, Bloodworth's like, can we just, this is all on the record. Can we just move it along? Bloodworth's sitting there going, counsel, I like to move it. I like to move it. But they are doing their job. It is their job to do. They can only work with the facts they have, and you can't tell your client not to write stupid shit after they've already written stupid shit. It's not, you can't put that shit back in the horse. You can't, at this point, unwalk the dog. And it seems like the strongest argument they had, the state already conceded, because the state was like, right. Yep. I'm going to zoom until we get...
Sorry, Your Honor.
Yay,
After
back into questions.
discussing this with Mr. Bloodworth, I'm going to move ahead.
Lovely. And again, the defense attorneys don't get to choose their cases. They were assigned to this case. They don't get to choose whether their client gets prosecuted or not. They are playing the best they can with the cards that they are dealt, and there's only so much they can do with the cards that are dealt. You can't go back in time and unring that bell. It seemed that Skye tried to. She emailed law enforcement and said, do not talk to my client. I imagine she told her client the same thing. That would logically make sense, but you can't forcibly make people stop talking because they think they're going to help. And helping's not going to help.
The only thing that was taken from the cell was this 8-page, 9-page document, correct?
Correct.
And what did you do with the document after you took it from the cell?
I took it into the jail commander and explained the contents of the letter to him, which then I was referred to take it to the county attorney's office to verify if it was a legal document.
I'm sorry, can you leave more? I didn't hear that last part.
Then to take it to the county attorney's office.
The jail commander and discuss the contents with him, and then was referred to the county attorney to determine whether it was a legal document or not.
All right. And it was determined this is not the document that was held up to the video camera when Ms. Richins was visiting her mother that you were originally looking for, correct?
Correct.
So this is a different document that you took out of the cell.
Correct.
All right. And then the rest of her belongings were put, or I don't know if the rest of them, a number of her belongings were put in a bin, correct?
I wasn't there when that happened.
I think you were, actually. Why don't we put on video
Great.
Exhibit
Good.
78 again?
Are we doing this to refresh his recollection?
Yes, but it's in evidence. I mean,
It speaks for itself. Was he there?
Are we gonna
Was he
ask more
not
questions
there?
about the bin, or can we move
I
on?
want to ask him what, yeah.
What's in the bin that you don't remember ever seeing, sir? I don't know. I never saw it. Great. The judge is like, do we really need to talk about the bin? I'm going to zoom.
We're in the cell.
Oh, jeez.
Oh.
All right. So you are in the cell when Sergeant Barrett takes the bin down, correct?
Correct.
And Alex, if you can back up more from where he comes from. Now, he comes from behind the door, correct?
Correct.
And those belongings
Sentence
are
could have gone a
things
lot of
that
different
were behind
directions.
the door, it appears, correct?
Correct.
But isn't that where the LSAT book is in that bin at this point?
He's like, I don't know.
I wouldn't know. I was looking at the document the whole time, so I don't even recall him taking that bin out.
Do you recall coming back?
You can see his gloved hands in the cell. That's it. Gloved hands in the cell. And the other one taking down the box and then back. He's like, I'm in the cell going, what is this? Right, because the T in the letter is substantial. Like the letter goes on to talk about what her family needs to say and how they need to be careful about reminding each other what to say. Like the T gets scorching quickly in the walk the dog letter. So I'm not surprised that he's engrossed and like, wait, what now? While the other deputy's doing whatever.
About an hour later to take pictures of the LSAT book?
I do.
And where was the LSAT book when you took the pictures of it?
I believe it was down in that property down there.
It was in the bin, correct?
Correct.
And did you take that book out of the cell and put it in the bin?
No, I don't know if Barrett must have grabbed it or if he grabbed it later and put it in there or if he grabbed it like while I was reading the letter.
Ma'am,
that be
the
on
tea
the
was
video?
hot.
If he put more things in the bin?
Yeah, I'd imagine.
You'd see him walk back down.
All right. Your Honor, you'll have the videos. So he doesn't recall. I don't want to just sit here and show every video. But
To be clear, I don't know how many of these there are, but I'm not going to watch all of them unless you have determined that one of them is relevant.
I'm not going to hunt for evidence for you,
You can
counsel.
just proffer which one you want me to watch.
She doesn't know.
I'd like to proffer a negative. There is not a video of anything else being put in the bin after we see the bin coming down the stairs.
Fair enough.
So, and there's only a few videos after this. But so there is a video though of you pulling the book out of the bin, correct?
Correct.
And taking a picture of it. All right.
Thanks, Your Honor.
Let me see.
Appreciate it. Are we continuing? Okay. Counsel, can we just?
We don't have anything further.
Oh,
Thank
goody.
you.
Mr. Bloodworth, any redirect for Sergeant?
You could hear the voice. The judge is like,
Yes, Your Honor, thank you.
any redirect? Briefly?
Mr. Ramos, rather than switch computers, can I get you to bring up a video?
Yeah.
You bring up video 84.
84?
Yes, Exhibit 84. It's the
So we're on
second
cross.
video number 22.
It's the second 22.
One down.
No, it might be the top. Let me look.
Sergeant Thomas, we'll just pick up where Miss Nestor.
Lewis. I let you get away with it once.
I apologize.
I think she said I'd
Miss
like him
Lewis
to. I'd
has
like him to
left
get it
off.
at least once, and he's like, shit.
I let you get away with it once.
Sorry, Miss Nestor.
Lewis. I let you get away with it once.
I apologize. Where Miss Lewis has left off. Take a look at that video. What is this depicting?
It's like, I'll get it eventually.
Me grabbing the book out of the bin
And why are you grabbing the book out of the bin?
so I could take a picture of where I found the letter.
And by book, you mean the LSAT book.
Yes.
And why did you want to take a picture of where you found the letter?
To book it into evidence or attach it to the report of where I found the letter.
Okay.
Because I stated it in my report.
And this is after the mattress and the rest of the stuff has come down from the stairs too, because when the box was there, that wasn't brought down either. So, okay. He was just like,
Is that the LSAT book in your left hand where you found the letter?
Yeah, it looks like it.
Is this you using your cell phone to take a photograph of that?
Correct.
Great.
And is that the photograph that, if you know the number, but is...
There's a picture of it attached to the report. I love that influencers in the wild. He's like, wait, no, the lighting's not right. We got to lay this table out better. Maybe if I won't be shadowed if we just move it around the table. He's like, we're going to get it. We're going to get it. We got a clean background. We're going to get a picture of the book. We're ready. We're ready. Let me just circle around this way so there's no shadow. Yes, everybody sing.
It's found at 86 in the court's binder. We can show you that photograph.
LSAT book.
We have it real quick.
I know. I'm waiting for him to just be like, no, we had an LSAT book. Influencer style. We had the LSAT book. This is where we found the walk the dog letter.
Sergeant Thomas, is the court showing you Exhibit 86?
Just waiting.
Is that the photograph of the LSAT book where you
He's so
found
over it.
the walk the dog letter?
Correct.
Yes.
And is that the photograph you took that was depicted in the video we just watched?
Yes.
Correct.
You please hand that back to the court.
Ms. Nestor, Ms. Lewis, you have 86, right?
Yes, Your Honor.
Very good. Thank you, sir.
Great. Sure. And the fact that
Tariq,
it was
have
in
you
the
found
LSAT book,
the walk the dog letter in the LSAT book, correct?
Correct.
not in the folder.
And you
is
never searched a folder, a manila
relevant.
folder during that entire search we've just discussed?
The
Not
last
that I
one
recall.
did.
And you
I
never
don't
searched,
remember it at all.
and you never searched a folder with Mrs. Zara's name on it?
Negative.
And you conducted your search at the head of the bed?
Correct.
Head of the bed is about 6.5 feet from the foot of the bed where Sergeant Barrett was standing?
Roughly, yes.
No further questions. Thank you, Your Honor.
Ms. Lewis, may we release this witness?
Yeah, we may, yes.
Okay, you can step down. Thank you. You're free to go.
Awesome.
Yes.
I don't think they have any other witnesses. I think we're probably going to be getting towards the end.
Thank you, Brian.
Counsel, what's next?
Your Honor, sorry.
It's still your floor.
We would just want to admit into evidence, which is State's Exhibit 107 and 108.
They've been offered. You'll
It's
have an
already been
opportunity
offered.
to
It's
tell me why they're
stipulate to those, yes.
important.
Counsel!
Those are
Just let the
recording and a
judge
transcript
finish.
of said recording of a phone call between Ms. Richins and her mother, where she talks about that these 6 pages, the walk the dog document, were located in the envelope with the privileged papers. There's other parts of the conversation, but that's what we would be offering.
Proffer the date for me.
September 17th, I believe, 2023.
It's the 16th.
16th?
So a jail
Okay.
call between Kouri and her mom.
I think it's the 17th, but
I could be
either
wrong.
the 16th or the 17th, it should be on the transcript.
Counsel's going to offer her jail call saying it's not privileged because it's part of a book and it's just all fiction. So if you're going to offer her mom saying to her mom, I swear they were searching my legal papers. I don't think that's going to go very far.
And then we have nothing further.
Okay.
Okay.
Your Honor, the state, as to the same walk the dog letter motion to suppress, wants to call Detective Jeff O'Driscoll.
One more witness.
May I ask a more practical question for just a moment? I can stay a little bit late, but I'm not sure if a little bit gets us to the end. And I don't want to stay a little bit late if we're still coming back.
If we're still not going to be
another day.
done.
I need to be careful about using that resource. So if we need more time, we need more time.
I need to be careful about using that resource. Your Honor, is the resource that you need to pick your kids up from daycare, because I totally get it, or is the resource that you don't want to make your court staff stay late and the sheriffs have a hard stop for those in custody? I'm curious about which the resource is. Which resource, Your Honor? Which one are we using judiciously, or is it all of the above? It might be all of the above, but it's like, I will stay late if we will be done, but I will not stay late if we will not be done, because if we have to come back another fucking day, then we will come back another fucking day. That is fine. He would never say that. One of my favorite judges who was Cuban would say things that way. He'd be like, if we need to be here another fucking day, we just come back another fucking day. It was so great. But this judge, that is definitely not his vibe. I will stay late. I will have my court staff and my bailiffs stay late if you promise we will be done.
That's fine. But should the next discussion we have be about blocking some more time for these
Are we going to be
issues?
done? Are we not going to be done? Counsel, are we going to be done? Are we going to be done? No, yes, no, yes. They're trying to figure out if they will be done. I appreciate it.
I got to be fair to Brittany and whatnot.
Yes.
Thank you.
Court staff. I appreciate that and court reporter.
I was going to get us there.
I appreciate the judge trying to be mindful of his court staff in addition to the attorneys. And if you need to block in other time, just come back another day and call the next witness and just do it then. I get it. So. I appreciate the attorneys. Though they are advocates in court, the attorneys have seemed to work pretty well together. So, all right, I'm going to try to zoom a little bit and see
Your
if they...
Honor, I think we can get through this. How late are you able to stay?
I can stay till 6, but let's be practical here. Can we really
Can
get
we be
through
so
everything
for
else that
real
we
right
need to
now?
get in between now and 6 p.m.?
The judge, can we be so
Mr.
for real
Ramos
right
is
now?
saying no. I hate doing these things under time pressure.
The judge, for real
Your
though.
Honor, I think some of that may depend on emotions regarding the data that Mr. Ramos has filed. The state intends to call Mr. Kochodimos
So you
testify to the effect of...
have 2 more witnesses.
Based on tons of training knowledge and experience with these types of warrants.
So you have 2 more witnesses.
This warrant is very typical of phone extraction warrants. In fact, it's more narrow than many phone extraction warrants that contain language simply like dump the phone as long as it has to do with the crime. And he can explain why warrants require that breadth. Now, I can see where that information would be unnecessary given the fact that this court has approved so many similar warrants and just probably knows that.
Well, the other issue that
But if you want to put the evidence in, you need to.
scope of the inquiry issue that I have here is that the warrant was issued. It says what it says. Is there a legal route for collateral attack on its scope at this point?
So,
I mean, once it's issued, isn't the only
It says what it says.
routes of attack either that it was secured through fraud, that's a Frank's hearing, or that its execution
There's no Frank's hearing
was
happening at the moment.
unreasonable. But as long as the information seized or secured is within the scope described by the warrant, is there a legal basis for the warrant was overbroad when issued kind of attack?
Your Honor, the state doesn't believe so. And to be clear, that the defense in
I
their
know.
motion has not challenged
Attacked it that way.
the veracity of the probable cause under Franks.
I don't think we're going to another.
The defense has not
Maybe we are
challenged
going to another
the
witness, but
execution of the warrant. They are indeed challenging the 4 corners of the warrant as issued.
Help me
Under
understand, Mr. Ramos, what's your hook?
It's a lack of particularity.
Mr. Ramos, help me out. I love that the judge is like, "What's your hook? Like, where's the beef, Mr. Ramos? Where are we at? Lack of particularity. I don't think we're there."
Described and what to search for within it.
And let's assume you're absolutely right about that, and that the judge that issued it missed it, wasn't sufficiently attentive. At this point, though, where we have, I believe, good faith reliance on an overbroad warrant, isn't it black letter law that's not
when
a
the court-
violation of the Fourth Amendment.
When the court asks you that way,
Well, no,
tread
I don't believe so.
carefully.
If it was issued and it lacked particularity,
Isn't it black letter law that? Counsel, warning, warning.
Your Honor has the discretion to go back and either suppress it entirely.
Do
or,
I have that authority?
I believe you do, Judge, based on case law.
Okay. And you'll be able to cite me to that?
The way I've read it, yes, Judge.
Okay.
Now,
All right.
that's assuming Your Honor believes it does in fact lack particularity.
Okay.
If it doesn't,
Well, I need to give you a fair opportunity to lay that foundation, though, and make your arguments.
now to be fair,
But
coming
that's within the
into this motion, or to
That's
this-
within the four corners of the warrant, though. The court can read the warrant because it's within the four corners of the warrant. It's the page says what the page says.
hearing, we were going to just submit on the four corners and just brief it. So I had no plans on
Right.
calling anybody. However, I understand the state's position of wanting to call Mr. Kouri.
Candidly, I really don't care what Mr. Kouri thinks is typical. I mean, I'll wager with him about how many of these I've seen versus how many he's seen, and so I think I can make that call.
And the state's comfortable with that, Your Honor, because
The court can decide it on the face of the warrant. The thing
candidly,
speaks for
this court
itself.
has signed warrants with identical language.
Yeah, probably so.
It is our stock language that we use in every phone dump warrant.
Right.
But I need to give Mr. Ramos an opportunity to make his arguments, and so.
And so here we
Well,
are.
that, Your Honor, I believe that opportunity will come in paper.
Yeah.
I'm happy to limit this based on the court's experience with such warrants to the four corners, not call Mr. Kouri and move on.
Is there any evidence you feel like the defense needs to put on
I
to
like this
provide
judge.
the record from which
This judge is like, I'm going to give you a fair opportunity to need what you need and to do what you need to do, but someone else telling me what they think of the warrant doesn't matter because it's my job to sit up here in the black robe and decide if this warrant is overbroad under the law or not. That's my job. So if you give me the warrant, I will read it and your arguments in the law you cite, but I don't need somebody else to come in as an expert witness to tell me about the warrant that I have to evaluate because their testimony is not helpful to me because it's my job to evaluate it based on the four corners of the document. The judge is like, can we just save everybody a little bit of time?
you can make your arguments regarding
In
this
paper.
warrant is infirm because of a lack of particularity.
Judge, I believe that I'm limited to the four corners.
Okay.
Ding,
I
ding.
don't believe I can present any evidence, even if I wanted to.
You're correct,
Understood.
Mr.
Should
Ramos.
he want to do it, and I'd certainly love a chance to cross-examine.
No, I don't.
But-
He's like, I'd love a crack at it, Your Honor.
Coach Redemus's testimony on that issue is going to be particularly persuasive.
We would agree, Judge, and one thing we did discuss, which we would just, it's already been offered. I've discussed this with Mr. Bloodworth. In the initial motion that I filed, I identified some warrants. Come to find out later, there was another one that it just wasn't identified as through the IMEI number.
Okay.
So we've gone back and forth. All of the warrants have been offered. We're stipulating to them, and I'll cite them in the brief, but just wanted to let Your Honor know.
Okay. All right.
Okay.
Mr. Ramos, anything else we need to discuss today regarding the motion to suppress electronic data? Okay.
Okay.
Mr. Bloodworth?
Nothing further on that motion, Your Honor. I think we can call Detective O'Driscoll in relation to the walk the dog motion. I think we can complete that before 6 o'clock.
All right. Ms. Lewis, do you want to give that a try?
Yeah, I think we can get this done.
All right. Let's give it a try.
Okay. One more witness. Detective O'Driscoll
Okay.
was being recalled regarding the
Detective,
walk
we
the
released
dog
you, so I gotta
letter.
swear you in again.
And they are trying to get through all of their motions
Do
to
you solemnly
suppress
swear the testimony you're about to
and
give
get all
in
the
matter
evidence
before
in
the court to be
today.
The truth, the whole truth,
And
nothing
then they
but
will
the truth,
file more
subject to the
briefing.
penalties of perjury. Yes. Thank you. Have a seat.
All right, sworn back in, back up on the stand.
Your Honor, may I
Please.
handing Detective O'Driscoll a copy of
The walk the dog letter?
Walk the dog letter that is in the court's docket at 214.
Docket 214. What now?
Detective
Docket
O'Driscoll,
214?
I'm going to
Walk the dog?
ask you some questions to ideally provide the court with some clarity regarding some of the discussion inside the walk the dog letter, okay?
Okay.
I'm going to object at this point. I don't see how going through this is going to be helpful to the court, like Mr. Bloodworth's been telling us all day. What's in the letter, what's in the letter, the court can read it. The question here is
Pause
whether...
one moment. Help me out, Mr. Bloodworth. Where are we headed?
Sir, it's interpretation more than reading.
Why can't I interpret it, though, as well as this gentleman?
Your Honor, because some of
Because he's the lead investigator.
interpretation requires information that the court doesn't possess that Detective O'Driscoll has developed through investigation. Can I give you an example?
Let me ask you
Yes.
another circumstance
Please.
question. Is it information that Sergeant Thomas had when he handed it over to the Summit County Attorney's Office?
No, Your Honor. It is information to decode, if you will, some of the coded pieces of the letter and to explain why to explain the meaning of the letter. And let me proffer why that's necessary, right? The defense
But the court asked,
in their moving papers of
the court asked a very poignant question. Was this known by the custody officers when they took the letter? And that's what the court had asked. And Bloodworth is trying to say, no, this is why you need to understand more about the letter.
essentially argued that among an attorney-client, the letter is a attorney-client communication. They've also, I guess, alternatively argued it is attorney work product protected.
Right.
It can't be both. It can be one or the other. They've
Sure.
argued in the alternative. And
Yes, it cannot be both.
their work product protection argument is essentially that this walk the dog letter, the defendant prepared it in anticipation of litigation or trial.
Or that it reflects a conversation she had with her attorney about those preparations? That the substance is attorney court work product, yeah.
Correct. All grounding in, we're doing this because of litigation and
Right.
trial. The state will make an argument in the future when we prepare our opposition papers that, no, the walk the dog letter was not prepared by the defendant in anticipation of litigation or trial. Rather, it was prepared by the defendant in anticipation of witness tampering and publicity. To make that argument, the court needs a deeper understanding of the walk the dog letter, who the various references are
That
in
is
the
a
walk the dog
fine
letter,
edge
so that the
between
state can
arguing that it wasn't prepared for trial, but it was prepared for witness tampering, essentially, to tell them what to say for trial. That is a finely parsed argument when they are arguing work product, which will be interesting to see, and for publicity.
make that argument.
And when you say references, are you referring to names, places?
Yes, names, places. So,
Why don't we just ask those questions, Ms. Lewis? That's fine.
That's all the
The
questions,
court's
Your Honor.
going to-
I'm going to hold up so the court can see it.
Take
It's
it.
the highlighted pieces of the walk the dog letter that Ms. Lewis has.
The way to do this, to obviate the objection, is to the extent this letter says something to the effect of names a person named John Doe, just ask this witness, do you recognize that name? Does that person have any significance to this case?
Yes, Your Honor, that's the plan.
Okay. Ms. Lewis?
He's like,
For the record,
Yeah.
yes,
just renew the objection that the letter can be read on its face for purposes of the
it
motion.
speaks for itself, is what she's saying.
Fair enough. Can you speak specifically, though, that there may be
We'll
names
study the videos.
or other references in there that you all recognize that I don't recognize or wouldn't
Mm-hmm.
when performing an objective review of the letter, because I don't have the same level of information that you all
That
have.
can be an argument.
I think that who these may refer to, I don't know what he's going to say, but may not be what we believe, what he believes may be something different. But now we're back to infecting the jury pool again. They're going to argue that these are codes.
The letter is
coded
shit out of the
words.
horse.
Where he gets his information is certainly not from Ms. Richins, who wrote the letter. So we're going to put a whole bunch more stuff out there that Mr. Bloodworth was very concerned
With
about.
respect, it's already out there. This was all on the record. Gosh. We had a hearing about this. Ms. Lazaro was standing there saying the same thing, and I said something to the effect of if they thought they had probable cause to charge her with witness tampering, they would have charged her with it, but we are where we are.
It's all on the
Everybody has
record.
their arguments. This has been out for a year and a half.
Every
Can
law
we
nerd on
just
the
get
internet knows, Your
factual
Honor.
information
We've
out, and
heard
you'll
today.
all be able to make your arguments. But that concern was vetted a year and a half ago.
Yes, it
I
was.
understand. I just have an ongoing objection to this.
I understand. Just
Well-
ask factual questions.
Yes, Your Honor, and can we agree that the state has discretion in
Objection, my
whether or
client
not to
is for
charge
both.
Sure.
if there's probable cause?
We'll see. Okay, let's keep moving.
Detective O'Driscoll, can you please turn to page 3 of the letter?
Let's all look at page 3.
In the middle paragraph, that reads, also please text Lotto or call, tell him, do not text me.
Yes.
Do you know who Lotto is?
It's Mike Kelly.
And who at the time of the walk the dog letter was Mike Kelly in relation to the defendant?
Close friend or intimate interest.
Is that the paramour?
The letter then says, tell him not to text me. What do you understand that reference to text me to mean?
Text messages sent over the home wave system from the jail.
And did they have a history of texting over the home wave system from the jail?
Yes.
Can you please turn to page 4? Do you see right at the top a reference to potentially working out mortgages for houses identified as hers, yours, and Chelsea's?
Yes.
The hers, you can tell from the letter, relates to Marissa's. Who is the yours in that sentence?
Lisa Darden's.
And how is it you know that?
Because at the time, Lisa's house, just like Chelsea's and Marissa's or those properties, was facing foreclosure.
And who,
And the letter's clearly to Mom.
who was responsible for the mortgages on those 3 homes that were facing foreclosure?
I bet I can guess at this answer.
Kay Richins Realty or Miss Richins.
You see about 2 sentences down, there's a reference to Lotto and his house in Hideout.
Yes.
Did Michael Kelly at that time
Wait, is Hideout a place?
own a home in Hideout?
Yes.
Wait, Hideout's a
At
place?
the end of that paragraph, you see a reference to the...
That's amazing. The house in Hideout, not to Hideout, actually in Hideout.
hotels.
Yes.
Do you understand that reference?
Yes.
What is it?
2 properties at the Canyons Resort that were short-term rentals owned by Kay Richins Realty.
And like the other 3 properties, were those 2 hotel properties in foreclosure at that time?
Yes.
The next paragraph asks,
So 2 rentals at a resort, the Canyons.
one way to get at Katie is going through my phone and finding pictures of her girl.
Oh, I forgot
Yes.
about this part.
Based on your investigation, did
This pissed me off.
the defendant's mother, Lisa Darden, at that time have access to either a copy of the defendant's phone or a new phone that contained
That's right.
the defendant
I forgot about
information
that.
from the defendant's phone?
It appears so, yes.
I object. He doesn't have any direct knowledge of that. Speculation.
Yeah, we lay a little foundation. I'm not sure what he means by it appears so.
Sure. How do you know that
I'll
the
fill it in
defendant's
if they don't
mother,
ask
Lisa
about it.
Darden, at that time had access to information from the defendant's phone?
During several other instances of calls or text messages between Miss Richins and her mother, she frequently asked her mother to retrieve data or information from, quote, her phone.
And
She
based on that,
kept saying it.
and based on that request, did and jail calls did Lisa Darden appear to retrieve
Give that
information
info.
from the defendant's phone?
In reply, yes.
On page 5, the letter references my girls and then Chelsea, Kelsey, and Selma. Based on your investigation, who are Chelsea, Kelsey, and Selma in relation to the defendant?
3 of her closest friends.
Her besties.
Finally, turn to page 6, please.
Yeah, detective knows everything about everybody now.
In the middle, it reads, lastly, don't forget to work on the gun receipts. We want to file charges and let the prosecutor not do anything about it.
Yes.
Based on your investigation, what is this business about gun receipts?
Miss Richins,
I'm going to object. I think he's identified the names of the people. I think now Your Honor can read the rest of this letter. There's nobody else to identify in here.
I think I can draw an inference on that one, Mr. Bloodworth. We can move on.
I suspect the court can draw an inference on crest white strips as well, so I will stop there.
Okay, very good.
Thank you.
Ms. Lewis, any follow-up for Detective O'Driscoll?
So, one moment.
Of course.
Yes, I can draw an inference about the crest white strips as well, and trying to get. Oh, my lawyer won't mind if you try to have her sneak contraband into the jail for me. It'll be fine. She loves me. Okay, we'll talk about the part of the letter that I mentioned earlier that they didn't get back into that much more at the end. But
Your
Bloodworth
Honor,
is.
we don't have anything further.
All right.
Are we done?
Detective, you can step down. Thank you.
do you need this copy?
What is it?
The letter.
No, I have it, sir. Thank you. You can leave it there. All right. Mr. Bloodworth, anything further from the state today?
No? Yes, no? Yes, no, maybe so, Mr. Bloodworth?
Your Honor, can I briefly recall the Detective O'Driscoll?
Boo!
We need to be iterating towards an end here. Okay. No, he's still.
I enjoy this judge so much. We need to be
You understand you're
iterating.
under oath, correct?
We need to be iterating towards an end here. Your Honor, that is such a fantastic turn of phrase.
Detective O'Driscoll, you've testified to this before.
Why are we
As a
doing
part
it
of your
again?
investigation, did you contact representatives of the hunting camp in Mexico where Eric Richins hunted?
Other investigators on the case did, yes.
I object. I don't know where this is going. It doesn't seem to have anything to do with what's in front of the court right now.
The letter talks about the hunting camp in Mexico.
I have similar questions. Tell me where we're going.
Your Honor, the court has heard this testimony, and that the testimony.
Stop there, though. Why do we need to get into this today?
Your Honor, because the defense has argued, not only in its moving papers, but in some of its questioning today, that this business about the hunting camp was a discussion between Ms. Lazaro and the defendant.
How would this gentleman know whether that is the case or not?
He would know that that discussion is inconsistent. The purported discussion between Ms. Lazaro and the defendant is inconsistent with the facts of the case that Ms. Lazaro had at the time.
How would he know
I'm also
that?
mindful of burdens here, Your Honor. The defense, of course, has the burden, right, to...
Showing that this is either privileged or protected from disclosure as work product.
Correct. And they have presented no testimony on that issue. Nevertheless, the state could present testimony right now regarding the investigation into the hunting camp.
Yeah, let's stop
Yeah,
there,
if the
though.
judge keeps humming while he's thinking, the entire chat's going to
Hunting
lose their
camp
mind.
issue potentially opens several different cans of worms. I'm going to limit you on this topic today.
Several
We'll
cans
see
of
if we ever
worms.
need to get into this prior to trial.
Yes, Your Honor, understood. Can I propose this? To the extent the state, because we haven't seen substantive papers from the defense, right? To the defense opens this can of worms.
Understood.
Can the state rely on Detective O'Driscoll's previous testimony on the issue in its responsive papers?
Sitting here today, I can't remember if these lawyers were present when he testified to that.
It was the previous set of lawyers.
Okay, I'll consider that.
Okay.
Still not sure this is ever going to come up on this motion, but we'll see.
I mean, if it
So I
does,
appreciate that.
then
I'm
there
not
might be an
sure
affidavit.
either.
Right,
That's
because the
even more
defense
reason to
has
move
not
on.
put them all the way on notice, and that's
Anything
what they're
else to this
saying.
No, sir, thank you.
Okay.
Ms. Lewis, may we let this gentleman step down?
Yes, Your Honor.
Again, are we finally done? Have we iterated to the end? I appreciate the judge. And the prosecution's
Okay.
trying to be careful because the
Mr.
prosecution is saying, I'm not sure. The defense didn't line out all of their arguments. And if they want to make an argument and we could have answered it in a question and we didn't ask the question because we didn't have adequate notice, then we're kind of on the back foot. And the judge is like, I'm going to accommodate that as best as I can. And I'll be mindful of that. And I don't get the sense that this judge is going to just try to bing them on a technicality if they are moving forward and it comes up. I think that the judge will say, we will figure that out.
Bloodworth,
as he said.
Anything else from the state today?
No, Your Honor.
Ms. Nestor?
No, Your Honor.
Ms. Lewis?
No, Your Honor.
Mr. Ramos?
No, Judge, thank you.
We need
The
to
law
talk about
nerds.
deadlines.
No, we're good. Thank you, Your Honor.
I'm
We're all good
happy
too.
to let all of you talk amongst yourselves, agree to some briefing deadlines, and tell me what they are when we convene on February 3. Is that agreeable?
Yes, Your Honor.
Yes, Your Honor.
Mr. Bloodworth?
That's agreeable, Your Honor. I
Thank
would
you,
just
Your Honor.
ask, because I've seen the court do it both ways, is the court's general preference for kind of a more substantive briefing from the defense followed by opposition by the state and reply?
I mean, you all can stipulate around whatever you want to do. To the extent people want to have the last word on the issues for which they have the burden,
I can see
I don't
Bloodworth
know if
wanting
I'm
the
gonna
last
say
word.
No to that. That can create some lengthy back and forth. So just talk to each other, see if you can agree to what's going to happen here. I would prefer to receive all the briefing, be able to read all the briefing, and then have a hearing where I can ask you questions about it and have you make your arguments after I've seen it. That works best for me.
We would love to have a hearing too, because I want to hear them argue it as
Talk
well.
to each other, though, about the timeline for that, and let me know what you decide on February 3. We are reconvening on February 3
Okay.
by WebEx, I believe, at 9:30 a.m. to discuss juror questionnaire related topics. Is that correct?
Yes, sir.
Okay. Ms. Lewis, is that your understanding?
It is my understanding that Ms. Olson and I were just discussing, given the information we got today about the February 11th date, it might make sense to move the February 3rd date until after February 11th.
Folks, whether you pull jurors from this county and adjacent county,
You
a
still
county in the southern end of the
have to
state,
ask them
isn't your jury
questions.
questionnaire going to look exactly the same?
He's not wrong.
You're probably.
And whether it's in person or by virtual means,
Still
isn't
have
your
to
jury
ask
questionnaire going to look exactly the same?
Yeah.
Okay. February
Yeah.
3, 9:30 a.m. by WebEx. All right. Anything else today, Mr. Bloodworth?
Are we
Your Honor.
done?
Thank you.
Enough work for
Yes,
this
Ms.
day?
Lewis, Mr. Ramos?
Nothing.
All right. Ms. Richins, I'll see you on February 3. I wish you the best of luck. Court's in recess. Everyone, please travel safe. Thank you.
All right, everyone. And with that, we have come to the end of the evidence hearings. So let's try to give a summary. Then we are at 6 hours in today. Emily, are we ever going to have shorter streams? No. And then at 6 hours in today, I'm going to answer a few questions and then I am going to have to bounce. Remember, tomorrow, no stream. It is Thursday, except for members. I do not know exactly what time yet, but members, I will let you know in the Laundered Lounge and here on the membership tab. I'll put a community post and let you know. We will do some members streaming tomorrow, time TBD. And Then on Friday, we will be in court in Massachusetts. If you do not have the Maynard app, maynardapp.com. It's a great way to stay in the loop with everything that we are doing. So for us to iterate towards an end, let's give a summary. At the end of the day of hearings, the attorneys were talking about their briefing schedule, meaning their papers will be filed, making their arguments based on the witnesses that we heard. The witnesses today covered a variety of motions to suppress from the defense. The defense is broadly arguing to suppress the digital data, the statements made by Kouri Richins, and of course, that walk the dog letter, which, as Mr. Bloodworth has said, every law nerd on the internet just calls it the walk the dog letter. So do I think this channel's now been referenced twice in this case? Yes. Directly in court, yes. But it's because the law nerds are respectful and lovely, and we stand. So the case for Kouri Richins is set to start testimony and opening statements in the beginning of May. Jury selection in April. Yes, it is up on appeal with regard to how that jury selection will happen, but we will see briefing on this, and then there will be another hearing with oral arguments. Today was just the evidence portion, so there's more to come with the motions to suppress, and we will see what the court decides. There's already been numerous arguments over, the walk the dog letter, and we have seen that play out over the past year. Was it a year and a half ago? Then we will see the arguments with regard to the digital data and whether or not the cell phone 1 or cell phone 2 was properly seized. It doesn't seem like there's a ton of arguments there. Kouri Richins' statements when she invited law enforcement into her home to sit down and have a 3-hour chitty chat also doesn't seem like statements that are likely to get suppressed. So we will see all of the more granular arguments on that down the road. Yes, this is a typical part of the process as cases get ready to trial. Sometimes I cover cases as they go to trial. Sometimes we cover cases from the time that there is an arraignment. And when we cover it from arraignment all the way through, you see these iterations of the motions to dismiss, the motions in limine, the deciding a lot in advance what evidence is coming in, what evidence might not come in, and the arguments of the attorney. And you get some of an understanding of the case, some of the understanding of the attorneys and how the courtroom operates. The thing I appreciate about how Judge M's courtroom in Utah operates is that he is respectful always of the attorneys and patient, but also keeps them moving in the right direction. The turn of phrase is absolutely wonderful. The thing I do not appreciate, and I like this case, I like these lawyers, I like this judge, and then all of the rules about no streaming, just all of the rules about no streaming, Your Honor. We hate having to wait to the end, and then it has to get uploaded, and it takes days. Just what, Your Honor, who hurt you? We would just love to, even if they're on a delay, to have them streamed. It just makes the access so lovely, just so lovely. So we'll see what happens with this judge. So tomorrow, members only. Friday, we will be in Massachusetts. Today, we were in Utah. The court rules are just, but that was, other than the sealed portions, the entirety of the hearing for Kouri Richins from Utah. That hearing was on January 23rd, but it was uploaded to Court TV in its entirety today. So is it contemporaneous? Yes, for what we have access to, it was. It absolutely was. I'm going to answer just a few questions, and then I have got to go. And y'all, I'm sure, are also ready to go. And the mods are also like, are we ever going back to streaming for like 2.5 hours? Is that ever going to be a thing? Maybe. I mean, maybe. I also loved seeing Mr. Ramos in court with his remarkable, matching my remarkable. I've seen you ask lots of questions. No, not sponsored. I bought these. I very much like the remarkable too. The Pro has a more colored screen. This is just a Black and white e-writer, though if you highlight in color, you can see it when you upload it on the computer. The Remarkable 2 is a bit lighter weight than the Remarkable Pro, which I really like. I just dropped my pen, which I really like. It's just a little bit smaller, a little bit lighter weight, and I like that format. The battery life on both of them is great. It's just really going to depend on what you like. There's also a little bit of backlight for the Remarkable Pro that's not on the Remarkable 2, which I like. I have not had a chance to get my Dave season sorted. I've not even had a moment, not even a moment. Massachusetts is going to be Friday, not tomorrow. So Friday for Massachusetts. And I think we will probably be starting at 8:30 Central Time to give us a little Zoom room. And if the court is a little delayed, we will have time to also be on that delay. I think me saying I'll be here at 8 is just a lie. So it's just not gonna happen. It's just not gonna happen. B2, thank you for the gifted memberships and for everyone who gifted memberships today. For those of you who are new members, we will see you in our members only stream tomorrow. Emily has been an NIANCian. Yes. Love her shirts. Yes. Hope she can go see them. I need to look at dates. I know they're coming through Nashville, so it is on my list because it is on my list. Chronic Shocks Art Journal, thank you so much for the gifted memberships. Who else wants Judge M to do audiobooks, right? I could think of characters he could voice. I think Judge M is like, I'm very happy to be a judge. If there was ever a judge who everybody's like, I don't understand why you don't want to be on TV always, I think it might be Judge M. I really do. We need Docket 214 merch. I mean, maybe Docket 214. I knew I could count on the Lawnards of Docket 214. I mean, Docket 214 is apparently where we live now. And I am sorry to hear. I've seen a couple Lawnards mention family members that are needing of prayers and Lawnards that are needing of support in times of grief. So all of the prayers and well wishes for you and your family from the Lawnards. I know J. Michael, I saw earlier in the chat you had mentioned that you just lost a family member as well. I'm sorry for your loss. And the Lawnards are sending hugs to your family and everyone in the chat that is grieving. We often have Lawnards that are celebrating and grieving and sometimes simultaneously. This community is just such an incredible community of kindness. And you guys are just the best. Loch Nessie, we might need merch with Docket 214. I mean, maybe maybe we will. The things have happened. The judge has judged. Thank you, Mr. Bloodworth, for mentioning the Lawnards. My kids have not seen it, but I will share that with them. In honor of the Walk the Dog letter, I mean, the Walk the Dog is wild. If you guys are newer to this case, go check out the playlist. This case, every time we're in court, we're like, but wait, there's more, but wait, there's more, but wait, there's more. And this trial should be fairly straightforward. The attorneys have worked together fairly smoothly. I look forward to a trial with there's going to be moments of like, what is even happening? Because trial, but of, hey, we collected the things we were supposed to collect. Everybody's doing their job the way they should. It's just been a very normal court process. And that is nice to see when some of the other cases we are covering, there was so much fuckery. It's nice to see just what really is a normal court case, just everyone doing their job, moving through the process the way we would expect that to happen. And I really just appreciate it. And it's nice. It's really nice to see. So Lisa R said, let's get nerdy with the Fourth Amendment. For days, we've been getting nerdy for days with the Fourth Amendment. Deb Jackson Smith said, Emily, did you know the arresting officer in the ASAP Rocky case is Erica's brother on Real Housewives of Beverly Hills? Deb, it was Erica's son that was the arresting officer on Real Housewives of Beverly Hills. Not her son from Tom Girardi, but her son from a previous relationship. But yes, Officer Zizzo is Erica's son. He was the first witness in the ASAP case. I've been keeping an eye on it. The sound in that stream is difficult. I will probably give some summaries of it. I very much like the judge in that case from my work in LA. I very much like John Lewin, the attorney in that case. You might recognize him from either the Jinx or from, if you've watched the prosecution of Spectre, then you might have seen him there. But it's hard for me to be objective with people that I know. And so it's one of those things where I'm just like, I know them. That's where I worked. So it's a little bit different. So I'm keeping an eye on it. LA is case by case. This one is streaming. The judge is running shorter days because his docket is pretty busy. So it's running about 10:30 Pacific to about 4 o'clock Pacific. So it's a shorter day, and so they're not getting through a lot. It's not a factually wild case. The defense argument seems to be that it wasn't a real gun. So that's going to be a lot of that case. It doesn't seem to be factually so. Durst. I said Spectre, didn't I? The Durst case in Jinx. Yes, thank you, witness. With John Lewin. My brain has just stopped, and I've just conflated John Lewin with his friend Alan Jackson. So my brain has just merged all the LA attorneys into one. So yes. Either way, it's harder for me to cover cases where the sound is terrible and cases where I know people, because it's just me being like, oh, that's what that judge is like. And also the facts of the case will be pretty straightforward. So we'll do summaries of it and go from there. If there are moments in court we need to cover, then we will cover them. I'm sure others are as well. But there has been so much going on in the other cases we're covering. I literally just can't do it all. And we'll be traveling next week. So February 3rd, Kouri Richins will be back in court via WebEx. That will not be streamed in any way. It's going to be a conversation with the attorneys, and then we will start seeing the next dates on the briefing on this, and we'll be covering it because we're covering the Kouri Richins case until it is done with trial, and then afterwards, I'm sure. So, Law Nerds, let's do a few more questions, and then I have got to zoom. Streaming is in fact dynamic, and we covered that when we switched which videos we were using today, because last night when I prepped the stream, it was not there. We are all waiting for the judge to say, get in the car, Elizabeth. We are all waiting. I don't think it's ever going to happen, but we are all waiting. Music to My Soul said, Bloodworth's like, Your Honor, I respectfully submit that all YouTubers covering this trial aren't so bad. Let it stream, Your Honor. Let it just, is it frozen? Just let it go, Your Honor. Let it go. Just don't hold it back anymore. Just let it stream, Your Honor. Let it stream. Let it stream. Kristen, 4 years and counting. Repping the 214. I mean, that's where we're at today. We are definitely in the 214. Docket 214. The Law Nerds know everything. And that is absolutely fantastic. So let me get to a few more. This plant is a Christmas cactus. Oh, the plant in court. Yes. Catfink UK said, just realized 30 whole months. I know you guys, this is the best member community. It's just absolutely fantastic. Motion for a now soundbite. We might have to soundbite Bloodworth and put him with the Law Nerds know. We might just need a Law Nerds. The Law Nerds, every Law Nerd on the internet knows. We might just need that, because look, there are moments in court that are too much, and every Law Nerd on the internet knows is giving Elle Woods, like any Cosmo girl would have known. I just can't. I just can't. It's too much. But Law Nerds, this is a great community that we have created, and way back in the day, a self-named community, because as I started streaming, we were all talking about it. And it's like, no, we're nerds. We like doing stuff. And chat said, yeah, we're Law Nerds. And I went, chat is bae, and chat is accurate, and chat is correct. And the Law Nerds went, we're Law Nerds. And we all went, we're Law Nerds. Obviously. And here we are, 5 years later, with Mr. Bloodworth in court being like, every Law Nerd on the internet knows. It's like, right. You just don't want them on your jury, Mr. Bloodworth, because they know more about this case than a juror should. But that's going to happen. Sometimes there are plenty, I'm sure, in Utah that have not been watching every twist and turn of this case and don't even know that it's happening. So they will find a jury. It will all be fine. Docket 214 is our passcode to the secret Maynard speakeasy in Hideout, Utah. So perfect. It's so perfect. We'll name a drink clandestine chemistry, which is in fact the charge for letting him cook in Utah. So we'll have a drink named clandestine chemistry. It'll be fantastic. I think we can probably come up with quite a lot more in very short succession about what our Maynard speakeasy would have. I think we could. Snacks, obviously. Potato skins are a must, but also same with like the goat cheese balls from Sir. It's going to be fantastic. Of course, there would be a mega pint of wine on the menu and mega pints of other hydrations. Of course, there would be mega pints. There would need to be all dressed chips. There would definitely need to be some story times, dramatic readings of iconic court moments, dramatic readings of court transcripts. It's going to be fantastic. Oh, Maynards, you guys are the best. Still waiting for clandestine chemistry merch. It's on the list. We have new merch coming up for you soon, which is going to be a lot of fun, and I cannot wait. The way that my ADHD is killing me with planning merch drops ahead because I have no chill. Like, creating something that I want you to see and not being able to do it the next day is so hard. And Team Baker has been waiting and ready for our next merch launch, and we are so excited. So don't worry, Maynards. We have some very fun merch coming up for you, but all of the suggestions are still on our massive docket of things we want to create for you, and making sure that you get A, stuff that is amazing and you will love, and B, stuff that is going to last. It is so good. So with all of that, it has been a lovely day in court with you. Moderators, thank you for a long one. I will see you all back in court in Massachusetts on Friday for hopefully not as long of a day. And I will do a summary of the motions that I have not finished going over for Friday with y'all, because I have not gone through the entirety of the experts' declaration, but I will give you a summary of that on Friday before we start court. We'll go to court and we will see what happens in Massachusetts on Friday. Members, I will see you tomorrow. Maynards, I will see you around the internet. Thank you for being here. Thank you for being a Maynard. You guys are absolutely the best. Take care. Have a good night. I'll see you soon. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Maynard app at maynardapp.com. It's a free download on iOS and Android, so I can keep you in the loop, because you never know when something's going to pop off. Thanks for being here, and thanks for being a Maynard.